Yes. From that side, yes.
Lordship, may I mention permitted
No,
to
not now,
mention-
not now. First the physical mentioning. Yes. Yes. Leave is granted. Yes.
For correction.
For restoration, my lord.
For correction.
Yes. Stay application. Yes.
May I mention item number 57, my lord. Well, kindly have a look at the order first, my lord. With notice to the other side.
Yes. What is the mentioning about?
57, my lord.
What are you mentioning it for?
Item 57, because my lord, we notice to the other side mentioned in my lord.
What do you want?
Well, my lord, let this matter appear to be mentioned. What happened, my lord? The division presided by Justice Mothures was pleased to direct, I am the unfortunate husband, and my wife is not appearing, who you had directed to come to an amicable settlement. So, my lord, I have served notice earlier. Again, I have served notice, my lord. Let this appear to be mentioned. Well, I want to utilize the puja vacation, my lord, for amicable settlement.
Yeah.
Let this
You want what for puja vacation?
But during the puja vacation, we can explore our vacation for me. Kindly have a look at the order, my lord. Kindly have a look at the order.
Chotkur.
Well, let this appearance to be mentioned. This is my humble prayer, my lord. I have served notice, my lord. This is the notice.
Yes, to be mentioned. Tomorrow it will appear as to be mentioned.
On Wednesday.
No, tomorrow. Why to?
My lord, so that I can come up with affidavit service. I have already
Very
served.
well. Wednesday to be mentioned. Wednesday to be mentioned. Yes.
My lord, may I permitted to my lord file the appeal, my lord, without certified
Yes,
copy applied.
yes,
And my lord, to move this week, my lord. The difficulty is that my lord, not only the writ petition was dismissed, my lord, but cost of 5 lakhs to
File it will be taken up on Wednesday.
extremely
Wednesday,
grateful.
yes.
Extremely grateful.
For notice, my lord, application for appropriate order, my lord.
What is the appropriate order?
My lord, HPCL.
Anyway, it's application handed. Yes, Mr. Vasu.
Number 7. The Archery application.
Yes.
That on the last day, your lordship was not satisfied with my client's content. Your lordship can takes it at 2 p.m. because the dismissed employee matter is.
Mr. Basu, keep somebody when the matter is called on. Mention inform the other side. When the matter is called on, we'll pass that. Yes. From tomorrow, we'll be taking, probably we'll be sitting singly from 3. So tomorrow mention, we'll take it up day after tomorrow. Yes. Application, yes. Yes, Mr.
There is a review application I had mentioned last week, your lordship had passed an order keeping it on the next day. Whereas the condonation application was served on me, it has been filed almost 3 or 4 months after the filing of the review application. I prepared my opposition last week itself, I've served on the other side.
It is due to appear when?
Well, it was due to appear in the monthly list on November. Your lordship initially was going
File that application, hand over the number of that. The section 5 is also due to appear then.
Yes, sir. I'm only opposing the section 5, not the review.
So when the matter comes up, then oppose.
Because the only difficulty I tell your lordship is that they've also made another false statement. So I was just pressing for a dismissal of the section 5.
When it is called on, Mr. Not before that.
November, I'm just pressing.
No, early. No.
Inclusion of fresh application.
Pardon? Application, yes.
Your lordship, in this matter, your lordship was pleased.
Application or final hearing?
No, your lordship, a corrected judgment was supposed to be uploaded. It has not been uploaded yet, your lordship. This judgment was.
There is some technical issue. We have spoken with the registrar listing. So you just wait for that. Yes.
My lord, may I
Yes, your lordship.
notice, my lord?
What is this application?
No, my lord. Matter, one matter, 2 matter I have 5, 1 matter not disposed of by your lordship. I am praying for similar order, my lord. Lordship, kindly remember, one judge cannot prefer appeal, challenging his own.
Yes.
Your lordship.
Let it come as to be mentioned. Inform the other side.
Yes.
It will appear as to be mentioned.
My lord, may I mention a can application, my lord?
Yes. Any other mentioning?
My lord, may I
Quick.
May I have your lordship's kindly?
Some typographical error, my lord.
Yes.
But I have received a notice from the other side, my lord. He is on.
I will wait for that.
With notice upon the the landed advocate.
What is this application?
My lord, this is an hearing matter appearing before your lordship. Kindly fix up any date after vacation.
Come back after
Because,
the
my lord, without any award, my
It's
lord,
upon-
the third party interest
No.
has been created.
Come back after.
My lord, I will.
Same.
Lordship,
Oh, yes.
Lordship, my senior.
Very well. We'll take up the online mentionings first.
Lordship, this is a matter of circuit bench.
Yes.
This is contempt matter. It was supposed to appear on 19th at 11.
Are you addressing us on the first application, which is before us?
Contempt matter.
No, we have not yet taken up. Are you
No,
mentioning?
it was taken up and thereafter in this contempt matter.
Item 1? Is this item 1?
No, Lordship.
What do you want now?
This is your honor.
What do you want now? What do you want now?
With Lordship Prosenjit Bishwas. it was supposed to appear on 19th.
Yes, we did not have the bench. Those benches will be deferred to some other date. We'll notify in advance. এই যে আপনি একটা না আজকে কথা বলে নেবেন ওই যে ডেট বেঞ্চ গুলো হয়নি ওই দিন কবে হবে ওগুলো আজকে আবার কথা বলে নেবেন we'll keep another date for that. Yes.
Yes, Lordship, my learned junior friend will hand over the
What?
mentioning slip.
I'm
Will in any event,
constrained.
three benches were constituted that day. Due to my fault, I was not there for some official work, could not be taken up. All those matters will be assigned some other date with advance notice in the list. Yes.
Because I'm constrained to mention that upheld and local
Yes.
Lords, the award holders appearance has inadvertently been omitted from the order, Lords. That will create some issue. So
It will
that
appear
would
to be mentioned. To be mentioned. It is
very
this
good.
is the original side list. Brother. Yes. Original side. Original side look the
Our appearance has not been, it
Good.
will come
Call on the
and
list. Call on the list.
Grateful, Lordship.
Seen করে দিন। Call on the list.
Jalpaiguri matter, item number 1.
Yes, please.
Lordship, I appear. Lordship, your Lordship's order dated, judgment dated 30th of July 25.
পরে ফাইলটা রেডি করে রাখুন।
30 days time was given to the department to refund along with interest. We filed the application on 31st of July. They acknowledged it on 14th of August. Till now, they have not paid the tax, neither the interest.
A prima facie case of contempt has been made out inasmuch as allegedly the alleged contemnor has one contemnor.
One contender.
Alleged contemnor has not complied with the judgment dated July 30, 2025, passed in MAT 104 of 2024 to the effect that the amounts directed to be
Para 71, Lordship.
refunded were not so refunded. First of next para, accordingly, the petitioner shall serve a copy of CPAN 71 of 2025 on the alleged contemnor, indicating that the matter shall next be listed on November 4, 2025. November 4, 2025. An affidavit of service shall be filed on the next date. It is জলপাইগুড়ি matter 4th থাকবে. It will appear.
Item number 1.
Yes.
And for the appellant, Your
Yes,
Lordship.
Ms. Attu, what is the matter?
The appellant does not wish to proceed with the matter, Your Lordship. There was
Does not want to proceed.
amicable settlement.
The appellant, learned counsel for the appellant submits that the appellant does not want to proceed further with the matter in view of an out-of-court settlement arrived at between the parties. Full stop. A written instruction in that regard is filed in court and be kept on record. Full stop. Accordingly, FA 41 of 2025 is dismissed for non-prosecution. Full stop. Interim order, if any, stands vacated.
Grateful, Your
No
Lordship.
arrest to cost. Thank you.
Item number 2.
Beg to represent the petition. Item number 2, Mr. Aniruddha Chatterjee and Mr. Iftikhar Munshi are appearing for the respondents. I am praying for a short pass.
No. Yes, what is the matter? You're there.
No, my lord, I have not been briefed, my lord. I'm just.
It's your client's misfortune. No,
But
nothing.
I have been informed, my lord, by Mr. Munshi as well as Mr. Chatterjee. My lord, short pass, they're on their way, my lord. Short pass, my lord, 10 minutes. Or 15 minutes, my lord.
Keep the affidavit service with you. ফেরত দিন এটা affidavit service. We're passing it short pass over.
I'm so grateful. So grateful.
We'll call it after these motions.
I'm so grateful.
Mr. Gali, please just be present.
I'll inform them.
Item number 3.
I am appearing for the petition.
Yes, what is the matter?
Petitioner predecessor.
Can you please take the microphone a bit closer to you?
I beg to represent the state.
Obvious.
Side change, Lordship.
Yes. No, you still remain the state. Yes.
Petitioner predecessor, he was a big guy. Mother, he submitted his B form. But at the time of hearing, he was not called on. By mistake, certain lands of his wife and 2 sons were included and directed to be vested. Then, he filed a writ application before this Honorable High Court. And writ application was first disposed of. Kindly take up page 55.
relevant portion is, my lord, page 56, last paragraph.
Yes.
In my opinion, if the revenue officer finds that the land which have been allowed to be retained by the petitioner also includes the land belongs to the said respondent number 5, 6, and 7, one wife and 2 sons, as mentioned in paragraph 6 of the petition. In that case, the revenue officer will consider the same after giving the petitioner a proper opportunity of being heard. If, however, it is found that no such land is included within the land allowed by the to be retained by the petitioner, in that case, the impugned order of the revenue officer will stand. And let
According
the-
to you, these lands should have been excluded from the land held by you, the ceiling, for counting the ceiling.
Then, my lord, I prefer
Yes.
appeal against this order.
Why
Kindly-
preferred appeal? You wanted an outright.
So, my lord, as because, my lord, appeal was preferred, that, my lord, kindly take up for a moment, my lord, page 61. Second paragraph.
Yes.
The learned counsel for the petitioner referred in a similar case where division bench of this court permitted the petitioner to file a supplementary B form. But I want to file a supplementary B form. Supplementary B form, and on that basis, the revenue officer.
So that was granted to you. You
Yes.
can file supplement.
Yes, and there was direction.
And that will be considered.
But there was a specific direction that we should file within 4 weeks from the date.
Right.
Madam, kindly take up the next page.
Yes.
Madam,
And within 4 weeks.
4 weeks.
Very good.
Date is mentioned 17th
Right.
June 2002.
Accepted. Yes.
Then, my lord, they issued notice one after another notice. We have annexed all the notices.
Yes, you have.
Kindly take up the page 75 onwards.
Yes.
All the notices, all the time we appeared.
Then what happened?
They have not concluded.
It may be, your lordship.
Not
What do
concluded.
then what happened?
We approach before the tribunal. My lord, kindly take up.
For disposal of that matter.
Yes.
Yes.
My lord, then, my lord, page 96. My lord,
Status report.
Status report call for. My lord, the first point lordship will get. First point, third party interest was created by giving certain lands of our lands were declared on the basis of vesting. My lord, settlement was given. Then, my lord, they said kindly take up page 97. They said last 2 lines of the report, which are not traceable, presently traceable. Records are not traceable. We cannot, my lord, proceed with the case. Then, my lord, tribunal court directed them, kindly take up the order of the tribunal court. Repeated direction was given, page 103, lordship will page 104.
Reconstruction.
Yes,
then.
And I was asked to assist them. But accordingly, repeatedly, we appeared and assisted the officer, and I have submitted that we have already annexed the entire B form, supplementary B form in the OA application.
Yes.
Even then, my lord, the final order passed by the tribunal, kindly from page 17, last and annexure, P5.
Yes.
This is very relevant, my lord. Here, on the careful reading of said representation, it appears to us that the grievance of the applicants is that the revised B form and subsequent the expert order passed by the BR case number has not been considered by the BLO concern in spite of the specific direction given by the High Court. The counsel for the applicant further submit the applicants have submitted revised B form on the numbers of occasion before the BLO Mograhat and the South, but no effect. On the other hand, the government representative of the state has converted the above submission stating inter alia the BLO Mograhat 1 district has not seriously.
Oh, tribunal said 14T3 has been initiated, so that is the panacea, so that can cure your defect.
Earlier on the B form, 661 proceeding was, but that was dropped. even the direction was given by the High Court. Certain portion of that land was, my lord, they have already admitted that they distributed to third parties. But we will be,
No, these transfers were made post order of the High Court, previous order of the High Court. No.
no.
Before that.
Previous, after, yes.
Anyway, if you have been permitted to file
My lord, they were early,
reform, fresh reform,
then
and they have to adjudicate on that, then 14T3 is a subsequent proceeding. So that would not be a ground.
that
So you have challenged this before us.
this order is before.
Yes, Mr. Khalid.
My lord, 14T3 so far is concerned, my lord, it can,
Subsequent proceeding.
that is subsequent, but
Different.
lordship, so far as B form supplementary revised B
Yes.
form was allowed to be considered, it has to be considered.
Don't be so fair. You lose your post.
No, my lordship,
Yes.
chapter 2B proceeding LR Act is altogether different. Let it,
14T3 is on a different footing because the initial vesting that
Yes.
itself has been questioned by the division bench. By the previous
14T3 is
bench.
not the question here. So B form has supplementary B form.
So they have produced documents, so that exercise has to be concluded.
Yes.
Yes.
We'll direct that to be done within what will be a reasonable period because the pujas are by the end of November.
Yes, yes, yes.
Thank you.
Revised B form has to be considered.
Thank you very
Let
much.
it be, let it be.
Thank you so much.
Grateful. Lord.
And 14T3 is pending as on date because there was a division bench proceeding going on.
At the outset, we must appreciate the able assistance and fairness rendered by the learned senior government advocate. Full stop. Next para, the constrictus of the writ petition is limited. Full stop. Learned counsel for the petitioner argues that initially a challenge was preferred by the present writ petitioner against the vesting of certain lands of the writ petitioner on the ground that within such lands, purported to belong to the writ petitioner, lands of other relatives of the petitioners were also included. For the next para, the matter came up to this court, when a writ court had directed the revenue officer to consider afresh the representation of the writ petitioner as to
My
the
lord, one
land.
right, my lord. Writ petition in the year 1969 was by the intermediary himself, Muhammad Naib Ali Lashkar. And the writ petitioner herein is the successor of
Or predecessor.
yes, petitioner's predecessor.
তার আগে সেন্টেন্সে কি বললাম? না 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 was challenge was preferred by the writ petitioner না করে by the original ওখানে by the original intermediary. আর পরেও যেখানে যা said writ petitioner না বলে ওখানে said writ petitioner the said intermediary. তা ফিরে এসো আবার এখানটা কি বললাম?
And consequent thereupon, my lord, the representation was preferred by the present petitioners.
Consider afresh the matter in the light of the representation preferred by the present writ petitioner
Lordship.
with regard to the lands which have been allowed to be retained by the petitioner, particularly on the issue as to whether those lands include lands belonging to other persons, being respondent numbers 5, 6 and 7 as mentioned therein, in which case the revenue officer was to consider the same after giving the petitioner a proper opportunity of being heard. Thereafter, it was held, if it was found that no such land had been included within the lands allowed to be retained by the petitioner, the impugned order of the revenue officer would stand. With a limited grievance against the same, the writ petitioner preferred an appeal, which was disposed of by a coordinate bench of this court by an order dated May 21, 2002, whereby it was clarified that the writ petitioner shall be permitted to file a supplementary B form return, which would then be considered by the revenue officer. Next para, thereafter, several dates of hearing were given and the matter was heard at length. However, subsequently, the matter being not concluded, a challenge was preferred before the learned tribunal by the writ petitioner. Full stop. Next para. In a status report authored by the Block Land and Land Reforms Officer, Mograhat Roman 1, South 24 Parganas, it was indicated that third party interests had been created in the land and that the records of the case were not traceable. Full stop. Thereafter, there were repeated directions by the tribunal, as evident from the annexes to the present writ petition, for a reconstruction of the records. Full stop. The writ petitioner was directed to cooperate with the authorities in that regard. Full stop. It is submitted that the writ petitioner furnished all documents available with the writ petitioner, sufficient to reconstruct the records. Full stop. However, ultimately the learned tribunal, by the order impugned dated February 25, 2025, came to the conclusion that since a proceeding has been initiated in the meantime under section 14 capital T within bracket 3 of the West Bengal Land Reforms Act 1955, the conclusion of the said proceeding would provide the only panacea to double inverted, panacea, PANACEA, double inverted only panacea, for giving relief to the applicants and directed the said proceeding to be disposed of. To sub next para, learned counsel for the petitioner contends that the proceeding under section 14 capital T within bracket 3 of the 1955 Act is on an entirely different footing than the original vesting order, which was directed to be reconsidered upon furnishing a supplementary B form by the petitioner. For sub next para, learned senior government advocate concedes to the extent that the proceeding under section 14T within bracket 3 is a different proceeding. Full stop next para. However, on merits, learned senior government advocate controverts the submissions of the writ petitioner. Full stop next para. Upon a careful consideration of the order impugned and the attending circumstances of the case, we are of the considered opinion that a proceeding under section 14T within bracket 3 of the 1955 Act, is in the nature of a subsequent revision of the original vesting and a fresh proceeding, as opposed to the reconsideration contemplated by the previous orders of this court. For sub next para, the order of the learned single judge passed in the initial writ petition, as modified by the division bench, was to the effect that the original vesting of the lands of the petitioner was to be reconsidered, after the writ petitioner having filed a supplementary B form, as to whether the land of the petitioner was also land of the petitioner which was vested also included the land of others. For sub next para, since such consideration was never concluded as per the direction of this court, the learned tribunal went traversed beyond his jurisdiction in coming to the conclusion, beyond its jurisdiction, in coming to the conclusion that the panacea within double inverted panacea of the writ petitioner lay in the conclusion of the proceeding under section 14T within bracket 3 of the 1955 Act. Full stop. Next para, in fact, no question would arise of the said provision, that is section 14T within bracket 3, being applied in the event the initial vesting was not conclusive. Full stop. By the previous orders of the writ court and the division bench of this court, the initial vesting itself was directed to be reopened upon the writ petitioner having filed a return in a supplementary B form. Full stop. Such supplementary return having already been filed, and the writ petitioner having already furnished the relevant documents with the concerned BL and LRO, the said BL and LRO within bracket revenue officer bracket close, was mandated to dispose of the said proceeding first, comma, before conclusion of the section 14T within bracket 3 proceeding. Full stop, next para, as such, comma, WPLRT 146 of 2025 is allowed on contest, comma, thereby setting aside the impugned order dated February 25, 2025, passed by the second bench of the West Bengal Land Reforms and Tenancy Tribunal in OA 3230 of 2015, bracket A LRTT, bracket closed, and directing the concerned BL and LRO, comma, Mograhat hyphen Roman 1, comma, District South 24 Parganas to immediately dispose of the supplementary return filed by way of B form by the writ petitioner, comma,
Page 62, my lord. 17th June.
pursuant to the direction of the division bench of this court dated May 21, 2002, passed in FMA. What is that? 124 of 1975.
Your lordship.
124 of 1975. Push up. It is expected that such exercise shall be concluded by as expeditiously as possible, comma, positively by November 30, 2025, upon giving adequate opportunity of hearing to the petitioner and all interested parties. Push up, next para. It is made clear that the writ petitioner shall further cooperate with the concerned BL and LRO by furnishing fresh copies of the available documents, comma, if any, afresh. Full stop, next para. All parties concerned shall act on the server copy of this order without insisting upon production of a certified copy for the purpose of implementation. No address to cost. Thank you, sir.
The affidavit service may be kept.
Affidavit of service may be kept. Both are
Either need.
be kept on. Thank you, sir. Next.
Item number 4.
May it please your lordship.
5-8 এটা ready রাখবেন অনিন্দিতা 5-8 ফাইলটা ready রাখবেন yes what is the matter Mr.
Lord, challenging the propriety of the order dated 7th of August 2025 passed by the learned administrative tribunal, my lord, this writ petition has been filed. In a nutshell, just I am placing, there was a public interest litigation. Private respondent number 6 and 7 introduced themselves as a public spirited citizen. What they challenge? They have challenged that, my lord, BLLO Namkhana initiated a proceeding under section 4C5 of the Act of 1955. What the proceeding says, that if, my lord, there is a conversion without following the process, in that event, the penal provision by penal, my lord, the measures should be taken under Roman 7.5. My lord, that has been initiated for the month of April 2023. Since, my lord, they have not come to a logical conclusion, therefore, the public spirited citizen, the private respondent number 6 and 7, came before this honorable court, filed a public interest litigation.
For imposition of those penalties.
For imposition of those penalties. Then Honorable High Court, my lord, passed an order directing the authority to come to a logical conclusion, the proceeding which has already been initiated by the, my lord, BLLO Namkhana. But, my lord, which aspect has to be agitated before the, my lord, the honorable court at the relevant point of time has not been agitated. Therefore, a review application has been filed by the, my lord, the writ petitioner before your lordship, my lord. In the review application, it has been.
You are the private spirited persons.
No.
You are the private spirited persons.
Yes, private spirited person. Then what happened, my lord? The person concerned, my lord, the writ petitioner before your lordship filed a review application. In the review application, it has been stated that no, there is no prima facie abnormality or there is any ex facie illegality in the order. Therefore, I am not going to review the application.
The ground of your review, what did you want?
Here, my lord.
What was the ground of the review before the
The review was, my lord, to recall the order.
Why?
Because, my lord, the aspect which is required to be considered, all the aspects have not been considered and passing an order. Because that place has not been placed before this honorable court at the time
but
of the
proceedings were initiated, those had to be implemented. Come to logical conclusion. If proceedings were initiated, you had your defense there.
Yes, that has been stated, my lord, in the review application. Just you file a comprehensive, my lord, application before the concerned authority along with all the documents.
You were denied opportunity of hearing in the first review petition.
Yes.
Basically, that was. So that opportunity has been given to you to file application.
A comprehensive application has been filed pursuant to the direction of this honorable court in a review application.
Right.
I entered appearance before the authority. That is the ADM LR. I stated that this is not a case of conversion. This is a case of correction of record of rights. My property belongs to my forefather. The property has already been converted. There is a provision of the rule 166. By dint of the rule 166, if any property has already been converted, 24th of March 1986, in that event, I am entitled to get a post facto conversion. So, my lord, this application has been considered and certain documents I have filed, they have not considered the document of the relevant contemporaneous document of prior to 1986. And thereafter, my lord, they dismissed my application.
What did you show to the to indicate that there was previous conversion?
My lord, I paid tax, property tax.
On the converted mode.
The converted mode, and that has been issued by the contemporaneous panchayat, and that has been verified by the panchayat also.
How did the authority go about that and deal with
They
that?
did not consider.
You challenged that before the tribunal?
I have challenged that before the honorable tribunal. When I have tribunal, subsequent order has been passed by the authority saying that immediately demolish your building. Then, my lord, I approach, I file a MA application before the tribunal. Tribunal reject my application saying that I have to carry out the order passed by the Honorable High Court because this is the, my lord, the be all and end all everything, and therefore I cannot do anything. Then, my lord, challenging the propriety of that order of a MA application, I approach before this Honorable High Court in a WPLRT. In the WPLRT, my lord,
it was dismissed or
dismissed.
Oh, right.
Then I approached before the, my lord, this Honorable Court. This Honorable Court passed an order affirming the order passed by the LRT. And saying that since, my lord, this order has been passed pursuant to the order given by the Honorable High Court, and therefore you are not entitled to get any relief.
Right, then
I have challenged it before the Honorable Supreme Court. Honorable Supreme Court entertained my application and allowed my application, and directing the LRT to consider the application on merit so far as the way 61 of 2024 is concerned, and granted a status quo.
Till Way's disposal.
Till Way is disposed of.
Then Way has been disposed of now.
No. When, my lord, this application has been taken up, subsequently that public spirited citizen came before the, my lord, the Honorable LRT and saying that I intend
He's
to...
appearing for the public spirited citizen, you. Yes.
I intend to, my lord, as a party respondent of there, filed an application.
Where?
In the Way, before the tribunal.
In the Way?
In a way where I have challenged...
He wanted to be added?
Yes.
He was added?
Yes.
Then?
Then, my lord, no pleading, nothing else as to why he is a necessary or proper party. Only simplicity, a document has been placed. I am a pattadar, although he is a primary school teacher. He is saying that I am a pattadar of a particular property. So,
Pattadar of that property?
In a one dag number. One dag number is that property also. But my case is quite different footing. So subsequently thereafter, although there is no document, nothing else, no pleading as
has
to
been
why
added.
Added.
You are challenging that adding?
Yes.
Show us the impugned order first.
Kindly have a look at page. Volume 2, my lord. Page number has not been mentioned. It is after 230.
After 230.
After 230.
Yes.
My lord, 1 second, my lord. Kindly have a look at 115. 115, their application. Second volume, first page. 115, kindly see the nomenclature and application under section 16D of the West Bengal Land Reforms Tenancy Tribunal. It says about the review of an order. There is no such nomenclature. Then, my lord, kindly...
Just forget the caption for the time.
Yes. Then, my lord, kindly have a look at, my lord, impugned order at page 231, although the, my lord, that pagination has not been mentioned. The application is filed under section 16L. That has been filed in 16D. Court is passing an order of 16L. I don't know, my lord, 16L is not in the provision in the statute. 16L in the WPLRT Act of 1997.
Regularly pass such orders which are not in statute. Yes.
With a prayer of the add of the two additional respondent of the respondent number 4 and 5 in the way in the 619 of the 2024.
Thank you. Sorry, please continue.
It is mentioned that the applicant in the instant MA filed a public interest litigation before the Honorable High Court, Calcutta, being WPA number 83 of 2023 in respect of the subject land.
Reasoning appears to be from the second page, last paragraph. Second last paragraph.
Yes. My lord, the second paragraph onwards. My lord.
Same. Very well.
At the time of the hearing of the learned advocate on behalf of the applicant, added respondent. Kindly see, my lord, added respondent, although not yet been added.
Not yet proposed, yes.
Yes. The instant MA and they submitted that the name of the Indrolil Paramalik, the one of the public spirited citizen is mentioned ROR as a possessor in respect of the subject land, and they filed a public interest litigation on which the Honorable High Court Calcutta passed an order. And it is for the first time pointed out that there is a dispute about the subject land. So they are the necessary party. So if there is any
regarding this dark number, which is where conversion has been alleged, they are not in possession of that.
My lord,
They claim to be in possession of a dark.
they mention 3 dark numbers.
That
one
of the converted one.
No, portion, a portion of the land, my lord.
Then they have a direct interest.
My lord, in that event, the public interest litigation cannot be done.
Should have failed. That is playing
My
in our
lord,
mind.
cunningly that has been done. If that be the
We'll
so,
look into that public interest order also, or that application, to see whether what they pleaded there.
my lord.
Let us complete this, then we'll come further.
First time they pointed out and that there is a dispute about the subject land, and so they are the necessary party. On the contrary, the learned advocate on behalf of the applicant in the way submitted that the applicant added respondent has no right title interest over the subject land, and public interest litigation is a separate matter and it has no relation with the way. The applicant added such and such as no way connected with the way. They are neither the necessary party nor the proper party. It appears from the arwa that the name of the Indrolil Paramarik has mentioned as possessor, not the Borgadar. Possessor. Moreover, the public interest litigation has been filed in the applicant and added such and such in the MA, along with the other in evidence upon which the Honorable Court pleased to pass a direction. Under Order 1, Rule 10 of the CPC, whether that applies or not, my lord, I don't know, because statute does not say so. The court add the parties in the suit in their presence is necessary for the effective and the complete adjudication in the matter. It includes the lot of the necessary parties and the who should have been included initially as the proper party whose presence helps the court resolve to all the question involved. Proper parties and the means the individual, those the presence and the which is strictly essential, help the court to effectively and completely adjudicate the question involved in the suit. In the instant case, the applicant added respondent in the MA case, where the parties of the public interest litigation and they have knowledge about the matter and the which may help of the tribunal to adjudicate the dispute effectively. Accordingly, in our view, this application added respondent are undoubtedly proper parties. Hence, they should be added as the respondent number 4 and 5. Then, Miller, that has been allowed on contest or such and such.
Have you annexed the order of the public interest litigation?
Miller, kindly have a look at page
67.
Miller 66 first. This is the Miller 66 first. This is the Miller the document which has been issued by the concerned BLLR, which allegedly they have claimed that not been pursued, which prompted them to appear before this court to initiate a proceeding. Then Miller 67. 67 order dated 16th of October 2023. Kindly see Miller paragraph 3 at page 68.
Yes.
In the light of the above, we direct the concerned authority to complete the proceeding initiated under section 4C5 of the Act and take the matter to its logical conclusion after passing reason order in accordance with the law. Then, my lord, the district magistrate directed to monitor the action taken. Then, my lord, the observation has been mentioned. Should I place it, my lord, enter it?
Do you have a copy of that public interest litigation itself, that application? You have a copy? Copy. So this direction was passed. So
Yes.
very well.
Then, my lord, kindly have a look at page 77.
You are not a party to this.
No, I were a party.
At that point of time, you are
Time
not.
my lord, all the aspect has not been placed.
That's why the review.
Yes.
Thank you. That's why the review.
Page 77. In the review application, my lord, kindly see page 78. We find that there is no error apparent on the face of the order, exercise of the review jurisdiction. It would be open to the review applicant to raise all issues before the concerned authority in pursuance of the proceeding initiated under the West Bengal Land Reforms Act of 1955.
But you did not challenge the locus standi of the public interest litigants then.
Subsequently, they filed three period public interest litigation.
Yes, this was the major one. Where
This was the major one.
So let us see their public interest litigation, whether they disclose this interest in the land.
No.
Yes. Para 8. Same thing. 6, they say inhabitants of the locality. 7, they say running that.
No, my lord.
Sorry, you are running the.
Yes.
Sorry. Let us see how they describe themselves.
My lord, they have filed a document where the my lord, all the villagers have wrote letters. This is the one, my lord, the document is also there. They are espousing the public cause.
They say that they are activists in the area.
Yes.
Achha, let us come back to that order 1 rule, the whatever addition of party application. That was page
115 of my application
115, my lord.
onwards.
Second volume, page 1.
And I also file my opposition reply, everything completed before the tribunal.
Let us see your locus, what you have. Yeah.
Nowhere it has been stated that he is a public spirited. It has been stated the applicant suppressed all material fact, deliberately did not party to the added applicant.
Where have they stated that they own a portion of the land in their application? I don't find it. We don't find it.
No, they furnished a document, my lord.
Document may be, cannot be beyond pleadings.
Yes.
We don't find anywhere. The only premise apparently was their public interest litigation, and the tribunal also proceeded on that premise that since they're proper parties whose presence is strictly essential.
No, the public, my lord, they have taken a point that they are the possessor of a particular dag number.
Where? They have not taken in their application for addition of party.
But the one document they have produced.
Maybe.
But that has been reflected in the order, impugned order.
Where is that? In the order?
Second page, my lord.
Second page. Yes.
Second paragraph. At the time of the hearing, learned advocate of the applicant and the added respondent submitted the name possessor of the such and such. Indulan Paramanik of the ROR of the possessor in respect of the subject land. They have filed a public interest litigation.
This is even beyond the pleading.
Beyond the pleading.
We'll come to Ms. Dedawal. Let us come to. Yes, Ms. Dedawal.
Malad,
Two primary things which you have to satisfy us. One is that if you have been implemented in the character in the character of a possessor of another portion of that land, your public interest litigation, it is contrary to that. It could not have been a public interest litigation. Once you claim public interest litigation as a public spirited person, you cannot claim a right in the land. Secondly, in your pleadings, there is nothing of that sort. You have been implemented only because you had filed the public interest litigation. You can bring on record all the relevant facts. Does that make you a necessary party in a private litigation like this? Public interest, you are a good party, but you are not even a proper party in a private dispute. It's between them and the authorities. How can you be implemented here? Authorities, I'm sorry, the authorities represent your interest in the sense that they can always produce the public interest litigation, and they are also stating about the public interest litigation and relying on that, because the review the public interest, the division bench permitted them to go before the. So you are not necessary parties here.
my lord, my record of rights. My lord, kindly see for a moment.
Can we have not pleaded that in your addition of party application?
3 plots, they are running the hotel. My lord,
No, they are whatever they have done, that will be considered.
My lord, in my
What is your locus standi? That is.
I specifically stated, page 27.
In reply, you have stated your locus standi.
In the petition also, my lord, I stated
Where
that
in the petition, where we don't find it anywhere. Only para 3, that the inhabitants of Purbo Amoravati and its adjacent area are virtually cultivators earning their livelihood by cultivating. What about you? Who are you?
my lord, we are the inhabitants of that area, and
Not even stated that. You have not even stated that we are inhabitants. You have stated that the inhabitants of Purbo Amoravati are virtually cultivators and earning their livelihood. Nothing else. And you describe yourself as by your names.
I'm the positive.
How are you a necessary party here?
Because my lord, as my instance, my lord, written complaint has been made, and on the basis of the written complaints, all the proceedings has been initiated by the.
Your written complaint, your role ends there as a complainant.
And my lord,
you lodge a complaint, your role is over.
83
You don't have a right of hearing unless you are a person interested. A person interest is only one whose rights will be affected, either before the appeal court or before this tribunal, you have not pleaded a single line as to what interest of yours would be directly affected.
My lord, in the reply, I specifically, my lord, stated.
Acha, let us see the reply. Where is that?
Yes. Reply here, my lord.
215.
Same thing.
My lord, I stated, my lord, kindly for a moment. For a
You are more obsessed with their hotel business than your own locus standi.
Page 217.
217, we are there. We have read entire page 217.
Page 217, para C.
Read out the sentence.
That the inhabitants of the Purbo Amravati and its adjacent area thereof are virtually cultivators and earning their livelihood by cultivation and sometimes earns their livelihood as daily labor. It is pertinent to mention that the Indrolal Pramanik is a member mentioned here, Borgadar of plot number.
There's no signature beside this. How do you know it was never, it was inserted later?
Stroke 2171.
There is no signature, no affirmation of this.
That was submitted before the tribunal. If
We
your
don't know.
lordship kindly call for the record that was submitted before the tribunal.
Even if that was submitted before the tribunal without this signatures, tribunal could not look into this. I'm sorry.
And
Could not look into this. This is not a part of the affirmation. And even if you have stated barely boldly that pertinent to mention that Indral Pramanik is the recorded Borgadar.
Yes.
Now, Indral Power.
If your lordship kindly see from 130, 131, 132.
131.
130, 130. 130, 131, and
Yes, that same Khotian number you also have something.
yes, 130, my lord, my name as a possessor. My lord, they are running their hotel 1681, that is Doba, 1683 stroke 2171, that is Sali, without conversion, that is Indrolal Pramanik is the possessor. My lord,
So
for
how does that
business-
give you a right? He is running a hotel illegally in an adjacent portion. You own an adjacent portion and you have a business interest in running a hotel.
My lord,
You are also running a hotel.
No.
You are a cultivator. Very well. You may have a public interest, but otherwise, personally, how are you interested? It's a different plot. You are not the owner of that plot.
because my lord,
You hold an adjacent land.
because my lord, on that land, because as they are, my lord,
This was disclosed for the first time before the tribunal.
my lord, this was disclosed before that was all.
You suppress this before the public interest litigation court
All the document annexed. My lord, it-
without any pleading, without a single pleading in the public interest litigation. Your public interest litigation is with us.
my lord, on that in public interest litigation, my lord,
These are contrary stands taken by you. You have to understand this. In public interest litigation, if you are an adjacent landholder and you claim a direct interest in the land, the entire premise of that public interest litigation goes. Therefore, your present pleadings are, even if you say you have pleaded, it's palpably contrary to the public interest litigation pleadings and vitiates the premise of that public interest order.
public interest litigation, my lord,
You cannot take a contrary stand.
his voice because Doba, that is nature of land, Doba, that is converted.
You raised your voice but kept your document behind yourself.
My lord, I annexed everything in the public interest.
No, this annexing business we have deprecated time and again and we'll do it again. That annexing documents without pleading, the court is, are those time bombs? You can use them whenever you like.
My right.
You annex documents, we are not supposed to go through a million documents you are annexing. Sorry, no, you have to plead and you have to argue. Never argued, not reflected in the petition itself. Can there be evidence beyond the pleadings? In a writ petition,
My right has been, my lord,
you are claiming a new right. You claimed as a public interest litigant. And here you are.
4C proceeding has been started for.
Sorry, Ms. Dedhawal, you
Kindly see.
this is a bad order. Please, don't disturb.
Court, my lord, only implement the 4C5 that was initiated.
Since you have suppressed that, we cannot permit you. This would be completely violative of equity because you are taking a diametrically opposite stand than the public interest litigation. There you have only stated that inhabitants, environmental balance and lofty words. And now it is seen that your business, your own interest is being covered. If you have a personal interest, now you are trying to set up a pleading which is contrary to a pleading in the public interest litigation. You cannot be permitted to do so. That will be contrary to equity. Writ court is equitable court. And this tribunal is exercising equity jurisdiction as well because it has substituted by virtue of L. Chandra Kumar. Tribunal has substituted us sitting singly. And we are sitting in judgment actually like an appellate court against a single judge. Same hierarchy. Tribunal is the single judge now. We are taking up in division bench the appeal in the form of a WPL.
And at other point also tribunal will have taken that as
That is a bad point.
other
You know about these things and you
all the documents
for that you are not a necessary party. Ms. Dedhabal
annex
cannot be supported.
by addition of party application, and that was first time before the tribunal. Well, that was not disclosed anywhere.
That does not make you a necessary party. I have knowledge which may influence the fate of the suit, even in a suit. That does not make me a necessary party. I have to have a direct interest. If you claim at the moment you claim a direct interest, that is patently contrary to your stand taken earlier before the public interest litigation bench.
Public
So you will be guilty of perjury then for suppressing this material fact.
well, at 4C
That is the consideration in a public interest litigation, Ms. Dedhabal. That is the only consideration. Whether you are trying to canvass a personal interest in the garb of a public interest.
well, that is twofold, malad, in the public interest litigation that DOBA has been malad filled up by way of constructing a
Even then, even if public interest is being hampered, if you have a direct interest, you say, I have a portion of the land, that interest is directly affected.
malad, in the year malad 2011, malad, they have started construction, malad, repeatedly I made representation, malad, from the 2011, I unable to enjoy my property.
And you have not disclosed anything there. By pen, you have just written, you have inserted that you are a recorded Borgadar of plot number such and such.
And the possessor, malad, I am the possessor, malad, from 2011.
Possessor, where have you stated? Recorded Borgadar means possession. But apart from that, you have not stated anything. Recorded Borgadar was this much.
2011, malad, I am unable to enjoy my property for their unauthorized construction.
Then your public interest litigation will give them liberty to approach the public interest bench to initiate a proceeding on for perjury. Or will directly refer
Malad,
for
there was a
perjury.
review application that was malad turned down.
You never took the plea that you have a public in private interest. You are for the first time inserting.
Free scope, malad,
Don't raise your voice so much, Ms. Dedhabal. We'll just refer it to perjury. We'll do that from here, even now. Even now. This is perjury. This is suppression of gross material fact. You get an order in the public interest litigation without disclosing. What?
litigation, malad, only
Do you know the idea of public interest litigation, Ms. Dedhabal? Do you have any idea? What is a public interest litigation? It is not to canvass your own rights. You suppressed totally that you have a private interest in the land, and in that same land you are a Borgadar, and now you got an order from the public interest court by saying that you are an inhabitant. Yes, environmental protection and lofty words. Not a single line disclosing that you have an interest in that land. And you obtained that order from the public interest litigation court.
regarding the
That order is vitiated then. The premise of that order goes. Those orders should be recalled. We'll refer this to the current public interest court for looking into this. We'll do that in any event. Whether we affirm this order or set aside. This is a contrary stand, we cannot permit you.
Another point, tribunal also, malad.
What is the other point?
That is all the points, malad, I disclosed there, malad, that was never be disclosed by anywhere.
Very well.
And I disclose everything because, malad, there was a BLLRO's report, and there was a, malad, in WPLRT when they malad, refused to grant any interim order, they came before this Honorable High Court. That Honorable High Court's order I annex, and SLP, malad, only liberty has been given to complete the proceedings within 6 months. Malad, nothing more, nothing else. And 6 months already gone. Malad, within 6 months, I filed it, addition of party, opposition reply, everything completed. Malad, that was not stayed. Only 6 months there was a stay order.
Do you mean to say that before the BLLR or the tribunal,
Yes.
it was never disclosed that there was a public interest litigation order or a review order? If that was disclosed, that is sufficient. Your presence is not necessary for that. What else should you do? What is your role as a complainant even in a public interest litigation?
Because all the, malad, opposition that was dealing, malad, in their earlier proceedings, in every proceedings, but that was not disclosed anywhere by the state, and that was not annexed by my learned friend also. First time it was disclosed before the before the tribunal. And, malad, here is a specific, malad, opposition made by the block land reforms officer disclosing everything that was not annexed in the application also. And everything malad, disclosed by the concerned BLLRO.
May I draw
But
your,
their case is completely conversant. Completely conversant. They
Yes, we have heard you, Ms. Didhaval. We understand. Yes, state has to say anything. No,
Anybody will-
neutral party.
Milord,
Yes.
may I draw your lordship's attention, page 211, 12 and 13.
You have disclosed for that.
No. Subsequent, Milord, public interest litigation has been disposed of when everything has been brought to the notice of the court. She has been compelled to withdraw. She has been compelled to withdraw.
For that reason.
Whoever shouts higher will win the case. Start. Your time starts now. Both of you, please. Just try to shout. Whatever. You may abuse the code also. But you have to shout. Whoever shouts the loudest wins the case. Right? Do that. We are waiting for that.
No.
Why not? And use the microphones also.
First, my lord, submit
Yes.
it.
Page 211, Milord. The order dated 12th of December 2023.
Yes.
They filed subsequent, Milord, public interest litigation. When everything has been brought to the notice of the court, they, Milord, withdrew this application.
What has been brought to the notice of?
That, Milord, they are espousing their personal cause.
That from this order, it is
Yes,
not evident for the.
withdrew, Milord. The next, Milord, the CPN they have filed, that has been, Milord, disposed of. They have alleged that the order alleged to have been violated has not been complied with. But court holds that that has been complied with. Next public interest litigation has been filed at page 213. That has been dismissed as withdrawn.
But not recorded anywhere that
Yes,
this was the reason. So we cannot go on. Yes, Mr. Dawar.
My lord,
We are we'll record his argument that it was withdrawn because you were exposed, sort of. But we don't find that from the order. You withdrew, that's.
this was withdrawn for that reason, that SLP pending before the court, Supreme Court. For that reason, my lord, the SLP was not finalized. For that reason, that was withdrawn. CPN, for that reason, that
Acha,
was
your main this OA before the tribunal is because the ADLR has concluded and said that the conversion was illegal.
Yes.
Without considering that this
This is a case where invocation of the rule 166.
24th March 1986, that was your ground.
Yes.
page 92 is the challenge before the.
But that is pending. We will not touch on the merits,
That is
just
the
as for the
subject matter
narrative
in
we
the
asked.
way, subject matter in the way.
But Ms. Didhaval, you are not a necessary party. You have done whatever you had to do. The tribunal has taken note of whatever you wanted to point out. But we are sitting aside this one. The writ petitioners claim. Now, the writ petitioners are running a hotel in the disputed plot. Push up next para. A public interest litigation was filed by the private respondents, claiming to be public spirited persons and inhabitants in the locality, seeking an early logical conclusion to the penal procedure which had been undertaken under section 4 capital C within bracket 5 of the West Bengal, this Land Reforms Act, West Bengal Land Reforms Act 1955, for alleged illegal conversion of several plots, including the plot in question. First up, next para, such public interest litigation was initially disposed of by directing the concerned authorities, that is the BL and LRO, to conclude the proceeding within a limited period. Full stop. Subsequently, at the behest of the present writ petitioners, the said order was reviewed, thereby carving out a niche, NICHE, of opportunity for the present writ petitioners to be given an opportunity of hearing before such conclusion. Full stop. Next para. Thereafter, the concerned officer, the concerned authority, disposed of the proceeding upon coming to the observation that there was illegal conversion of the disputed plot of land by the writ petitioners. Full stop. Learned para. Learned counsel for the writ petitioners argues. Learned counsel for the writ petitioners argues that the concerned authority, while passing such order, did not take into consideration the provisions of Rule 166, which categorically provide that if the land was converted before March 24, 1986, such conversion could be regularized subsequently. Full stop. That apart, the documents produced by the writ petitioners before the concerned authority, it is alleged, were not considered while passing the order in question. Full stop, thus, para, being thus aggrieved, comma, the writ petitioners filed an original application
61 of
bearing OA number 61 of 2024 before the West Bengal Land Reforms and Tenancy Tribunal, which is still pending. Full stop, next para, during pendency of the same, comma, proceedings were initiated for demolition and orders were passed by the authorities for demolition of the constructions made by the writ petitioners on the property in question, comma, which was challenged by way of a writ petition, comma, unsuccessfully. Full stop. The said order of the writ petitioner, writ court was affirmed in appeal, comma, challenging which a special writ petition was preferred by the writ petitioners, comma, which culminated in an order of status quo being passed in the meantime and a direction on the learned tribunal to dispose of the original application
on merit.
on merits.
Within a 6 months.
Within a period of 6 months. Full stop, next para. Thereafter, comma, an interlocutory application, comma, bearing MA number 1619 of 2024 was filed by the private respondents herein.
6 and 7.
Acha, private respondent number 6 and 7 herein. You agree to that, Ms. Dedhaval? 6 and 7. 6 and 7 herein, comma, apparently captioned under section 16 within bracket small d of the West Bengal Land Reforms and Tenancy Tribunal Act 1997. Full stop, learned counsel for the writ petitioner argues that the said provision is one for review and is not applicable to an application which is substantially for addition of the private respondent number 6 and 7 as parties to the original application. Full stop, next para. It is further argued that the learned tribunal erred in law and without jurisdiction in allowing such application, comma, thereby directing the respondent number 6 and 7 to be impleaded, comma, inter alia on the premise that the writ petitioners are in occupation of a portion of the subject land. Full stop, next para. It is argued that the said stand is contrary to the one taken in the public interest litigations. Full stop, next para. It is also sought to be argued on behalf of the writ petitioners that subsequent writ petitions were also filed, comma, which were mostly withdrawn by the writ petitioners on the in view of the contrary stand taken before the tribunal, comma, to obviate any adverse orders being passed in the public interest litigations. For some next para, learned counsel appearing for the private respondent number 6 and 7 controverts that the subsequent writ petitions were withdrawn to suppress anything. Full stop, it is submitted that such withdrawal was in view of the pendency of the matter in connection with the previous proceeding before the Supreme Court, Honorable Supreme Court. Full stop, next para, learned counsel for the writ petitioner places reliance on certain documents which are annexed to the present writ petition and were produced by the private respondents before the tribunal, which indicate that the private respondent number 6 and 7 herein, comma, the proposed additional parties, comma, in the tribunal are in occupation of a portion of the property. Full stop, next para, learned counsel for the private respondent number 6 and 7 also places reliance on paragraph 3 within bracket small c of an affidavit in reply filed in connection with their application for addition of party before the tribunal, where it has been pleaded that the private respondents that the private respondents are recorded borgadars of the concerned plots. Full stop, next para, thus, comma, the said interest in the property, it is argued, comma, gives a right to the private respondents to be impleaded as a party before the tribunal. Full stop, secondly, comma, it is argued that material points and orders of court were being suppressed by the writ petitioners before the tribunal, comma, which necessitated the impleadment of the private respondent number 6 and 7 as parties to the said proceeding. Full stop, next para, heard learned counsel for the writ petitioners, comma, the private respondent number 6 and 7 and the state. Full stop, next para, it transpires that within the four corners of the application for addition of party, comma, not a single statement was made as to the private respondent number 6 and 7 being in occupation of the property, in physical possession of the property in question. Full stop. Next para. Although we do not accept the contention of the writ petitioners that the caption of the addition of party application was erroneous and as such the same was not maintainable, comma, since it is well settled that the content and prayer and not the caption of an application is material, comma, we cannot give a go by to the fact that in the original application for addition of party, comma, which formed the basis of the impugned order, comma, there was no averment as to the petitioners as to the private respondents number 6 and 7 having any personal interest in the property. Full stop. It is for the first time in paragraph 3 within bracket small c that a sentence was introduced by way of handwriting, comma, stating that Inrolal Pramanik, comma, one of the private respondents, comma, is the recorded Borgadar of plot number 1683 by 2171. Full stop. Next para. Apart from the fact that we do not find any signature of the person affirming such reply against the said sentence inserted by hand, comma, we also find that the said bald statement is insufficient to establish actual physical possession and interest of the private respondents in the disputed plot. Full stop. Next para. More importantly, comma, a gross dichotomy would ensue if such plea of the private respondents is accepted at this stage. Full stop. All along, comma, the very premise of the public interest litigations filed by the petition by the private respondents was that they were public spirited citizens and being concerned with the environmental hazard being caused by illegal possession by the present writ petitioners, comma, the private respondents had approached the court under the public interest litigation umbrella. Full stop. Next para. However, comma, it is well settled that such remedy is available for the purpose of canvassing genuine causes touching the public interest and having a bearing and ramification in the public law domain, and cannot be abused by persons having direct and personal interest in the subject property. Full stop. Next para. If the plea of the private respondents now being sought to be canvassed is to be accepted, comma, it would then follow that private respondent number 6 and 7 have a direct and personal interest in the land in question and as such had no locus standi whatsoever to maintain the public interest litigation. Full stop. Thus, comma, the said fact having been suppressed before the public interest litigation court, comma, tantamounts to gross suppression of germane and material facts before the public interest court. Full stop. Next para. Thus, comma, the private respondents cannot have the cake and eat it too, it too, comma, by having the benefits of both worlds. Full stop. In the same breath, comma, since the private respondents have obtained orders in connection with public interest litigations on the very premise that they were public spirited citizens, comma, they cannot now be permitted, comma, in equity or in law to take a diametrically contrary stand by claiming private and direct interest in the plots in question. Full stop. Doing the same would tantamount to putting the endorsement and seal of the tribunal and or the court to a patent illegality and suppression exercised by the private respondents. Full stop. Next para. Moreover, comma, apart from such contrary stand being not maintainable at this juncture, comma, the handwritten insertion that too in the affidavit in reply in connection with the addition of party application does not suffice to indicate the exact extent and nature of the interest of the private respondents in the suit in the disputed property. Full stop. It is well settled that documents by way of evidence, comma, which is beyond the pleadings, comma, cannot be looked into, and as such, comma, this court chooses not to look into the documents sought to be relied on by the private respondents, comma, nor was the tribunal entitled to do so. Full stop. Next para, coming to the impugned order, comma, we find that the tribunal, comma, in a cursory manner has observed that at the time of hearing, the learned advocate for the proposed added respondents submitted that the name of one of them, bracket Indulal Pramanik, bracket closed, is mentioned in ROR as possessor in respect of subject land, full stop. Next para, that apart, comma, not a single line has been devoted by the tribunal to consider the said pleading to be a premise of adding the private respondents as parties to the litigation pending before the tribunal. Full stop. The only substantive reason attributed to the order adding the private respondent as parties is that under Order 1, Rule 10 of the Code of Civil Procedure, a court can add parties to a suit if their presence is necessary for the effective and complete adjudication on the matter, comma, which includes a lot of necessary parties who should have been included initially as proper parties, whose presence helps the court resolve all questions involved. Full stop. The tribunal went on to explain that proper parties mean the individuals whose presence, comma, while not strictly essential, comma, helps the court to effectively and completely adjudicate all questions involved in the suit. Full stop. The tribunal proceeded to observe that in the instant case, comma, the proposed added respondents were parties in public interest litigation and they have knowledge about this matter, which may help the tribunal to adjudicate the dispute effectively. Full stop. Next para. Unfortunately, comma, the above grounds are not good grounds for addition of a party in a litigation not having public ramifications or erga omnes, ERGA space OMNES effect, comma, that is affecting the interest of third parties. Full stop. The dispute is now between the state and the present writ petitioners insofar as the conversion is concerned. Full stop. The mere fact that a public interest litigation was initiated by the private respondents does not entitle the private respondents to have any locus standi to be impleaded in such a private dispute, comma, which would expand the scope of the private dispute beyond recognition. Full stop. Next para. Even the division bench taking up the public interest litigation, comma, in its order of review, comma, specified that opportunity of hearing was carved out for the writ petitioners. Full stop. Next para. The mere fact that the present private respondent number 6 and 7 could add value to the proceeding by citing the orders of the public interest litigation does not entitle them automatically to be either necessary or proper parties in the private dispute between the state and the writ petitioners. Full stop. Next para. Thus, comma, arekta line. In any event, comma, it is for the state, comma, in the event the writ petitioners at all suppress, comma, to bring before the tribunal all orders passed previously by the writ court. Full stop. Next para. Even otherwise, comma, since the SLP was preferred, comma, in connection with a subsequent proceeding, comma, where all the material facts, comma, including the existence of the orders passed in the public interest litigation were disclosed, and the writ petitioners are bound to rely on the order passed in the SLP, comma, since a status quo has been passed in their favor, comma, it cannot be said that the tribunal would be oblivious of the orders passed in the public interest litigation. Full stop. Next para. In view of the above, comma, we are of the opinion that the learned tribunal acted dehors its jurisdiction in impleading the present private respondent number 6 and 7 as necessary and stroke or proper parties to the litigation pending before the tribunal, comma, which is private in nature, comma, taking into account a diametrically opposite version being given out by the private respondents regarding locus standi than that taken in the public interest litigation. Full stop. Next para. In view of the above, comma, WP LRT 153 of 2025 is allowed on contest, comma, thereby setting aside the impugned judgment dated
7th of August 2025.
Yes, August 7, 2025, passed by the third bench, West Bengal Land Reforms and Tenancy Tribunal, in MA number 1619 of 2024, arising out of OA 61/2024 within bracket LRTT. Full stop. Accordingly, the order allowing the implement of the private respondent 6 and 7 is hereby set aside. Full stop. It is expected that the learned tribunal shall proceed as expeditiously as possible, comma, in terms of the order of the Honorable Supreme Court, comma, to decide the original application pending before it, comma, without being prejudiced on merits by any of the observations made above. Full stop. It is further clarified that it will be open to the that it is expected that both the writ petitioners and the state shall place all relevant documents, comma, including the orders passed in the public interest litigations before the tribunal to facilitate a proper and comprehensive disposal of the original application. No rest to cause certain certificate.
If not already disclosed, I have already disclosed, my lord.
Comma, if not already done. Is there any connected application in this?
No, no.
Item number 5.
Yeah.
I appear for the petition.
Yes, what is the matter?
The expeditious disposal of a contempt application.
My lord, this is a matter, my lord, relating, you kindly come to, my lord, the order passed by this honorable court. Page, my lord, the page 36. My lord, the 36, my lord, the by this honorable court directed to dispose of this application within 8 months. Thereafter, my lord, the application has been preferred before the learned tribunal. Learned tribunal has passed the order not to, beyond the July, you have to, my lord, the dispose of the mutation application. They have been, my lord, the given a chance of, my lord, the notice.
Dispose of what application?
My lord, the application for the mutation. That is kindly come to page 14. Order passed on 18.
So that mutation application writ petition was dismissed. Let us see the order of Justice Rai.
Yeah.
Article 36, writ petition. Achha. So writ court did not have jurisdiction. So you are given liberty to file an original application before the tribunal to be disposed of within 8 months.
8 months.
Now,
8 months, my lord, kindly come to, my lord, the page.
What was the date of this order?
54.
When did you file that application?
File the application, my lord, within time. My lord, file this application on, my lord, the just after my disposing of this, my lord, the writ application by this honorable
In
court.
2025 January or
25, Thereafter, my lord, 18 to 2025, kindly come
18 to 2025 is not immediately after, much after.
Much after. 18 to 2025.
So 8 months has elapsed when? October.
October. My lord, thereafter, my lord,
October is not yet over. Has not yet come.
Was not come. But they have been, my lord, July. Kindly come to the, my lord, the application, my lord, 18 to 2025, learned tribunal observed that the July, not beyond the July 2025, my proceeding has to be completed.
Next date has been fixed on 18th of May 2026.
Now the question is that, my lord, they have served a notice for field inquiry. My lord, the after when the field inquiry have been,
So you want a compliance of the single bench's order?
My lord, I am not compliance of the single bench order.
What are you challenging here?
My lord, I am
order under contempt
application should be, my lord, the dispose of as the learned tribunal has been directed to take up the not to beyond the July 2025. My lord, after the admitting the contempt application, they have been shifting the date to the 2026.
The contempt application was filed on?
One of the 8th, my lord, the 8th August of 2025.
What was the contempt about?
Contempt about the violation of the order, my lord, passed by this honorable learned tribunal of the 18th February 2025. They have been directing to the annexure way application page 18 to take a decision.
You allege that the tribunal was in contempt of the order.
Tribunal has, my
And you
lord,
filed the contempt application before the tribunal itself.
tribunal, I have been, my lord, filed the contempt application against the
The
order.
tribunal will decide allegation of contempt of by itself.
Not, tribunal has to, my lord, decide the contempt application on the violation of the BLRO, the order of the BLRO. This is, my lord, my case. BLRO has to, my lord, take a decision of this, my lord, application. But BLRO has
But the single bench of this court in the writ petition directed the tribunal to dispose of within 8 months if you file an application.
But
So your challenge against your challenge before the tribunal was against inaction on the part of the BLR. So where is the contempt here?
Contempt, my lord, the not to, my lord, the implement the order of the passed by the learned tribunal. The I am passed the
Tribunal had passed the previous direction.
Yes,
Where is that?
That is, my lord, the PH, my lord, the
Page 54.
54.
Order under contempt.
No, this is the tribunal's direction.
He's alleging violation of this in the contempt application.
Preferably bila আছে. Oh, tribunal had disposed of previously.
Disposed of this.
আচ্ছা, now only the contempt is pending.
Yes.
Yes, what do you say? What should be a reasonable period, Mr. Gali? End of November, only contempt.
Lordship will direct the tribunal to, my lord.
The tribunal, yes.
18th May is the next.
Lastly, my lord, they have served a notice, my lord.
18 May 2026 cannot be the next date. I mean, we'll direct them to prepone, it to be preponed.
Make it reasonable, Lordship. So
Is the tribunal fully manned now?
I think not.
It is not. How many benches are functioning, Mr.?
I can't see.
3 benches we are getting orders. 1, 2, 3, third bench. Up to third bench you have seen.
Yes.
How many benches are there? 3 benches in
Fourth
total?
bench. Fourth bench.
4 benches. So one shot contempt application can be decided earlier then. The challenge in the present writ petition is in the delay on the part of the West Bengal Land Reforms and Tenancy Tribunal, first bench, in disposing of a contempt application filed by the writ petitioner. So, next para, the brief backdrop of the case is that a writ petition was filed, giving rise to WPA 28458 of 2024 by the writ petitioner, alleging inaction on the part of the BL and NLRO regarding the application for mutation made by the writ petitioner. Video order dated December 4, 2024, a learned single judge of this court disposed of the said writ petition by granting liberty to the writ petitioner to approach the tribunal for such inaction on the part of the BLLRO, and if so done, the tribunal was to dispose of the same within 8 months. For next para, the learned tribunal, by an order dated February 18, 2025, disposed of the original application filed by the writ petitioner pursuant to the order of the learned single judge by directing the concerned BL and NLRO, Raiganj at Kornajhora, KORNAJORA, district Uttar Dinajpur, as expeditiously as possible, after extending an opportunity of hearing to all interested persons to opposite parties disclosed in the notice annexed thereto, preferably before the end of July 2025. Full stop. Next para, the BLLRO having failed to dispose of the matter before July 2025, a contempt application bearing MA 1124 of 2025 was filed before the tribunal
4th August.
On August 4, 2025. August 4, 4th August.
4th August.
August 4, 2025. Who's up next para? By an order dated September 1, 2025, the learned tribunal has posted the said contempt application for hearing in the next year, that is on May 18, 2026, which is more than 1 year after the filing of the contempt application. full stop, no, more than, no, which is about 9 months after filing of the contempt application. 4, 5, 9. Filing of the contempt application. Full stop. Next para. Learned counsel for the petitioner seeks an early disposal of the contempt application. Full stop. Upon hearing learned counsel for the petitioner and the state, comma, we find that an excessively long date has been given for disposal of a contempt application, comma, which is otherwise summary in nature. Full stop. Next para. Keeping in mind the limited context of the contempt application and the inquiry thereof being confined only to the non-disposal of the matter by the concerned BLNLRO within the stipulated time, comma, we are of the opinion that the learned tribunal ought to prepone the date of hearing of the contempt application and to dispose of the same at the earliest. Full stop. Accordingly, WP LRT 155 of 2025 is disposed of by directing the first bench, comma, West Bengal Land Reforms and Tenancy Tribunal, comma, to prepone, to shift back the next date for hearing of the contempt application bearing MA number 1124 of 2025, bracket A, in connection with OA 3621 of 2024 of LRTT, bracket closed, comma, fixing a date upon notice to both sides before November 30, 2025, and to dispose of the contempt application as expeditiously thereafter as possible, comma, positively within December 31, 2025, upon giving opportunity of hearing to all concerned. Full stop. No address to cause, urgent certified copies. Affidavit of service filed today be kept on record. Thank you. Next.
Item number 6.
Yeah, I'm for the petitioner.
The private respondent.
I've served. They're appearing anyway.
What is the matter?
Friday evening, my client got this.
Friday evening?
I got
Entire weekend?
Yes, Friday evening.
You require 1 or 2 hours.
No, Friday evening I got this application lordship writ petition.
More than enough time
10,
has been given to you.
Morning 10 o'clock I received it. Morning 10 o'clock I received it. My client received it on Friday 4 o'clock.
Rightly so. 48 hours have been given. Yes, what is the matter?
Lordship, I am the private respondent before the learned tribunal.
You received the brief today morning?
Yes. Today.
Why did you receive the brief?
From my client.
Why did you receive the brief?
Because I was a advocate on record or before the time.
That's why you received the brief.
Received the brief.
That's why you received the brief. Anything is given to you, you receive. The court is taking up the matter at 12 and you have received the brief at 10.
Yes.
And you are asking, you're with a bold voice, you are saying to the court that yes, I have received late. 48 hours notice is more than enough. You get 10 minutes further. We'll come back in 10 minutes.
Lordship, the land originally, it was, a portion of it was recorded in the name of the petitioner's predecessors. I just indicate the framework first. And I saw that the name of the private respondents herein was recorded to the entire extent of the land. I preferred a application for the correction before the revenue officer.
You said it was recorded in your name, your predecessor's name,
Predecessor's name.
in the CS.
CS and RS.
And suddenly you discovered that their name was recorded.
Recorded to the entire extent. Now I preferred an application before the revenue officer. Revenue officer said that yes, there are reasons to believe that it's not correctly done, but you have to approach the civil court. Civil court for correction about title declaration. Thereafter, I approached the appellate authority. The appellate authority passed an order by saying that 50% of the plot be recorded in my name, in our name actually, and the rest 50% in the name of the private respondents. The private respondents took up the order in appeal before the without the LRTT. The tribunal said that yes, the private respondents are unable to trace out their title by way of any instrument. So the order, because the revenue of the appellate authority recorded 50% in their name, said that the entire order, the order is bad, but is silent in respect of the rest 50% to which I am entitled to.
That amounts to deemed affirmation of that. You say the entire land then should have been in your name.
Now, my lord,
if there is a silence regarding your 50%, then it's a deemed affirmance of the 50% given to you.
The revenue
to that also. If you are satisfied with that, we can do that from here, subject to hearing, not before hearing.
Revenue officer's order says that didn't, I mean, not entertain the challenge. The appellate authority recorded 50% in my name, 50% in their name. So if the appellate authority's order goes, then where will
the order has been set aside?
My lord.
Oh, that's right.
So that is the difficulty.
Right.
My lord,
Very well. So as far as your 50% is concerned, there was no adjudication at all.
There was no adjudication.
But the effect was that it was also
effect was there. My case is that in respect of 50%, it is unchallenged. That is
understood.
Fine. And for the rest 50%, I say that he's claiming under one person from one lady. I say that initially the CS record of rights, the land was recorded in name of two persons, Gopeshwar and Kopileshwar.
Since you are challenging Mr. Chatterjee, the limited scope of this writ petition is whether the tribunal should have considered your 50% and decided on that before setting aside.
Lordship.
Regarding their portion, they have not preferred any challenge.
They are not preferred any challenge. As far as I am concerned, I have filed a suit claiming my title in respect of that portion, but I am not agitating it here because that's subject matter of the.
But you have claimed title in respect of the entire property or 50% in the suit?
As in the suit, I have claimed my property in respect of the entire property.
Entire.
And that's after the order of the tribunal was passed. I filed the suit.
Let us hear them. Yes, what do you say?
Motibala Devi's name was reflected in the RS record.
Nonibala was your?
Motibala Devi.
Please take the microphone. Please take the microphone.
Motibala Devi's name is reflected in the RS record of right.
Who is Motibala? Your predecessor or their predecessor?
I purchased the property from the legal heirs of the Motibala.
All right.
Lordship, Motibala name.
But you have not preferred any challenge against this tribunal's order. So tribunal's order remains as far as you are concerned. There is no provision. This is not an appeal that will have a cross objection.
I'm narrating because Lordship, whole share is reflected, but only dispute regarding the Ejmali. There is no dispute in the KB record. KB record, Ejmali is not there, Lordship. Thereafter, Lordship, after demise of the Motibala, their legal heirs name came into the record.
Motibala owned 50% of the property.
Whole share.
So why did the
39 decimal was recorded?
Why did the appellate authority hold 50%, 50%?
Appellate authority invoked the jurisdiction of the civil court and stated that you are the holder of the 50% and the other people of the 50%. Lordship.
But in the absence of any challenge by you to the order of the tribunal, we cannot go into that even. We can only look at his 50%.
I challenge the order of the appellate authority stating that the appellate authority
before the tribunal, but
the
tribunal has held no. The entire appellate authority order should be set aside.
Yes.
Because you have failed to prove your title.
No, and stated that this RS record of right cannot be challenged under section 54 of the West Bengal Land Reform Act.
That has also been.
Yes.
So let us see the imputed order first.
Yes.
Mr. Kalib, we will come to you last. Mr. Chatterjee, you better complete your arguments on that merits also. Then we'll go back to your friend again.
Lordship. Lordship,
Just took a brief understanding of the case.
initially the land was recorded in the name of Gopeshwar and Kopileshwar. I prepared a family tree, my lord.
Acha. But you should give copies to them also.
I have only one copy. That's the difficulty.
Why? Should have more. Gopeshwar,
In the
Kopileshwar.
CS record of rights, the name of Gopeshwar Kopileshwar is recorded and it's an admitted case.
All right.
I am claiming under Gopeshwar.
All right.
Lordship, the
You are P1, P2,
indicated
all.
P1, P2,
Right.
P3, and P4.
So entirely under Gopeshwar.
Entirely under Gopeshwar.
And they claim under whom?
They say in RS record of rights, the name of the legal heirs of Gopeshwar is there. That is Visheshwar, Kashinath, Anadinath, Dukhaharan. Their name is recorded in the RS record of rights to the extent of 50% of the share. And name of one Pashanbala comes there in RS record of rights. Now, and Motibala's name, my lord, thereafter is recorded when Pashanbala's name is struck off with a pen and Motibala's name is recorded and some noting is there, Ejmali. All the authorities have raised questions how Motibala gets against the title to the property because they're not being able to show that from the family of the family of Puitundu.
You all claim by inheritance from these people, Misheshwar and Onadin.
I am claiming under Gopeshwar.
By inheritance.
By inheritance, recording is in respect of as intestate succession from Gopeshwar.
All along in the name of Gopeshwar and
Gopeshwar and his sons.
But suddenly in RS also the same position was reflected.
RS was in the name of this Visheshwar Kashinath sons.
Acha.
Suddenly, when LR record of rights, my lord, I find that the entire plot is recorded in the name of the private respondent. And he traces his title from one Motibala. And the authorities say that he has not been able to show how Motibala
acquired. The tribunal's order once.
Lordship, it's at page number 177 is the...
Yes. Refer to the internal pages so that...
Lordship,
page 177, Lordship.
Just refer to the internal pages, Mr. Chairman. We are following from the...
My internal, Lordship, it's page number 179 is the relevant
internal, lower, bottom.
Oh, internal page 2.
2, yes.
In the last paragraph, it is crystal clear.
It is argued. What is KB record?
Khanapuri Bujarat.
Oh.
So,
This is a bad logic probably under section 54. Appellate authority cannot correct this RSI. Appellate authority is not for the first time correcting RSROR. The appellate authority is sitting in judgment over RSROR, which had the power to do it. Because the original application was for correction of the records of rights.
Lordship, the LR record of right.
LR record of right. So that the appellate authority has the same powers as the first authority.
And as far as this Paschim Bardhaman is concerned, a vast portion of Paschim Bardhaman LR record of rights has been finally published very recently. That is why the KB stage has been stated.
Maybe. Yes, you want to add anything? The reasons are given in the order itself.
One more point is that after this order has been passed, the BLR, the private respondent has approached the BLRO for correcting the record of rights, means to reinstate it at the stage when his name was recorded as a whole. So that is now reducing.
Yes, because if that order of the appellate authority is set aside as a whole, that should be the position. That would follow.
That is the consequence.
So let us hear now. You have comprehensively argued. We have seen the reasoning also.
Nothing more. Only one point, that in respect of the
no,
of the rent, I have filed a suit. I have disclosed the plaint here.
Yes.
Lordship, I purchased the property from the legal heirs of the Motibala. Motibala.
The tribunal has clearly held. First of all, we are giving you the point so that you can answer. The appellate authority held on the premise of only the recording of Motiwala as Ejmali by scoring through Pasanwala without any basis being disclosed. You have failed to produce anything in support of Motiwala's title. Anything. That's why tribunal has set aside that the order of the appellate authority. But specific observation is that in the absence of any document to show that Motiwala acquired any right in the property. If that is the premise, then why shouldn't their share be considered? Because they had produced documents.
Lordship, Motibala's name is reflected in RSROR.
That is without basis. That is the premise.
Lordship, the deed of the Motibala, who is there praying for the submit of the direction was given to submit the deed. That deed was not available. Due to that is in that that was given. Lordship, I purchased the property from the legal heirs.
But you have not challenged. You have not challenged this order. But you have just taken advantage of the. We should remand it back to the appellate authority to consider both your title deeds and adjudicate regarding the share of the petitioner. Writ petitioner's share should be adjudicated. If that be so, the appellate court's order, the appellate authority's order should be modified by holding that because if you have failed to show the basis of Motiwala's name recording, then it should be, there should not be any your entire correction of the record of rights should be set aside. Their application should be allowed.
Lordship, see, total reflection in the RS record of right, total share is reflected in the name of Motiwala, 39 decibel.
RS record does not create title. There has to be a basis, a foundational fact which supports that recording. You have failed to produce anything. Why the name was changed in the LR records? Because the CS records and the LR records also have a forward effect. A forward presumption is created by the records unless that is something is shown to change alter the factual situation.
The deed from which the Motiwala purchased or not.
You have failed to produce anything. Anything. So why should the records have been corrected in the first place? Just LR records only show this.
Lordship, kindly come to the annexure.
In the RSROR, Pasanwala's name has been scored through and Motiwala's name has been noted as Ejmali. But there is no basis. You have to show some basis.
Ejmali reflection, but in the KB record, there is no indication of the Ejmali is there, Lordship.
Where do you find that?
Ejmali, the direction was given by the tribunal to produce the KB record. KB record was produced before the tribunal, and there a copy was given to me. In that copy, I got that there is no indication of the Ejmali is there, Lordship. On the basis of that document,
But you don't have a title deed of Motiwala, nothing.
I did not get because I purchased the property of the legal heirs of the Motiwala.
So when
I,
you purchase the property, you should have something to show that prior title, you should have
on the
conducted a
basis of
search.
the record, Lordship,
It's
it is
caveat
the
emptor.
1959's Motiwala enjoying the property in the RS record of right in her name. When I purchased the property, at that time, the Lordship, the pageant petitioner woke up and filed an application before the authority to cancel the record, RS record of right, because I am the entitled to get the share.
And this is also very self-contradictory.
No, we'll come back to you. We'll come back to you. Yes, Mr. Gali, what do you have to add?
My lord, be that as it may, whatever the learned tribunal has said, it has quashed the entire order of the appellate authority, because appellate authority has slashed 50 for him, 50 for the other. Basis not found. Now, what has happened after, my lord, consequent upon the passing of the order by the learned tribunal, now this RO has started the proceeding anew. That is page 241. My learned friend has annexed the notice also. 241, 89 of 2020. I believe this is the new case opened in this case.
New case opened at whose instance?
Jiten, both are getting notice, which since, my lord, after quashing of the 54 authorities order, so now this proceeding has been initiated, lordship, by putting both the parties on notice.
On the 50,
my learned friend wants stay of this before your lordship.
50, 51, how did they come in? '51 is revision. Yes, it was Somo to do it also. Somo to do it also.
Yes, yes. Lordship.
But the tribunal's order is apparently better. 50-50 was granted by the appellate authority.
Lordship.
They were actually happy with that. They did not challenge that. It is the private respondents who challenge that.
Yes. They want the entire.
Mr. Chatterjee, we are proposing to remand the entire matter to the tribunal. Not only to, because you produced some deeds that is also not clearly reflected here.
See, what I have produced is I have traced out my title to the up to the CS.
Therefore, both of you stand on the same footing, and your learned friend has a point in saying that since 1959, this HON'BLE was appearing, Motiwala's name, in the records of rights. So that also has to be explored. Apparently, 50-50 was the right formula adopted by the appellate authority. But even then, because Motiwala's name was there as HON'BLE, if that be so, then if both of you fail to produce any documents,
Lordship, in the same document in which Motiwala's name appears as HON'BLE, the names of my predecessors also appear, and that is why this recording as HON'BLE has been doubted by the authorities.
But if it's HON'BLE for one, it's HON'BLE for the others also.
If it is HON'BLE,
HON'BLE cannot be isolated.
He cannot claim the entire property.
The entire property he cannot have.
So
that recording, that recording has to go. So appellate authority did that only. Set aside and said it has to be 50-50, recorded as 50-50. That appears to be the only plausible thing. We are wondering whether we should retain that by setting aside this order as a whole and affirming the order of the appellate authority. Where is the appellate authority's order?
That is at page 115, lordship.
115. Because none of you are coming up with title deeds.
No.
Because I am claiming an intestate succession.
He is also claiming to have purchased from successors of Moti.
But I am tracing my title from the CS record of rights from Gopeshwar. His name is in the CS record of rights.
But RS records from 1959, it was recorded as HON'BLE, their predecessor in
the same document in which his name has been, Motiwala's name has been recorded as HON'BLE, my predecessor's name has been recorded.
Automatically also become HON'BLE.
So as far as
there cannot be half HON'BLE. I mean, if both of us are recorded as owners, and one is recorded as HON'BLE, the other also becomes HON'BLE.
As far as the 50% is concerned, there is no dispute. Only the rest 50%, I'll fight it out before the competent civil court.
I think
yes, 115.
Yes, 115.
Nothing to say about Sheriff Pashan.
He stated that he purchased the property of 70 decimal. If it is so,
who said? You?
No, it is
They claim by inheritance, they are saying?
he submitted the opposition, not even in the opposition is stated.
Who
that
purchased from whom?
Gopeshwar Pujari purchased the property. He submitted the opposition before the tribunal, and they said opposition clearly stated that.
Gopeshwar was at the CS era. Let's see how the appellate tribunal proceed, appellate authority proceed. Actually, Mr. Chatterjee, before the appellate authority, you said that you had nothing to say about the share of Pashanbala, and you wanted to restore the names, your name and your co-sharers, and his co-sharers.
I got the information regarding the plot number 70 of page 34, where it is clearly stated that the particular name is information is 39 days. Compensation of the floor of Donati and all that.
চ্যালেঞ্জ করেছে আপনার ডিটটা, আপনার ডিটটাকে সুটে চ্যালেঞ্জ করেছে, তাহলে সেটা
The appellate authority's option was the most intelligent option in the facts of the case, actually.
If both were happy, then nobody would have bothered.
If both were happy. No, they were not happy. They are not happy. But now, now you have been made unhappy by the tribunal and you have not challenged. So let's strike a deal. Set aside the tribunal's order and maintain the appellate authority's order, and we'll say this will be subject to the declaration of title in the suit. That suit, if they win, they whatever, and consequentially, and if they lose, you can also. If the civil court says they don't have title at all, then you can come up with.
He has not challenged it, but applied for correction before the BLRO.
No,
so he's taking advantage. Yes, obviously, he'll take.
I would have also taken in this.
Yes, right.
I purchased the deed, and that deed was also.
Which deed is non-existent?
No, that deed was not challenged. I purchased the
that deed will be given to you by your client tomorrow morning at 10:30.
Yes, disclose before the tribunal.
Dispose of the matter.
Before tribunal, there was supplementary affidavit, and he has disclosed a deed that was not taken into.
That is where.
Say that's in respect of a different plot of land.
No, Jiten Banerjee's deed is there annexed to the writ petition.
That is in a different plot of land. Achha.
No, same plot 39 decimal from the successors of Mutibala.
He couldn't trace out.
Deed was not challenged before the civil court. Lordship by the.
He couldn't trace out till Kopileshwar.
That deed was in respect of Motibala's share.
Total 39 decimal purchase from the legal heirs of the Motibala.
39 decimal is the entire property, entire land.
Kindly see page 41, Lordship. Kindly see page 41, Lordship. That is the deed.
Before that, Lordship, 34 is the information which I collected from
Motibala,
where it is
and the schedule is page 48.
They are legal heirs of Motibala and transfer the entire land.
So, no, then it's other way. It's the other way around. They produce a deed. You don't.
Remains unchallenged.
This is in respect of Motibala's share, and the authorities.
Entire land has been.
Land there was.
Yes, in respect of Motibala. I say Motibala couldn't have transferred it.
Not Motibala. Page 48. Come to page 48.
Yes.
The description of the property covers the entire property.
Yes, but who is transferring? This some Bijoy Banerjee, some Banerjees. They trace out their title from Motibala, and he couldn't show how Motibala became the owner of the property.
You have shown nothing.
I have traced out from
Gopeshwar's title deed you have not produced.
But Gopeshwar and Kopileshwar.
You have not produced any title deeds. You just say by inheritance you claim.
Gopeshwar and Kopileshwar is undisputed in their affidavit itself. I'll show. It's at page number 119. They claim that Motibala someday purchased or somehow obtained it from Kopileshwar. It's at page number 119. It's an admission.
Very well. We'll set aside the order of the tribunal. We'll remand it to the appellate authority to consider all your whatever deeds you have produced and then to come to a reasoned conclusion. Everything will be considered. We cannot convert ourselves to a fact-finding forum.
26 that has been interchanged.
On affidavit, he
Total
says,
here.
on
shall be
affidavit, he says.
indicated in the name of the
হ্যাঁ অ্যাপেলেট অথরিটি সমস্ত ডকুমেন্ট কনসিডার করে করবে। এটা এইভাবে
total
দুজনেই তো
here.
একটা জুয়া খেলার মতো করেছে, যেহেতু ওর নাম এজমালি আছে ধরে নিল যে 50%।
Gopeshwar and Kopileshwar, if it is Ejmali property lordship, then one property of plot number 26 that was recorded in the name of Gopeshwar, not Kopileshwar.
He says Ejmali and transfers the entire share.
That has been interchanged lordship. That may be the interchange. Because the 26 is 38.
maybe means may not be.
Now that is the interchange of it between the Gopeshwar and Kopileshwar.
Moment you say maybe,
38 is
there's a
recorded-
50% chance of it
I'm
being
reminded of my
No, 38 decimal recorded in the name of the Gopeshwar and 39 which you.
The brief backdrop of the present challenge is as follows. Full stop. Next para. One Gopeshwar and Kopileshwar apostrophe names were recorded as joint owners of the disputed plot in the CS records of rights. Full stop. The present writ petitioners claim through two sons of Gopeshwar, namely Bisheshwar and three sons of Gopeshwar, namely Bisheshwar, Onadinath, and Dukhaharan, Dukhaharan, whereas Kashinath apparently left no heirs. Full stop. Next para. As per the writ petitioner's case, the writ petitioners inherited the property of Gopeshwar through their respective fathers. Full stop. Next para. On the other hand, it transpires that in the RS records of rights, at least since the year 1959, the name of one Pashanbala, which initially appeared in the records of rights, was scored through, and the name of one Motibala introduced as double inverted মধ্যে Ejmali. Full stop. The writ petitioners have not challenged the said recording prior to the purchase of the property by the present private respondents. Full stop. The cause of action for the writ petitioners approaching the concerned BL and LRO for correction of the records of rights was the mutation of the property and consequential alteration in the records of rights exclusively in the name of the private respondents. Full stop. Next para. Learned counsel for the petitioners contends that since the name of the predecessors in interest of the present writ petitioners all along appeared throughout the CS records and the RS records, and Motibala's name was merely recorded with the rider double inverted Ejmali, there was no occasion for the concerned BL and LRO to alter the records of LR records of rights, thereby introducing the name of the private respondents instead of the writ petitioners or their predecessors. Full stop. Next para. When the writ petitioners approached the concerned BL and LRO for further rectification of the records of rights by altering the name of the private respondents and substituting in place the names of the writ petitioners by reverting the position back to as it was prior to the purported purchase by the private respondents, the same was refused by the BL and LRO, prompting the writ petitioners to prefer a challenge before the appellate authority. Full stop. The appellate authority, on the basis of the recording in the RS records to the effect that Motibala was recorded as Ejmali, whereas the predecessors in interest of the writ petitioners' names were also recorded, directed that the names in the records of rights be altered to the tune of 50% in the name of the writ petitioners and the rest 50% in the name of the private respondents. Full stop. Next para. The being thus aggrieved, the present private respondents preferred a challenge before the tribunal. Full stop. The learned tribunal, comma, by the impugned order, comma, set aside the order of the appellate authority on the grounds as set out in the impugned judgment, comma, pursuant to which, comma, it is alleged, comma, the private respondents have approached the concerned BL and LRO for reverting the records back to the original position in their name. Full stop. Next para. Learned counsel for the writ petitioners argues that while the learned tribunal came to categorical findings that the parties were unable to produce any deed to show that Motiwala purchased the portion of Gopeshwar Patitundi or purchased the share of Pasanbala, comma, the recording in the name of the private respondents, comma, as the purchasers from Motiwala was erroneous, comma, the appellate authority, comma, instead of directing the BL and LRO to rectify the records of rights and directing the entire property to be recorded in the name of the writ petitioners, comma, merely set aside the order of the appellate authority, comma, thereby in effect restoring the order of rejection by the BL and LRO, comma, the net effect of which would be that the recording in the name of the private respondents exclusively would be restored. Full stop. It is argued that the component of 50% of the property, comma, which was directed to be recorded by the appellate authority in the name of the writ petitioners was not entered into by the tribunal at all. Full stop. The learned tribunal, comma, without coming to any adverse finding or setting aside the direction to record 50% of the property in the name of the writ petitioners, comma, in effect set aside such portion of the appellate authority's order as well. Full stop. Next para. Learned counsel appearing for the private respondent submits that a purchase deed in favor of the private respondents was produced before the authorities. Full stop. It is further argued that although the name of Motiwala appeared in the RS records in place of Pasanbala, within bracket, with the recording double inverted Ejmali, bracket closed, at least since 1959, comma, which was never challenged throughout this period by the appellate by the present writ petitioners prior to the purchase by the private respondents, comma, the said challenge ought to have been turned down by the learned tribunal. Full stop. By the learned appellate authority. Full stop. As such, comma, it is submitted that the order of the tribunal, comma, to the tune that it has set aside the order of the appellate authority and restored the position as it was when the name of the private respondents was recorded as the exclusive owner, comma, was justified. Full stop. Heard learned counsel for the parties, including the state. Full stop. We find prima facie, ex facie, that the finding of the learned tribunal that the appellate authority invoked the jurisdiction of the civil court is incorrect, comma, since the limited scope of adjudication of the appellate authority was coextensive with that of the BL and LRO, comma, who under section 51 of the West Bengal Land Reforms Act 1955, comma, has the power to record or to correct or rectify the records of rights if there are erroneous entries. Full stop. For such limited purpose, comma, the BLNLRO and by necessary implication, comma, the appellate authority, comma, are entitled to assess the prima facie evidentiary value of documents produced by both parties, comma, now all the concerned parties having interest, comma, which documents might provide the foundational basis justifying the correction of the records of rights or otherwise. Full stop. Hence, comma, such an exercise by either the BL and LRO or the appellate authority would not tantamount to exercising the jurisdiction of the civil court, comma, since such exercise is confined to the correction of records of rights and not to conclusive declaration of title of the parties, which is within the domain of the civil court. Full stop. Next para, in any event, comma, since the writ petitioners have already filed a civil suit claiming declaration of their title in the property, comma, it would be within the domain of the civil court all the more to decide such issue. For the next para, the other ground cited by the learned tribunal to the effect that under section 54, comma, the appellate authority cannot correct the RSROR is also erroneous, comma, since it is the order of the BL and LRO, comma, the first forum which definitely has the power to correct the RSROR, comma, whose order the appellate authority is sitting in challenge over under section 54 of the 1955 Act. Full stop. Hence, comma, the powers which could be exercised by the first forum, that is the BL and LRO, could very well be exercised by the appellate authority instead of unnecessarily remanding the matter back to the BL and LRO. Full stop. Next para. The problem, comma, however, comma, with the impugned judgment is that while conclusively holding that the private respondents could not produce any document of purchase by Motibala regarding any portion of Gopeshwar or Pasanbala, comma, the admitted co-owners, original co-owners of the two of the original co-owners of the property, comma, comma, without considering the sanctity of the title stroke rights claimed by the writ petitioners with regard to the property in question, comma, the entire order of the appellate authority was set aside by the tribunal, comma, thereby in effect cancelling the 50% recording in the name of the writ petitioners which had been directed by the appellate authority without any adverse inference being drawn against the writ petitioners and or the portion of the appellate authority's order granting such 50% recording in the name of the writ petitioners being set aside or reversed in any manner. Full stop. Such approach on the part of the learned tribunal was dehors the law and as such cannot be sustained. Full stop. Next para. The question which is now posed before us is whether to remand the matter whether to remand the matter to the tribunal, comma, the appellate authority or the BL and LRO for a comprehensive adjudication of the issue. Full stop. Next para. The BL and LRO, comma, we find, comma, merely on the premise that the appropriate remedy would be before a civil court, comma, turned down the entire prayer for correction of records of rights made by the writ petitioners, comma, thereby shirking the authority vested in it by law. Full stop. Next para. However, comma, sending the matter back to the BL and LRO at this stage, at this belated stage, would unnecessarily protract the litigation much longer than would inure to the benefit of either of the parties. Full stop. Rather, comma, the DL and LRO, comma, which was in season of the dispute and adjudicated the matter, comma, would be the appropriate authority which should re-adjudicate the matter upon adverting to all documents produced by the parties and taking into consideration the arguments of the private respondents to the effect that the recording of the property in the name of Motibala as Ejmali, comma, along with the predecessors in interest of the writ petitioners having not been challenged for so long ought to be taken into account. Full stop. Next para. Also, comma, the learned appellate authority ought to consider the arguments of the writ petitioners made before us to the effect that although the name of Motibala was recorded as Ejmali, comma, the names of the predecessors in interest of the writ petitioners were also recorded in respect of the self-same property without the qualification within double inverted HON'BLE being there in their respect. Push up next para. In such view of the matter, comma, WP LRT 156 of 2025 is disposed of on contest, comma, thereby setting aside the impugned order of the setting aside the impugned judgment of the tribunal dated June 13, 2025, comma, passed by the third bench, West Bengal Land Reforms and Tenancy Tribunal in OA number 2270 stroke 2018 within bracket LRTT, and remanding the matter to the appellate authority, that is the SDL and LRO, comma, Asansol, for a re-adjudication of the entire dispute between the parties by taking into consideration all documents filed by the parties as well as all arguments advanced by the parties at length, and by upon consideration of the contentions of the parties regarding the nature of the recordings as HON'BLE in the name of Motibala and without such qualification in the name of the predecessors in interest of the writ petitioners. Full. While doing so, comma, the appellate authority shall also take note of the absence of any challenge for a prolonged period to such recording by either of the parties. Full. The appellate authority shall also grant opportunity to the parties to produce documents in support of the foundational facts justifying the recordings in the name of Motibala and the predecessors in interest of the writ petitioners during such hearing. Full stop. The appellate authority shall, comma, accordingly, comma, dispose of the matter afresh in the light of the above observations upon giving ample opportunity of hearing and production of additional documents, comma, if any, to both the all the interested parties as expeditiously as possible, comma, positively by February 28, 2026. Full stop. There will be no arrest to cost.
The affidavit of
প্রথমে affidavit of service file today be kept. Thank you. Pass over.
Pass over item number 2.
I beg to represent the Millard petitioner, Millard.
Yes, Mr. Chatterjee.
Like here, Millard.
Oh, you're for the response.
Millard, the orders under challenge.
For a change, for a change. Mr. Galib said that actually.
Yes, Lordship. Millard, orders under challenge, if your Lordship, Millard, are the orders passed, Millard, in a contempt proceeding before the learned tribunal. I shall try to, Millard, impress upon your Lordships that there is an attempt on the part of the learned tribunal to travel, Millard, beyond the order under contempt. Before that, Millard, may I
What are you trying to do, Mr. Mushi?
No, I was trying to find out the brief.
Bad location to search for that.
So, Millard, before taking your Lordships, Millard, to the order under contempt, Millard, may I just, Millard, give a bird's eye view of the matter. Millard, the Shingho rise, here the Chondi Charan Shingho Rai. Shingho rise by the intermediaries.
Must be Mr. Chatterjee's client.
Lordship. Yes.
Appears from the name, yes.
So, Millard, Section 4 Estate Acquisition Act notification was there. The land vested on and from 15th April 1956. Notification under Section 4 was there. Thereafter starts, Millard, in the year 1958.
Yes, sir. Oh, is it a question? Yes.
In the year 1950, the Shingho Rise, Millard, they filed, Millard, a partition suit amongst themselves.
1958.
1958. Thereafter comes, Millard, another number of suits by different members of the Shingho Rise families. Multiple suits.
Regarding that property only,
Yes.
regarding which Section
Yes.
4 was
in the year 1968, challenging the vesting process.
68, not 58.
First come 58, partition suit amongst the members of
Shingho
the
Rise.
Shingho Rise. Thereafter comes different suits filed by the members of the Shingho Rise in the year 1968.
For what? Between themselves?
Challenging the vesting proceeding.
Right.
There was win or loss. They lost the suits. In some of the matters, the state won the cases. So they were appeals preferred.
Some of the matters they lost, and in the others the state
Yes, I
won.
find some of the appeals made. Yes, Lordship.
No. None of the suits were decreed in their favor.
They lost.
All. So vesting
Some
retained.
lost, some won. Thereafter
Some
comes,
one means vesting was at the same time retained and not retained.
yes, some Lordship. Lordship, well, thereafter comes appeal in the year 1972. Some appeals were the state.
But they lost refiled, and
Some appeals by
that
the
much we can.
Lordship. Now, based on the decree of the appellate court, in the year 1992, one of the members of the Singhorais, that is the mother of the instant petitioner private respondent, she approaches Honorable High Court.
Against what?
Wanted correction of record of rights in terms of decree passed in appellate by the
appellate court decided all the matters in favor of them.
Not all, some in their favor, some against the state. So there were two set of appeal, one set of appeal by the state, another set of appeal by the members.
Some they one means the same vesting is challenged.
Regarding their
Section
portion,
4 notice was
respective shares, they filed their different suits.
But Section 4 notice was not challenged. The proceeding was not challenged. It is one composite proceeding.
One composite proceeding, but since they are claiming to be governed by the Mitakshara law, so individual shareholders, they were claiming to be individual intermediaries, which they cannot.
How can individual vesting be segregated like that?
They were, Miller, claiming to be. No, it can't be. It can never be. And Miller, so far as the Mitakshara law is concerned, there are pronounced.
Very well. She filed an appeal before this?
No, she preferred a writ application before this Honorable Court.
Implementation of appeal courts.
Correction of record of rights in terms of the decree
of the appellate
passed in her favor. Asha Lata Singho Rai was the writ petitioner. One writ petitioner. She was a decree holder in respect of her share. So she wanted correction of record of rights in terms of the decree passed in her favor.
That was filed in 1992.
1992.
No, the writ petition was filed in 92.
1990.
Yes. Then.
Now, my lord, in the writ petition, there was some direction given that yes, if you prefer an application within 6 weeks, then it will be considered. If not, it will not be considered. This was the condition. That application was never preferred. Thereafter comes in the year 2013, one original application before the learned tribunal.
By?
Not by Ashalata Singho Rai, but by the present private respondent, Chondi Charan Singho Rai.
Who are they? They were parties to these.
They were, yes, in some of the suits they were parties, and my lord, they belong
to they won their appeals.
No, that they are silent. No.
What do they want in the way?
In a way, they said the 1992 Honorable High Court has passed on order that remains non-compliant till date. We want compliance of this particular order. RO has not disposed of the application. We want correction of record of rights.
There was no application, you say?
There was no. But Asha, Lordship, kindly see the say. Asha,
what application do they want disposal of? There was no application filed by Asha Lata.
They were claiming that the application was in fact made.
All right.
Now, my lord, in that particular way of 2013, an order was passed directing the BLLRO, yes, you consider to comply with the judgment of the Honorable High Court. Nothing else. Proceeding was initiated. BLLRO passed order holding that although Asha Lata was given the liberty to prefer an application, but you, Singho, this Chondi Charan Singho Rai, you have come before me. You have failed to show the application which was preferred by Asha Lata Singho Rai. Thereafter, the BLRO dealt with the point of law with regard to Section Estate Acquisition Act, avowed object. It can't be divested. Civil court's order is a nullity because in the year 1968, there was Section 46, not 57B. Section 46 is the earlier avatar of Section 57B. 57B came in the year 1973. So when 1968, the first suit was filed, Section 46 was in play. So their prayer for correction of record of right was rejected. Preferred appeal before the 54 authority. 54 authority upheld the observation of the BLRO. Agreed by these two orders, they come before the Milord Tribunal. In the year 2019.
20?
Lordship.
Which year?
Sir, 2019.
2019.
Now, Milord, may I respectfully invite your Lordship to Milord, page 78. This is the background, the bird's eye view. May I respectfully invite your Lordship, Milord, to Milord, page 78.
Yes.
This is the order. So, that order. So 1980, this 2019 was the original application preferred, and they alleging non-compliance of the order passed in that particular order, they preferred one contempt application. In the contempt application, this particular order
Contempt of which order?
Contempt of the order passed in OA number 1980 of 2019.
What was the order?
Page. No, this is the order under contempt.
No, you said that the
Yeah,
way was preferred
yes,
against
this
section.
this was the order passed.
No, you said the way was preferred against section 54 upholding the BLRO.
Yes, so this order was passed. This order dated 28 September 2022. At page
This
below
finally disposed of the LRT way.
Yes. This is the order under contempt. So this is the order passed.
All right, let us see this.
Kindly cease, Milord, may I place this order?
But you are not challenging this order.
No, I am challenging what
Order
has been
passed
passed
in the contempt.
subsequently in the contempt act.
So you say there was no contempt.
Yes, I said I have complied with this order. There should not be any contempt. Then also, Milord, another tribunal is trying to hauling me up. No, this is not compliance in letter and spirit. I want further compliance, and next date, Milord, some fixed in the month of July. Lordship, may I read out this particular order?
Yes.
Acceptability of the judgment and decree of civil court declaring title of the applicant over the case land in light of the provisional section 57V of Civil, as well as existence of the direction of the Honorable High Court, Calcutta, to correct the record of rights in terms of judgment and decree of the civil court, has become subject of challenge between the parties in this way. The backdrop of the way in a nutshell. All right. May I invite your Lordship, Milord, to the relevant part, Milord, page 81. Paragraph 9, Milord. The sentence, Milord, starts with, Milord, in view of the above grounds. Both the impugned judgment passed by the ADM ADLRO dated 28 June 2019, passed in appeal case number 65/2018, as well as the order dated 8 January 2018, passed by the BLLRO Kalna 1 in connection with this case number 11 or 20, are not sustainable in law. Accordingly, both the said impugned orders are set aside. The BLRO Kalna is hereby directed to consider the representation of the applicant received by you on 24 June 2013 afresh, and to dispose of the same, the observation made by the Honorable High Court, Calcutta, V-Day 10th October 92, in CO number so and so within a period of 4 months from the date of communication of this order. However, the representation of the client, appellant, received by the BLRO Kalna on 24 June 2013, and its content could not be gone through by us, as the same was not produced before us along with the OA, so the same may be verified with regard to the suit plots, which are to be recorded in favor of the applicant in compliance of the order dated 10th August 1992 of the Honorable High Court, Calcutta, in CO number so and so. With regard to correction of the suit land, as it arises out of the relevant civil court order affirmed by the Honorable High Court of Calcutta in the stated order in CO number 1992, it further be meticulously verified whether the same correction of records belonging to the appellant can be made in accordance with law and relevant rules existing.
Mr. Galib, this has to be read in the light of paragraph 6 to 8. Because paragraph 6, it says interim order was passed regarding possession. And the High Court order is interpreted by the tribunal to say that that would not be given effect to if they don't make the application within time. But nowhere was it mentioned that the order would not be given to the
Now,
main
may I
order.
take your lordship to the Honorable High Court's order?
This order, my lord, is
Page
not-
22.
Yes, the respondent applicant authorities failed to appreciate the mandatory part of the direction.
Oh, lordship.
In this light, because the order is in the light of the, in terms of the observation made by the Honorable High Court.
Lordship. And Miller kindly sees Miller.
That has been quoted here. You say there may be some difference.
And I am showing you lordship. Let us go to a text.
This judgment is not on the chart.
No, but still, the interpretation is.
Interpretation also.
So, Milord, I am Milord, may I, Milord?
In contempt, they are saying that let us see the.
In 80, no, last paragraph with regard to the correctional suit land as it
Where,
arises.
which page?
No, the same page 82.
82.
Now, the learned tribunal is telling at the same time, the same breath,
In
that you
accordance
got to
with law.
meticulously verify whether the same correction of record belonging to the applicant can be made in accordance with law and relevant rules existing.
Yes, because the High Court in the first place directed the correction of records of rights.
Milord, page 22.
Let us see that. Yes.
Lordships.
That would be necessary. You are
Lordships.
You are right.
Lordships. This is by Ashalata Shingorai, as I told you, Lordships, at the very outset.
Yes.
And the ordering portion starts from page 24. The state respondent concerned is directed to correct the relevant records of right in terms of the judgment decree and order as mentioned in the writ application within 3 months from the date of filing the application, which is to be made by the petitioner within 3 weeks.
This is the entire order.
This is the entire order. This is the entire order. Within 3 weeks from date. In such application, the petitioner is to annex the copies of the said judgment, decree or order, and such application is to be made by registered post with AD. Till such correction is made, the respondents are restrained from taking possession of and or interfering in any way with the petitioner's possession in the disputed lands.
Let us see as it is. Yes. Yes, please carry on.
কোথায় ordering portion? এটা the High Court order. I am reading out. The cost
None
title,
for the state after that. This is it.
the cost title starts from page
Must be-
22.
Let us see the date.
The cost title starts from page 22, Lordship.
August is much prior to Puja.
10th August 1992. And the entire cost title kindly sees as we used to write
Yes,
earlier in the matter of, in the matter of, in the matter of. Then comes page 23, last 3 lines from bottom, Ashalata Shingo Rai. Petitioner
So the
and
timeline was given for the correction, but
such
the-
application, the petitioner is to annex the copies of the what are he is to do. These were the directions, my lord. That judgment decree order and such application to be made by registered post with
this
AD.
judgment decree and order is the order judgments passed in the appeals.
Lordship. Till such correction is made, the respondents are restrained from taking possession of and interfering in any way with the petitioner's
So
possession.
the
in
tribunal
disputed
says in terms of this, what remains for adjudication by you? Can you even after that say no? It cannot be.
land. Meticulously to be gone through in accordance with law.
But in terms of the
As
order,
because my lordship knows, my lord, 46 earlier Avatara 57B.
in terms of the
Analytic-
order of the judgments produced, if the direction of the tribunal is in the same breath in terms of that direction, you have to meticulously consider in accordance with law. Now then, after that, can you resile from that position and say, no, that order is bad, void, null and void?
Certainly not, my lord. I
And it's
can't,
in
my lord.
terms of that.
But my lord, here, my lord.
What have you done here? Exactly.
No, I have
What is the contumacious act alleged?
now my lord, compliance done. According to us, our understanding, that is compliance, page 92. Page 92. Milos, 1 minute. 13 November 2024, the order number 7, Lordship. Page 92, order number 7, dated 13 November 2024. The case is taken up for hearing today, Sri so-and-so, father so-and-so are present. No receipt copy of representation file dated so-and-so produced today also. Prior to this, my lord, may I take your lordship to order number 2, my lord?
Please notice served with register.
Yes, notice served. So here starts from page 90. So compliance, the case is taken for hearing so-and-so. No receipt copy of the representation file dated 24 June 2013 produced today also. Lordship kindly recalls that the learned tribunal was asking to produce this particular representation which is to be considered. See, it was not produced before the learned tribunal. It was supposed to be produced before the
Meticulously.
No.
Meticulously to be looked into.
No, and this representation also was not placed even before the authority also. Neither before the tribunal. After thorough perusal, my lord, of the order dated so and so, consider the representation of the applicant received by the office on 24 June and to dispose of the same, he is quoting the tribunal's order. Now, my lord, next page, page 93. Now, as per the solemn order dated 20th September 2022, passed by the Honorable Tribunal, the undersigned has been assigned twofold task. Scrutiny of the representation dated 24 June 2013.
1, 2 misses out the vital portion that in terms of the order of the judgments of the civil court. 1 and 2 record scrutiny of the representation, which is quite correct. Correction of the ROR as per the existing rules and acts only. But what about the in terms of the High Court's order? That third component has been missed out here entirely.
Lordship, kindly seize, my lord. Kindly seize, my lord,
this
with deepest of respect, with humility, my lord. Again,
who are you abusing now? Deepest of respect to whom? The tribunal or us?
Lordship, my lord, may I, my lord, travel your lordship, my lord, to page 82 once, my lord. Kindly seize, my lord. The learned tribunal, my lord, has made the window a little wider, my lord, in my understanding, lordship.
Okay, let us see what you have done first.
So what he has done, my lord, so he is 93. I was reading out, my lord, with respect to the scrutiny of representation dated 24 June 2010, he says, what does he say? Kindly see, my lord. After thorough search of records and relevant documents, undersigned could not find any such representation at present. The instant applicant was asked to produce the copy of the representation repeatedly, but the applicant failed to produce any such scrap of paper. Hence, at this juncture at the time, the undersigned is unable to verify the same. Next, as per the solemn order, the undersigned is to traverse through the relevant statutes with respect to the statutory provisions of following arguments and facts need to be discussed. Now, as per the petition on the basis of judgment of title suit, title in High Court case paid to correct the record of rights in his favor. Hence, in this juncture, it would be pertinent to discuss the order of the learned district court passed in TA case number in respect of observation of the Supreme Court in connection with vesting and retention of land by the intermediary. The avowed object, now he is quoting the avowed of object of West Bengal Estate Acquisition Act. He is quoting EIR 1990 SC Supreme
Is that VLN? It's a splendid order, actually. Yes.
He is a BLLR. Lordship.
Yes, our BLLR has DLLR has. So we'll come back at 2 and continue. No further. You have exhausted your remedies regarding grant of adjournment. No. Whatever, wherever. We will continue.
It will take some time and come by.
But allow me to complete Ajkar Vishiva. I will complete. Let him come and respond, my lordship.
No, he'll come and respond today itself. You want nobody to decide that. You will complete as fast as possible after the recess.
I'll complete.
We'll ensure that. So that Mr. Chatterjee does not get an opportunity, Mr. Munshi has to be there. Yes.
My Lordship, I was in the midst of that compliance, my lord,
Yes.
page 92, my lord.
Right. What have you held ultimately?
So Lordship, so I was reading, my lord, at page 93, the two issues were, my lord, according to his understanding, he has held that these were the two directions by the tribunal at page 93. And then with regard to the representation part, he says that the petitioner fails to produce a copy of the same, hence I am unable to go through that, verify it. Next, he goes on to the question of, my lord, vesting. Now, while dwelling on the issues of vesting, kindly see me, his observation starts from page 94 onwards. My lord, he says WBA Act, once it is done, it is free from all encumbrances. He cites several cited. Lordships knows all these judgment, my lord. He says, my lord, kindly sees, my lord, page 94, my lord. Last but one penultimate paragraph, the sentence starts with here these degrees. Here these degrees of learned civil court clearly infringe the specific jurisdiction of 4 and 5, failed to consider the vesting was complete as on 15th April 1955, and where the pre-existing right at interest of bequest was vested to the state, and the retention of khas possession of different category land depends exclusively on the allowance of arrow. To jeopardize the vesting procedures, Singho Roy is moved before civil court and filed title suit praying for division of Ejmali properties by meets and bounds, but revenue officer vested the selling surplus land of Singho Roy's by declaring Nagendra Gopal as Korta of the joint and even a Mitakshara family partition cannot be legal if it is made instrument to hold selling surplus land. Honorable High Court, he has cited authorities on this. There are two judgments of this honorable of our coordinated bench judgment, Lordship. Then, my lord, he says he deals with kindly sees page 95, first, second, third, fourth paragraph. But these degrees were passed by the civil court is with total disrespect of section 46. That is earlier avatar of 57B. He says second amendment and which is omitted by so and so, which is in total statutory jurisdiction of the revenue officer. Learned civil judge has done this in spite of the bar of section 56. Then later on he deals with letter section 57B. He deals with. So, my lord, the sum and substance, my lord, he says, my lord, if I may, my lord, respectfully take your lordships, my lord. So, my lord, page 96, penultimate 96, penultimate paragraph, section 57B2, ousted the jurisdiction of civil court, and remedial section 57B3, 57B4 have been inserted. Then he deals with section 9 of CPC also. And, my lord, kindly page 97. 97, Lordship. Lack of jurisdiction of civil court in the matter of vesting and retention under provision of so and so has been upheld recently by 3 judges. He deals with Pramila Shapui also. Decree is in defect and void decree. Dwarka Agarwal and the Honorable Supreme Officer, that is Kiran Singh. Last day I cited, my lord, Kiran Singh, my lord. Inherent lack. And 98, my lord, kindly sees. He deals with the High Court order portion also. That application has to be made within 3 weeks. Kindly sees, my lord, the page 98, second paragraph. The application article 220 of the Constitution of India, CO number so and so, the Honorable Justice N.K. Mitra was pleased to direct the state respond to correct the legitimate ROR in terms of judgment decree order as mentioned in the petition within 3 months of date of application. Filing the application by the petitioner in that solemn order, petitioners were asked to make application within 3 weeks. Date of with annexed copies of judgment decree, it was clearly depicted in that order. If, however, that application not made within the apposite period, the interim order shall not be. Under the circumstances, on asking petitioner, failed to exhibit any registration acknowledgement showing submission of application, because, my lord, he was supposed to shut off the application by registered post with AD. He did not, hence undersigned does consider that the interim order passed by has not attained its effect. Thus, the undersigned is not in a position to correct the record of rights under 4 corners statute as well as conditions. My lord, this is a.
Have you annexed a copy of the appellate court decree by any chance or order?
Appellate court,
which was directed
my lord,
in terms of
it is
that.
not annexed to our petition.
Have you got a copy? Yes, let us see that once.
But I have got the entire bunch of the notified copies.
The appellate court reverts the trial court's finding or reverse? So let us, it will contain the comprehensive decree then. If it reverts, it will pass the decree.
Many suits were filed.
Show us the best in your favor.
in attainment.
This is the appellate court's decree, judgment and
New call of action.
Sorry, my lord, I had only one copy.
এই কপিটা দিতে না এই কপিটা দে আমার কাছে নেই তো
প্রবলেমটা লুকিয়েছে ইন্টারেস্ট অর্ডার কমপ্লিট জাজমেন্ট ব্ল্যাঙ্কেট করে দেয় Mr. Munshi, this is the entire judgment of Justice Mitro, the writ court. There is no reason, I mean, in terms of the judgment, there is no adjudication, not the appeal court. The writ court's order, previous Justice Mitro's order, page 24.
Yes, my lord, 22. But
24.
They have not any challenge against that.
No, understood, but
Yes, my lord.
there is no adjudication on whether the decree, judgment and decree was valid or something.
Was passed in terms of the title.
No, they take the tribunal takes the authority takes a question of nullity. In case of nullity, no appeal is inherent lack of jurisdiction due to section 46. So that is one point we will hear you on, but even then, it's a question of nullity then. Did not have inherent lack of jurisdiction pertains to the existence of the decree. No appeal is required.
For that, my lord, they need to challenge this order. They did not throw any
Nullity
challenge.
can be ignored any time, but Justice Mitro's order stands in the way.
Yes, my lord.
The writ court's order stands in terms of the.
Exactly, my lord. That is
Yes,
what
you
I-
are right. This order was not challenged. You're right.
This order was
Yes.
never challenged. And my lord, if my lord kindly comes to.
But then the tribunal is in contempt, not the officer, the BLLR.
After.
Because the tribunal directed, apart from in terms of the decree, also specifically that it further be meticulously further means after in terms of the civil court.
Page 82, a lordship is standing.
82. It further be meticulously verified whether the same correction of records of rights belonging to the can be made in accordance with law and relevant rules existing. So that was the additional rider added by the tribunal. So if somebody is in contempt, it's a tribunal which is in contempt. The tribunal directs beyond the direction of the writ court.
But my lord, there is also a rider, my lord, page 82, second paragraph. With regard to the High Court's order.
That is what we are saying. That is what we are saying.
Yes,
That after saying that with regard to correction as it arises out of the relevant order affirmed by the Honorable Court, after that it is stated, it further means additionally, be meticulously done and these things in accordance with law. So what is the wrong committed? The act done by the BLLR was in consonance with the tribunal's order.
But since
Further.
then they have not challenged the order, there was second round of.
We have also not challenged the order of the tribunal because the tribunal's order is the order which directs the BLLR to go into both considerations.
If I may appraise your lordship, my learned senior friend finishes, then I would appraise your lordship of some more facts.
So he has finished. What remains?
What remains? No, so lordship, this, my lord, so this is the compliance I have shown to your lordship,
sure.
my lord. So, my lord, my respectful submission, this aspect of the matter would be, my lord. My lord, there was a, my lord, direction for considering accordance with law meticulously, my lord.
Yes, we've seen it.
My lord, my
components
respectful
were-
submission would be good, bad, indifferent, legal, illegal, whatever, my lord. My respectful submission, my lord, he has, my lord, passed an order. So, my lord, if any person is agreed with that order, my lord,
Not a good defense always in contempt. If it is in the teeth of specifically
May
in the
I
teeth of some
pose-
order.
may I pose me this question to myself, my lord? It's a new cause of action if any person agreed with it.
Both remedies may lie. Both remedies may lie if it's a palpable contempt, especially if I direct you to decide in a particular way without any rider, and then you decide the other way, it can be contempt. But here you have a better case
Lordship,
because
window
because of the
is
tribunal's
wider.
ramification of
Yes,
this
wider.
tribunal's direction.
And secondly, my lord,
That is what we are asking, that whether the
Lordships-
tribunal could have been said to be.
and lordship had taken note also of this point The BLRO says that you were supposed to make an application within 3 weeks in compliance with the Honorable High Court's order of 1992. You
So
did
that
not do it.
takes away the effect of the interim order as considered rightly by the tribunal also. That takes away the effect of the restraint order regarding possession.
Main direction does not go. Lordship. So Miller, now Miller, so Miller, this is the
That the
compliance
tribunal
done.
has even held. The tribunal also holds so.
Lordship. Now, my lord, these two orders under challenge, if your lordship may respectfully place, my lord. Lordships, but they say have already gone through this. After 108, after page 108,
Yes.
kindly leave me lord one page in between. Thereafter will the impugn lordship. 20th June 2025. What is lordship?
Yes.
After 108, leave one page in between lordship thereafter. So he, my lord, the learned tribunal says, I should not go into the fact of this case. State stand. Now he says, my lord, kindly cease, my lord, if I may respectfully invite
30th of June.
20th of June.
Not 30th of June.
That is second one.
After page 108, it starts with 30th of June. What are you saying?
Hey. No, skip that, lordship. I said skip that page, then comes lordship. Kindly skip that page, then comes, yes, 20th June.
Yes.
This is the impugn lordship. Kindly seize me what does the learned tribunal. This is the order, my lord. I have come before lordship to place under judicial scanner of your lordships. My lord, kindly seize me lord, page 3 lordship straight away. Internal page 3, my lord.
Yes.
At the top, the sentence that this bench in its order dated 20th September 20, that is the order under contempt, directed the concerned BLRO to consider the representation of the applicant received by him on 24 June and to dispose of the same according to the observation of the Honorable High Court. My lord, may I pose it? Was this the only direction, my lord? May I pose this question to myself? Kindly see page 82, my lord. Juxtapose. Now, my lord, now we go through the order of the Honorable High Court and he goes on. Now, so this order has two parts. Very good, lordship. Now we go through the order 7. That is the compliance, which I showed you, lordship. In this order sheet, it is written that these decrees are passed by in total districts 46. He deals with. Then, my lord, kindly see he quotes, my lord, all the judgments which the BLRO said, and finally comes, my lord, kindly comes to, my lord, page, my lord, 5, internal page 5, the concluding part. Second paragraph, my lord, some running page to they were certified copy. Second, but instead, the sentence starts with instead. PLRO only criticized the order of the civil court in this entire order sheet by stating intelligence so and so. And he said, we have already discussed that according to observation of Honorable Apex Court, the right or wrong, the order has to be obeyed and cannot traverse beyond the order, cannot test correctness of the order. And my lord, he says, my lord, you do again direct to file show cause. And my lord, the second order, my lord, this, my lord, kindly skip the next page, next to next page, 11th July, last page, my lord, before the back sheet. This is the second. You come prepared with the compliance report, and this is what he asked me. So, my lord, lordships, my lord.
Difficulty is the tribunal order says writ court order is very clear. No qualification to that in terms of the order of the High Court.
Lordship.
If you don't file it within 3 months, effect of the interim order will not be given. Will go.
Lordship.
But the order remains, direction remains.
Lordship.
But here the tribunal says with page 82, with regard to the correction of the land as it arises out of the relevant civil court order affirmed by the Honorable High Court, such and such, it further be meticulously.
This is the part.
No, this is the other part. First, page 81 is hereby directed to consider the representation of the applicant afresh and to dispose of the same in terms of the observation made by the Honorable High Court, Calcutta, which in turn says it has to be in terms of the appellate court's degree. That order. Now, that rider is at the qualifier is page 82. It further be meticulously verified whether the same correction of records belonging to the appellant can be made in accordance with law and relevant rules existing.
The prefix further.
That can be interpreted harmoniously as in terms of the decree, because the decree declares the title. They has to, if there is any other infirmity in terms of the rules, because there may be other nitty-gritties also, suppose the application is not in form or otherwise something, that it should be read harmoniously with the previous portion. It has to be in terms of the appellate court's degree.
Lord,
that basis itself could not be, was not given,
cannot be disturbed.
Cannot be opened. reopen.
My lord, may I, my lord,
In
respectfully-
terms of that, and in accordance with law, further in accordance with law and relevant rules, that means obviously the procedural rules and the modalities and all these things.
my lord, in accordance with law, my lord,
Otherwise, it cannot be harmoniously construed, the tribunal's direction.
but my lord,
It cannot mean to say that you can reopen that. That would be not reopening only the writ court's order, but reopening the appellate court's degree, which we have to remember also be attain finality.
no, lordship, lordship, certainly, my lord. But my lord,
You say that is a nullity. You could have said it's a nullity unless the writ court's order intervened. The writ court comes in between and says, no, it has to be done in terms of writ court does not stop at the appellate court's degree. Suppose it was a nullity. Writ court directs specifically that it has to be in terms of that degree. After the writ court order and that being unchallenged, as Mr. Mushi rightly pointed out, that remains unchallenged. We are not only on the appellate court's degree, we are proceeding on the premise that the appellate court's degree has not been challenged. If it's a nullity, might not be challenged, but he's right. Subsequently, that was affirmed by the writ court order is not challenged. Writ court says in terms of that, then nullity or not, that has to be in terms of that, in the absence of any challenge. Even the tribunal could not go beyond that, and tribunal says in terms of that. Adds further to be meticulously seen, because the representation is not before me. Look into it, whether that is in terms of the rules, the procedural rules and the modalities, obviously. There is no scope of any second interpretation. It has to be only
Lord,
interpreted
in
in one
accord-
way, harmoniously.
Lord, in accordance with law, my lord, 57B and section 46, my lord, is the law, my lord, which governs, my lord, the field lordship. If I may, my lord,
We are helpless. You did not challenge the writ court's order.
but writ court, my lord, is, yes, writ court certainly is harping upon, my lord, the decree, but decree itself is a nullity, my lord. And all the, my lord, Kiran Singh says, even it can be taken up in a collateral proceeding also, that it's a nullity.
Can be taken. But if there's
So,
a
my lord-
direction in terms of that decree, can you go beyond that?
So, my lord, my twofold respectful submission. One is, my lord, this BLLR has passed an order in compliance with the, my lord, the learned lordship.
Yes, Mr. Gal. So first point is that the decree was a nullity. Obvious point.
Lordship. Now, I should not interpret the order of the BLLRO because that is the sum and substance of his recent order.
No, you are saying that that is what has been done by him. You say if the decree is a nullity, even in terms of that, there is a direction. If there is a direction, there is scope of holding that, yes, in terms of that, I am acting, but that's a nullity. So
this is my lord, what, my lord?
And also the second portion, page 82 is very crucial.
Yes,
in your
82, and my lord, my third respectful submission, my lord, he has complied with. If I am not happy with it, my lord, I should go for agitating.
Fresh
my lord.
cause of action.
In a may I, my lord, only my lord, one judgment, my lord, if I may, lord.
Yes, yes. Why can't?
My lord, 2014, Shagorna, 2014, 3 SCC, 373, my lord, on the contempt, my lord, on the proposition of this contempt, my lord.
Yes.
If I may, my lord, respectfully invite your lordships, my lord, to my lord, paragraph 19, my lord, of the report, lordship. Paragraph 19 of the report. দিয়ে দিচ্ছি তোমাকে। ও আচ্ছা, পড়ে নাও এখানে এসো। My lord, the paragraph 19, my lord, the power vested in the as well as court to punish for contempt is a special rare power, my lord. If I may trouble your lordship, my lord, from the sentence placitum D, the sentence that the courts must not, my lord.
Yes.
Must not therefore travel beyond the four corners of the order, which is alleged to have been flouted or enter into questions that have not been dealt with or decided in the judgment or the order violation of which is alleged. Only such directions which are explicit in a judgment or order or are plainly self-evident ought to be taken into account for the purpose of consideration as to whether there has been any disobedience or willful violation of the same. Decided issues cannot be reopened.
He has not done that.
Not can the plea.
Where has the decided issue been reopened? Contempt court does not do that here. Contempt court says my order is clear. You have not complied, so I issue rule of contempt or whatever direction for contempt. It has not been reinterpreted. Court has not reinterpreted anything. The tribunal
So,
has not.
Lordship, I want, my lord, the last paragraph, para 82, my lord, he has read to it. So, my lord, this, my lord, he has done, and my lord, secondly, my
No,
lord,
this reinterpretation has to be in contempt. In contempt jurisdiction, the court, that was the original order. Page
Yes.
82 is the original order. This judgment says in the contempt jurisdiction, you cannot revisit your order.
so in the contempt jurisdiction, as I've shown you with the two orders which are under challenge,
Yes.
before Lordship, my lord,
Where is the revisiting of the original order?
no, he is not happy with the order which the bailiff has passed in compliance thereof. So he is interpreting that. It
Question
is
of
not,
happiness, unhappiness. He holds that my specific order has not been complied with. He has said that the essence of the order of this bench in the above may to dispose of according to the observation of the Honorable High Court. But instead of that, BLR only criticized the order under such and such ground.
so he holds, my lord, it is a non-compliance.
Yes. He has not reinterpreted his order. He says this was my order. He has not rectified the order or done something else.
Next order, he is asking for correction.
Yes, Mr. Galib, let us hear them.
And my lord, 57, 54.
On law, we cannot do. In contempt jurisdiction, that is what precisely cannot be done. It cannot be reinterpreted.
No, but the BLR has dealt with that issue only, but subsequent judgments have not been dealt with. So, my lord, these are my submissions, my lord.
Yes, Mr. Chatterjee, only one question to you. Otherwise, yes. Two questions rather. Page 82 dilutes page 81 in the sense that meticulously further description, in accordance with the rules and extent, law and extent rules and something. One, and secondly, if there is a scope of little bit of scope of interpretation, then we should not haul up somebody for contempt. It's not a willful and deliberate. Issued a rule, I mean, virtually issued a rule, the counterpart of a rule.
He has been asked to explain again. There's a report to be filed. It's not that he's hauled up for contempt right out. The I say, Lord, it's a little premature. Then you have to look at we are of the considered view that
But ME is allowed on contest.
the one fair chance should be given to the concerned bearer. So, since he has joined very recently, hardly 10 days back.
That is a modification of the previous one. But the first order,
Lord, he has started 11th July,
20th June also. He says 20th June has also been checked.
20th June.
20th June allows the contempt application and says contemner is hereby directed to file show cause on or before next date. But that's even
Why contempt? That's a show cause. So now it's
allowed is a misnomer, in fact.
Yes. The contemner is hereby directed to file show cause on or before the next day as to why contempt proceedings shall not be drawn up against him. It's that whether the tribunal could have done it, could have done. They can't say that this is beyond jurisdiction. It's at the show cause stage. And then he's again given a chance to the PLR to
It's premature.
very premature. Number one, the submissions made, the appeal, who filed the appeal may ask this question to your lordship. Your lordship hasn't seen that. The state filed the appeal, where the degree was granted. The appeal was of the state. Can it satisfy my
Whatever. I mean, that appellate decree we have seen. Mr. Bush has given.
Is there the High Court says it should be complied with? The tribunal says
Appellate decree per se, Mr. Chatterjee, would not have been much of a barrier if it's a nullity in the eye of law, inherent lack of jurisdiction.
it was not taken by them.
But what comes between is Justice N.K. Mitra's order.
My lord, exactly.
That has not been challenged, and you and your learned junior both point out that yes, that is very, that has not been challenged. So that says nullity or not, that has not been considered, not taken even.
Consideration at all.
Directed to in terms of that.
And then the 22 order of the tribunal, which said that please comply with that order of Justice Mitra. That has also not been challenged.
He's unhappy, not me.
No, they might have been unhappy with whatever they want, but the law doesn't change with his happiness. And once the yes, it's right actually. Once
The strategy is right. The other Mr. Chatterjee.
No. From Bardhaman is always.
No, he says if he's always right, either he's not always right or he's always right. Then no has to be right also.
Now, whether there is contempt or not, that is also to be decided. So opening up everything on a show cause order, my lord, in my respectful submission is unlawful.
Answer.
No, only one sentence.
You go and resume your other argument in the other.
With my, no, only one addition to my learned friends, my lord. No, but yes, show cause in the first order. Kindly
Second
says-
order also.
Second order kindly sees, my lord, the penultimate alleged content below is here directed to complete the compliance plan and to bring the corrected ROR in person before this bench in terms of the judgment positively honored before so and so. It's a gunpoint.
No, the ROR in person.
No ROR. You bring the corrected ROR.
ROR in person means he has to personally come and bring the ROR. So cause
Corrected ROR.
rule has been issued. It's corresponding to a rule issued in a contract.
Yes, Milo. So Milo, show cause stage has crossed. Not premature. This application not
It
prepared.
has not been committed. This is not exactly appellable in that sense because it's not a judgment. Any order is appellable, you're right, but no case has been decided in a sense. We express our dilemma in our order and send it back. We won't
Well,
interfere.
kindly take into consideration this paragraph of this penultimate paragraph of the last order, Lordship. And will consider.
ROR cannot come in person. Is the BLLRO?
No.
Who will bring the ROR in person? In person qualifies the BLLRO.
Bring the corrected ROR.
He has not been directed to bring his toothbrush. Only the ROR. Only the ROR.
Gamcha toothbrush.
Please also consider, my lord, our predicament.
What predicament?
From 92, my lord, the
Nullity and
there is no nullity.
such a beautiful order of the BLLRO, Mr. Chatterjee. We are impressed with the order.
I am sure.
If a court passed this order, we would have appreciated so much. But the BLLRO,
Beyond the High Court, it might be an inferior order, my lord, we might have.
we also appreciate the boldness of the BLLRO. And we cannot do it on paper because there is a direction of the tribunal. We'll somehow appreciate the order. We'll find out a way to do it right now. But yes, you are right on the point that it's premature.
Absolutely.
We'll make our observations and then say those will not be binding.
And then say it's not binding on the. But I would say, my lord, kindly do not make any observations for the moment.
Now, there is a dilemma as to whether there is a dilemma in interpretation of the order. It's a double dilemma.
If I can show your lordship, my lord, that there isn't any. But even then, my lord, if your lordship sees, my lord, there needs to be a quietus to a litigation. Good, bad, indifferent. You can't open. The trial court might have, the BLRO might have, my lord, written a fabulous order. I completely bow down to your lordship's observation. But by that, he can't open a litigation again.
But nullity can be taken at any stage, as he rightly pointed.
Taken that.
BLLO can even.
And you have a nullity.
Oh, nullity is. What did you say?
I'm sure.
Section 46 did not have inherent jurisdiction. Yes. Let us see that.
Page 92, page 92, it starts. He has
এই তো বলেছে 97 এ kindly sees last two line 97 এ
Yes, he said.
No, এই তো without jurisdiction hence nullity. Hence
Chaman currency has been considered. Fundamental principle without jurisdiction is a nullity.
97 এ বলে
fundamental principle,
Even the previous paragraph has been distinguished as nullity.
But that is with respect to that judgment. Look, subject
No case raised.
Honorable Supreme Court observed in currency and other.
No. Kindly see the last sentence of the first paragraph of page 97. These above said degrees are decree without jurisdiction and hence nullity. Clear finding. Fantastic order, Mr. Chatterjee. Otherwise, fantastic order. And considering that it comes from a BLLRO, hats off. You're lucky that he's arguably in contempt.
But,
Should have been made a judge.
96 quarter.
Yes.
Because jurisdiction is ousted to entertain.
Fantastic judgment, Mr. Chatterjee. We are enamored by this judgment. So, by conjoint effect of section 9 of CPC and section 57B of WB Estate Acquisition Act, Civil Court jurisdiction is ousted to entertain the TA cases. Having entertained TA cases, title appeal, learned Civil Court acted without jurisdiction. These above decrees are decree without jurisdiction and hence nullity. Wow.
The suit was in 46 is suit. In 46.
Whatever, no, these are the appeals.
Yes.
Suit was dismissed.
Partly
Partly decree, partly. So it merged in the appellate court's decree. It is the appellate court's decree which is being considered. No, Justice Mitra directs the appellate court's decree to be considered in terms of the decree of the appellate court.
No, I think there's a.
See Justice Mitra's order.
Yes, yes, but I'll show you the degree.
Judgment and degree as mentioned in the writ appeal.
Yeah.
That has been handed up to us probably.
Certified copy.
Only one copy, so that must be the copy you were searching for.
Look at what this, no. Have a look
Eight.
at page 32, 31.
The ordering portion is very clear.
What was the?
Title suits are decreed on contest, some are not.
We have a look at it.
Title declaration.
Yes.
We are seeing the decretal portion only. Yes.
Then there is no way, the civil court never had jurisdiction on that. Title declaration. He can't say that the civil courts didn't have jurisdiction. Yes.
I've got a copy of the previous section 46.
Title declaration, he can't be vesting, yes.
Maybe you have a point there.
Title declaration, he can't say. So, Lordship, they're not being enamored by the.
No, the language, the treatment, fantastic. I would love to pass such a judgment. Even if wrong. Even if wrong. Such a reasoned judgment. It's a pity that he is merely, not merely, BLRO is a responsible office, but not a civil judge. Very important, but he should have been a civil judge.
Yes, problem is he can't declare titles. He can't do that.
No, that he cannot, unfortunately.
And this was a title declaration. He can't say that these are.
But the omitted section is not given in this book. That is the difficulty.
Have the Estate Acquisition Act with me.
Oh,
but,
you're one step further.
One step further.
I have the book, but it's omitted, that's only written.
So even without that.
Yes, title declaration, right.
No, it will be a dangerous situation because this BLRO is very good, very fine.
No, not that. Mr. Chatterjee, the way he has treated it, and it may be a wrong judgment. For that, a fresh cause of action has been taken. But the question here is whether he's in contempt or not. Now, this finding, whether the tribunal is in contempt by passing this order, that, page 82, not only stopping there, but now he hauls up this poor BLLR as for contempt. He say the tribunal says, in terms of Honorable High Court, and page 82, it is categorically stated, it further be meticulously verified. In addition, whether the same correction of records belonging to the appellant can be made in accordance with law and relevant rules existing.
So that tribunal has attained finality because the tribunal said that you can't. That order is also in finality. So he has to do in terms of the tribunal's order.
But in accordance with law and the relevant rules is very wide.
The tribunal goes on to say that you will have to correct the record of rights in terms of the High Court's order. You will have to carry that out.
Where does he say it?
81.
In contempt.
No, in the main order. And then they recorded it.
There is no thereafter in the main order. That is the second last paragraph. After that, it is disclosed. In contempt, he cannot do that.
Main order. This is the main order. They have not referred any challenge against the order.
This is the order, Miller, on reviews. On review, Miller, it starts from 78.
What was the original order?
No, original order.
What review? This is the original.
This is the original.
Order. Thereafter, the review came.
Yes.
78 kindly turns to first 80. First 80.
Yes.
Looks to paragraph 7. Your Lordship pointed it out.
Yes.
But that was a submission, that if the application is not made,
That was turned down, rightly turned down. Right.
Yes, he's not 81 bottom. The BLL and LRO Kalna is hereby directed to consider the representation of the applicant received by him on such and to dispose of the same in terms of the observation made by the Honorable High Court.
That cannot be read in isolation without the subsequent paragraphs.
Then, within a period of 4 months, however, the representation of the applicant received by Atto, if he had not developed, then So the same may be verified with regard to the suit clause which are to be recorded in favor of the applicant in terms of compliance.
What is the scope? What is the scope of consideration of any representation? Then the court could have directly directed the.
I bow down to that. There was no scope at all. But even
The tribunal created the problem by adding these things. It's the tribunal which is in contempt.
because now the problem is they have accepted this order. So now they can't go beyond that.
No, they have
Because the
accepted,
sum and
but
substance of the order is that you have to comply the High Court's order, sum and substance. Whether there is a representation or not. Sum and substance is the High Court's order needs to be complied. And if he says anything beyond that, my lord, it is to be, my lord, taken into not taken into consideration at all. And there needs to be a quietness. If they have a right, my lord, they have proceedings. They can do whatever they want to, my lord, with it. But today, my lord, the 92 order of Calcutta High Court needs to be, my lord, complied. And if he doesn't, then he will have to face consequences. Whatever the consequences, this is not a final consequence. And it is not even a consequence because he has been given a chance. So he will actually be hauled up for contempt if he doesn't comply with it.
the present challenge has been preferred against an order dated June 20, 2025, whereby an application, a contempt application filed by the private respondent was allowed, thereby directing the alleged contemptor, that is the BL and LRO Kalna-Roman I, Purbo Bardhaman, to file show cause as to why contempt proceedings shall not be drawn up against him, vide section 15 of the West Bengal Land Reforms and Tenancy Tribunal Act for willful and deliberate violation and disregard of the solemn order dated September 28, 2022, passed by the said bench of the tribunal in connection with OA number 1980 of 2019 (LRTT) by not disposing of the application of the applicant and not conclude the hearing in terms of the order of the Honorable High Court at Calcutta, as well as the order dated July 11, 2025, whereby, keeping in view that a fair chance should be given to the concerned BL and LRO, since he has joined only 10 days back, the said BLLRO was directed to complete the compliance proceeding and to bring the corrected ROR in person before the said bench in terms of the judgment of the Honorable High Court, this Honorable Court, positively on the next date fixed. Full stop. Next para. Learned senior government advocate, appearing for the appellant state, submits that the order passed by the BL and LRO, which was the premise of the rule of contempt issued against him, substantially complied with the direction of the tribunal. Full stop. Taking this court through the order of the tribunal dated September 28, 2022, which has been allegedly violated, learned senior government advocate points out that apart from a direction on the BL and LRO to dispose of the representation of the applicant stroke private respondent in terms of the observation made by this court, vide order number August 10, 1992 in CO number 11078 within bracket W of 1992, the tribunal further directed the BL and LRO to meticulously verify whether the correction of records of rights belonging to the applicant stroke private respondents herein can be made in accordance with law and relevant rules existing. Full stop. Thus, it is contended that the concerned BL and LRO, while passing the order, which is allegedly contumacious, comprehensively dealt with the law on the substance of the dispute and came to the finding, upon a consideration of several judgments cited before him, that the decrees of the civil appellate court were nullities, and as such, the correction could not be effected in terms of the same, in respect of the records of rights concerned. Full stop. Next para. It is argued that in view of the rider of the order of the tribunal to the effect that the BL and LRO was to meticulously verify whether the correction of records of rights could be made in accordance with law and relevant rules, comma, the BL and LRO acted well within the ambit of the said direction in passing the impugned order, comma, considering the legality and the relevant rules. Full stop. It is sought to be argued by learned senior government advocate that in view of section 40 of the unamended section 46 of the West Bengal Estates Acquisition Act 1953 being applicable, comma, it was beyond the scope of the civil court to decide the issues involved, and comma, as such, comma, the BL and LRO could not be said to have committed a contempt of court by passing a well-reasoned order in accordance with law. For sub next para, learned senior government advocate next argues that that in the event the private respondent is aggrieved by the order of the BL and LRO, comma, a fresh challenge against the same is the appropriate remedy and not a contempt application. For sub next para, it is submitted that in the event any illegality or irregularity in the order comprises the grievance of the private respondent, comma, the appropriate remedy would be by way of an appeal as contemplated in the statute. Full stop. It is beyond the jurisdiction of the contempt court to interpret its own order and come to a finding as to contempt, comma, it is argued. Full stop. Next para, learned senior government advocate places reliance on such and such reported at 2014 3 SCC 373 2014 3 SCC 373 for the proposition that the courts must not travel beyond the four corners of the order which is alleged to have been flouted or enter into questions that have not been dealt with or decided in the judgment or the order, comma, violation of which is alleged, comma, in a contempt plea. Full stop. Next para, learned senior government advocate submits that by the last limb of the second impugned order dated July 11, 2025, comma, the BLLRO has been directed to comply with the to complete the compliance proceeding by correcting the ROR, comma, thereby seeking to interpret its parent order in a contempt proceeding, comma, which is not permissible in law. For sub next para, learned senior advocate appearing for the private respondent submits that there was no option for the BL and LRO to enter into the veracity, comma, validity or sanctity in the eye of law of the decree of the appellate court, comma, in view of the specific direction of the writ court.
Page 22. 24 is the
24. Of the writ court, dated August 10, 1992, passed in civil order number 11078 within bracket W of 1992, that the state respondent is to correct the relevant records of rights in terms of the judgment, comma, decree and order as mentioned in the writ application within 3 months from the date of filing of the application by the writ petitioner therein. Full stop. Next para, it is submitted that the mandatory nature of the said direction did not leave any option for the BL and LRO or the tribunal to deviate from the same. Full stop. It is contended by the learned senior advocate that the order of the tribunal dated September 28, 2022 has to be read in such context. Full stop. In the said order, comma, the tribunal categorically directed the BL and LRO to consider the representation of the applicant stroke present private respondent afresh and to dispose of the same, double inverted, in terms of the observation made by the Honorable High Court, Calcutta, with a order dated 10/08/92 in CO number 11078 within bracket W of 1992, double inverted close, full stop. As a corollary thereto, comma, it was added that the BL and LRO must meticulously verify whether this correction of records belonging to the appellant before the tribunal can be made in accordance with law and relevant rules existing. Full stop. Next para. It is further pointed out by the private respondent that neither the decrees of the appellate courts, civil appellate courts, comma, nor the order of the writ court passed in CO number 11078 within bracket W of 1992 were challenged before any competent forum. Full stop. Thus, comma, those attained finality and cannot be deviated from. Full stop. Hence, comma, the BL and LRO, comma, in hitting at the very root of the said directions by questioning the validity, comma, legality and or sanctity of the decree of the appellate court, committed a blatant contempt of the direction of the tribunal. Full stop. Next para. Learned senior advocate further argues that the present challenge is premature since by the impugned orders, comma, the BL and LRO has merely been directed to show cause as to why he should not be penalized for contempt. Full stop. No penal action has been taken as yet against the BL and LRO, and it should be left to the tribunal to decide on the outcome of the rule. Full stop. Next para. Upon a careful consideration of the arguments of the parties, comma, we are of the opinion that the stage at which the present challenge has been preferred is somewhat premature to a limited extent, comma, insofar as a rule has been issued, an order in the nature of a rule has been issued for the BL and LRO to show cause as to why he should not be penalized for contumacious action. Full stop. Next para. However, comma, the portion of the second impugned order dated July 11, 2025, whereby the BL and LRO has been directed to complete the compliance proceeding and to bring the corrected records of rights in person before the bench, tantamounts to prejudging of the issue involved in the contempt application, comma, in the sense that unless it is held that the BL and LRO is in contempt of the direction of the tribunal, comma, it would not the tribunal would not be empowered, comma, sitting in contempt jurisdiction, comma, to ensure compliance of the said direction in a manner as the tribunal interprets sitting in contempt jurisdiction, comma, which would be contrary to the principle laid down in Sudhir Vasudeva Supra. Full stop. Next para. Insofar as the alleged contempt is concerned, comma, the order of the writ court in CO number 11078 within bracket W of 1992, comma, no doubt, comma, left no manner of doubt as to the records of rights being mandatorily directed to be corrected in terms of the judgment and decree as mentioned in the said writ petition, that is the decrees of the appellate courts. Full stop. Next para. Although the state has a point in arguing that the appellate court's decree, comma, even if not challenged before a higher forum, comma, its nullity can be set up at any point of time on the ground of inherent lack of jurisdiction, comma, the order of the writ court in CO number 11078 within bracket W of 1992, comma, which has also not been challenged and has attained finality, comma, comes in between such argument and the order of the tribunal. Full stop. Even if there would have been left some scope of considering as to whether the appellate court's decree was a nullity in some coordinate forum, comma, after the order of the writ court to correct the relevant records of rights in terms of the judgment and decree and order as mentioned in the writ application, comma, there was very little scope of reinterpreting or reopening the said decrees. Full stop. Since the state, comma, which was a party to in the said writ petition and was a party to the said writ petition has acquiesced to such order by not preferring any challenge against the same, comma, it apparently was the duty of the concerned BL and LRO to correct the records of right in terms of the appellate court's order. Full stop. Next para. However, comma, a second layer of doubt has been created by none less than the tribunal itself in its parent order dated September 28, 2022. Full stop. There would have been no option for the BL and LRO but to directly correct the records of rights if the tribunal stopped at directing the BL and LRO to dispose of the representation of the private respondent in terms of the observations made by this court in CO number 1108 of within bracket W of 1992. Full stop. However, comma, the tribunal went one step ahead and directed, comma, even apart from such correction, comma, to meticulously verify whether the said correction of records belonging to the appellant can be made in accordance with law and relevant rules existing. Full stop. There is a twofold dilemma involved in the present matter. Full stop. The first is whether the subsequent direction of the tribunal to for the BL and LRO to meticulously verify whether the records of rights could be made in accordance with law and the relevant rules would apply only to the procedural part and the modalities involved, or could also touch upon the substantive validity of the correction of the records of rights, comma, in which case, comma, it might have been argued to be open to the BL and LRO to consider such aspect of the matter also. Full stop. Next para, the second layer of dilemma is whether, comma, if there is a scope of dual interpretation or multiple interpretations of a particular order, comma, a person can be hauled up for contempt of the same, comma, since contempt being a penal jurisdiction and the last resort of courts, comma, has to be seen on extreme standards. Full stop. If there could have been a justified dilemma in the mind of the alleged contemner as to the import of an order, comma, a contempt rule generally, a contempt, penal action on contempt is generally not taken. Full stop. Next para. However, comma, since it can also be argued by the private respondent that the direction of the writ court, comma, read in conjunction with the order of the tribunal had only one way of interpretation. Full stop. A harmonious interpretation of the two could only lead to the BL and LRO correcting the records of rights in terms of the order of the appellate court decree and look into whether, as per the extent law and rules, comma, there was any procedural defect or irregularity as to the modality in which the application stroke representation was made. Full stop. Next para. In view of the double layer of dilemma, comma, it is premature to say at the present juncture as to whether the BL and LRO is in contempt of the direction of the tribunal. Full stop. Next para. As such, comma, the present writ petition is also premature insofar as it concerns the issuance of the rule of contempt, comma, since it is yet to be decided by the tribunal conclusively as to whether the BL and LRO is guilty of contempt and is liable to be punished for the same. Full stop. Next para. However, comma, the second component of the impugned order dated July 11, 2025, to the extent that the BL and LRO has been directed to complete the compliance and to bring the corrected ROR in person before the tribunal, cannot be sustained in law. Full stop. Sitting in contempt jurisdiction, comma, the tribunal, comma, prior to conclusively deciding whether there has been a contempt or not, comma, could not enforce the compliance of its parent order. Full stop. In the event the private respondent was aggrieved with the said order in law or on facts, comma, the remedy available to the private respondent would be by UEFA challenge, by UEFA challenge in an appeal before the appropriate forum and not the contempt jurisdiction. Full stop. Hence, comma, the portion of the impugned order dated July 11, 2025, whereby the BL and LRO has been directed to correct the records of rights, would tantamount to an exercise of jurisdiction by the tribunal in contempt. Full stop. Next para. Insofar as the rest of the order is concerned, comma, we are of the opinion, comma, in terms of our above observations, comma, that it would be premature to interfere at this juncture. Full stop. Accordingly, WPLRT 110 of 2025 is disposed of, comma, thereby sustaining the impugned orders dated June 30, sustaining the impugned order dated June 30, 2025, as well as the impugned order dated July 11, 2025, insofar as the same pertains to the direction on the BL and LRO, Kalna 1, Roman 1, Purvo Bardhaman, to show cause as to why contempt proceedings shall not be drawn up against him for the perceived willful deliberate violation by not disposing of the application and concluding the hearing of the same in terms of the order of this court in the writ petition. Full stop. However, comma, insofar as the latter portion of the impugned order dated July 11, 2025, comma, to the effect that the concerned BLLRO has been directed to complete the compliance proceeding and to bring corrected ROR in person before the tribunal on the next occasion is concerned, comma, we set aside the same. Full stop. We make it abundantly clear that we have not entered into the merits of the contempt application. Full stop. In the event, comma, upon conclusion of hearing the cause shown by the BL and LRO, comma, the tribunal is of the opinion that the BL and LRO is guilty of contempt, comma, it will be open to the BL and to the tribunal to take appropriate necessary action in accordance with law, and, comma, in such case also to direct compliance of the order passed by it. Full stop. Next para. However, comma, in the event the contempt proceeding culminates in the BL and LRO being held not guilty upon extending the benefit of doubt to the BL and LRO or otherwise, comma, the tribunal shall then drop the contempt proceedings and shall not pass any order for implementation of its order in connection with the contempt proceeding, but leave it to the private respondent to take appropriate steps for implementation of the said order in accordance with law. Full stop. Next para. Any connected application is there?
No, Lordship.
Next para. No order as to cost. Urgency.
No, no.
20th July. So the 20th July order is under charge.
Lordship, yes. Lordship has used
20th July, there is no 20th
June. 20th June.
20th June 2020.
Must be
Lordship has used 30th June, that is.
must be a typo then.
No,
In
Lordship.
the prayer portion, what have you paid?
20th June.
20th June.
No, in the dictation, Lordship, somewhere it has gone 30th June, I think.
Date is 30th June.
No.
Page 101, my lord. Of the writ petition.
Oh.
That is the relevant order.
যেখানে thank you. Thank you very much.
Only once.
যেখানে June 30 বলেছি সেখানে 20 হবে। Thank you.
নেক্সট ডেট কবে আছে তার মধ্যেই শো করবে
Yes, এটা ফেরত দিন। প্রথমেই হকটা হবে এফিডেভিট সরি ফাইল টু বি কেপ্ট।
গ্রেটফুল টু লর্ডশিপ।
Item number 7.
আচ্ছা অনিন্দিতা একটা কথা বলছি,
Item number 7, when praying for short password.
why at this hour? No.
But he is engaged. Mr. Basu is engaged in court number 13.
13 is senior to us or junior to? Which court we don't know.
13 Justice Mantha.
Senior to us, yes.
Actually, I was
We have these egos,
13. I was assisting him just a while ago.
Yeah.
Yes, he told that he's.
Then we have to grant it. Pass over.
Item number 8.
Only
Yes, Mr. Manna, how are you? Long time no see. Yes, but you don't have any case as usual, must be.
All right.
Must be the usual order then. Usual order of dismissal.
Sometimes.
No, what is the matter? What about service?
No, it is not even a correction of only this minute. OA number. OA number, my lord, kindly see page 11. OA number 744. Page 11. Order of the tribunal.
It's in a dispose of matter.
Dispose of matter. Lordship, kindly see.
Page?
Page 11.
11, yes.
And kindly see the order of the tribunal.
Second one.
OA number 744.
744, yes.
2017. But the order was passed on our honorable High Court, my lord.
774.
Lordship, kindly see page number, ordering portion of the page number 14. Dismissal in OA number.
Yes, we have seen that. So it should be.
Only this, my lord.
But Mr. Manna, difficulties, Justice Shogata Bhattacharya is still available. Should go before a bench. For this, will not really get very well doing.
Only this, my lord.
The present, have you given any notice to the other side?
Notice
Very well, in view of the innocuous nature of the prayer, prior service of notice on the state is the respondents is dispensed with. Full stop. In the order dated April 11, 2019, passed in WP LRT 46 of 2019, in the first paragraph, it was recorded that dismissal of OA 774 of 2017 LRTT was the subject matter of challenge in the writ petition, whereas from the order sheet passed in the concerned OA, we find that the case number is actually OA 744/2017 LRTT as opposed to 774, which was recorded in the order. So next para. Since the order, of which correction was sought was passed by a division bench, one of the learned judges comprising which is still available, ideally the matter should be sent to a bench by constituting a division bench, including the learned judge who is still available of the said bench, we take judicial notice of the fact that the said available learned single judge is sitting singly now, and it would be extremely cumbersome for the writ petitioner, for such innocuous prayer as made, to seek a constitution of a bench, a division bench comprised of the said learned single judge and another learned judge of this court for this limited prayer. Full stop. Hence, comma, since this is the regular bench taking up such writ petitions, comma, we allow the application bearing can 1 of 2024, comma, thereby observing that the order dated April 11, 2019, passed in WP LRT 46 of 2019, shall be deemed to stand corrected to the limited extent that the expression double inverted OA 774 of 2017 bracket LRTT bracket close double inverted appearing in the very first line of the said order shall be read as double inverted OA hyphen 744 stroke 2017 within bracket LRTT bracket closed inverted close full stop. Let this order be deemed to be a part of the order dated April 11, 2019. No arrest to question.
My lord, tribunal not passing this until correction of.
Pardon?
Until correction of that.
No, you won't. So why did you wait for so long? 2019, this is 2025, 6 years.
Correctly, my lord, they are until correction of that I am coming here.
You should have come much earlier.
My lord.
Yes.
Item number 9.
I'm for the opposite party.
You're for the? So what? What?
After vacation.
After vacation, why? You're enjoying an interim order?
No. It's review, my lord. Order 41 stage, your lordship.
But we'll clarify that this will not.
Lordship already clarified.
It's everything.
That's also been done.
That hasn't been done.
But there is a problem here. I will, when I.
There's nothing in the review application. Order passed by us.
Yes.
Then you don't have any means to avoid also. Then why are you not asking for time?
No, I don't want to avoid. I will come back to you. I need to.
What? There is nothing in the review you can understand.
I can tell you.
But even nothing, I mean, consists of positive and negative
Otherwise,
energy in intimate stage.
I would not have taken up the brief at all. I found something. That's why I will.
On the prayer of the learned senior advocate for the petitioner, review applicants, let the matter stand adjourned till after the vacation and be listed.
Immediately after.
And be listed টা কেটে দিন adjourned till after the vacation. যখন next list বেরোবে এটা।
And be listed থাকুক না।
Yes, it will be. It will continue in this.
Mr.
After the
Mukherjee has. I'll show you a lot. What he has done.
Not said anything.
What he has done. I'll show you a lot.
That respondent in order 41. I have not
This
argued.
matter, in this matter, what have you done? This is a review of what?
Review of order 41 stage, my lord, your lordship dismissed the appeal. So, my lord, I have not.
Out to your lordship, that
Your client's pockets must be very heavy.
No, the entire thing will go. Should go. Share. দেখলে should go. নিজে সব নিয়ে নেবে।
Order 41 review.
Registered deed, he is seeking for title on the basis of unregistered.
No. That's not correct. আমি পরে লড়াই করব।
Item number 10.
এই কারণে order 41 dismiss করে সুপ্রিম কোর্ট বলছে যে ডিসমিস করলে তুমি order 41 rule 11 এর রিজন দেবে। আগেকার অর্ডার সব হচ্ছে order 41 rule 11 এর ডিসমিস, নো সাবসেশন কোশ্চেন। রিভিউ করলেই আপনার খুলে যাবে। হ্যাঁ।
Your Lordship, I am for the respondent.
This is item 10.
Item 10. Your
I'm for the appellant, my lord.
I have not received the brief yet.
Why have you not received the brief?
I have been informed yesterday only that there is a
Affidavit of service they have.
Your client has been served. When was he served? Let us see when he was served. That is not a good ground, ma'am. In our court, at least that is not a good.
I know, Your Lordship, but he stays.
Today we are
out of
on,
India.
what is the date today? 22nd. No, 9th September he was served. 9th September.
I have been informed.
That's your problem. Why did you take the brief? What is the matter?
My lord, an ex parte, my lord, this is an appeal from an final decree, my lord, passed in and my lord, matrimonial.
No, what is the can? Section 5 is there.
One is section 5, 519 days delay.
Come back tomorrow.
No, my lord, ex parte degree, my lord. When the, my lord,
519 days we have to hear
the
the
baby, no, when the baby was born, my lord, the husband is still, my lord, beside me.
Not baby figuratively. We thought the litigation was being referred to as a
No,
actual baby. The husband was not there.
Husband was still, my lord, beside me. Now, when we came back, my lord, to our matrimonial house, my my lord, in-laws, my lord, told me divorce has been passed.
When you came back from the hospital.
I have taken specific
You,
objection.
you come back tomorrow prepared in the matter.
This is
Let her
a
come.
case.
She'll be embarrassed.
Come back with the
Come back.
file, Your Lordship.
But tomorrow, if you are not there, we'll record an order today.
I'll be there.
Affidavit of service filed to be kept on record. Full stop. Learned counsel for the respondent seeks for a day's accommodation. Full stop. As a last chance to the respondent to contest the matter, the same is adjourned for the day. Please come back tomorrow. Recorded last chance.
Yes, sir.
If you any senior is there, or you will argue.
I'll be
Fantastic. You
This
argue.
is a case, Milord, where Milord, disciplinary
Come back tomorrow.
proceedings
Come
Milord,
prepared.
must be initiated against the process server.
Don't make faces. We may not do that.
Milord, this is such thing. Milord, the baby Milord is born. In their birth certificate, husband's name is there. Milord, when she went back to the in-laws' house, the divorce decree is
He
passed.
deserves a prize for his cunning.
And Milord, the process server has given a report. I went to the suit property. The lady came up wearing a face mask, but she refused to sign the acknowledgement.
She is not in a position to controvert, but that's why you are prejudicing the court. We'll forget in any event. We forget all matters by the next day. So no difficulty.
Tomorrow.
No difficulty. Come back, ma'am, tomorrow. Yes.
Item number 11.
Yes.
The 11 I am for the plaintiff.
Yes, Mr. Das.
I am for the plaintiff husband.
The appellant. You are for the appellant. Yes.
Sir, 5.
What is the delay? Please take the mic a bit lower. What is the delay?
121 days, my lord, is a mistake.
How many?
121 days.
What mistake?
Sir, categorically mentioned in the section 5,
81.
No, my lord, it wrongfully written হয়ে গেছে 91 এর জায়গায় 81.
If you have explained the delay, we'll look into it.
Explain para 5 में explain
হ্যাঁ?
each and everything.
মেমোতে কি বলছে? স্ট্যাম্প রিপোর্টে কি বলছে? Stamp reporter says only 25 days.
Yes, also
Stamp reporter says 25 days. You have written in your application 80 something.
81, my lord, it is 91 হওয়া উচিত. It is correctly.
You say it is 91. Stamp reporter says 25. Let us see the dates.
121 days, my lord. Actual order passage, order and
Stamp
judgment.
reporter says 25, so we'll check up.
I
7th
don't know,
April,
sir.
when did you apply?
I corrected wrongfully 81, 91 days.
7th
It is
April.
correct.
Wait. Ma'am, please wait. 23 days, 23. আর এদিকে হচ্ছে 5. 28 দিন ওখানে চলে গেল।
The order and judgment passed 7th August 2025, my lord. Order and judgment passed 7th August.
5/8
That's the 7th April. Seventh.
पक्का तो is approximately a bit more than 25, not 121 days. Anyway, what is the explanation?
Well, you explain para 5, my lord. Appellant petitioner's mother is suffering from various ailments, so she did not contact with me.
When was the decree passed?
7th April 2025. To service.
You have been appointed by the legal aid.
Yes, my lord.
Sufficient ground.
Yes. Well, section 5 restoration.
No, sometimes we look into section 5 as legal aid.
No.
The present Can 1 of 2025 is an application for condonation of delay in preferring the appeal. Full stop. As per the report of the stamp reporter, comma, the delay is of about 25 days,
No, my lord.
comma, although a different number of days has been mentioned in the application. Full stop. Be that as it may, comma, we find from a careful perusal of the application, comma, particularly paragraph number 5, comma, that the appellant was handicapped in preferring the appeal due to the critical illness of her mother during the relevant period, as well as due to her meager financial means, comma, which compelled her to approach the District Legal Services Authority to avail free legal aid in preferring the appeal. Full stop. Upon hearing learned counsel for the parties and taking into consideration that sufficient explanation have been furnished for the delay, Can 1 of 2025 is allowed, thereby condoning the delay in preferring FAT 369 of 2025. There will be no rise to cost. Now, what have you challenged?
Order and judgment, you can challenge
Your divorce suit or their divorce suit?
after divorce. After divorce.
Your divorce suit granted.
Yes.
But one short point before my learned friend starts. The order was passed on 7th of April.
Yes.
My client remarried, my lord. These are the.
If you file your opposition, we won't grant any stay. File your opposition, disclose those. We'll keep those on record. You have not filed any stay application.
Today file this.
Today file this means?
Today already filed.
Why?
Today already filed this stay application.
What is the number? Can 2?
Can 2.
Learned counsel for the appellant, at this juncture, submits that a stay application has been filed bearing number can 2 of 2025. Full stop. Next para. However, learned counsel appearing for the respondent seeks to rely on certain documents to indicate that in the meantime, you waited for the appeal period.
Yes.
In the meantime, the respondent husband has contracted remarriage
on 31st of July 2025.
On July 31, 2025, after waiting for the statutory limitation period for preferring an appeal. Full stop. In such view of the matter, there is no scope of grant of interim stay / injunction at this stage in any event. Full stop. The appellant shall, the district legal services authorities, you are appearing through the district legal services or the High Court legal service?
High Court legal services.
Next para. The High Court legal services authority shall ensure that special messenger costs are brought within a week from date for bringing the trial court records. Full stop. The trial court records shall be accordingly brought by special messenger. Full stop. Next para. The appellant, through the High Court legal services authority, shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Full stop. Next para. The liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. If you file your stay application, you can mention it, give a copy to Mr. Das, his junior, and then you prepare your affidavit if you get a copy in advance. And we'll just take it and... Yes.
Item number 12.
Well, happy pujas.
Same to you. All of you.
I may not come
during the...
may not have any matter before your lordship in the last 2-3 days.
If you are going to foreign country, then we'll impose costs on you. Then otherwise...
We do.
Yes, Mr. Das. Happy puja.
Someone doesn't get leave also. So much of problem.
Why not? There's no difficulty if you go abroad. Why? Why not? That's just a joke. Yes. Next matter. Call করেছেন? 12.
I appeal for the appellant. Here, I am out of time in doing certain things. Lordship had passed an interim order in my favor. Thereafter, my learned friend took out an application for recalling of your Lordship's order of injunction. Then, Lordship had directed us to prepare a paper book as well.
They said they remarried or something like that.
I'm sorry, my lord.
This is a matrimonial.
No, my lord. Title dispute, my lord.
Oh.
An order of injunction passed by your lordships.
That was recalled.
No, that they applied for recalling, and that is why this matter is appearing before your lordship. My lord, lordship had directed us to prepare a paper book. I'm out of time, but I have prepared it. My lord, I'll serve it on my supplementary as well as.
I need to serve a copy.
My lord, couldn't do
supplementary paper book.
A paper book which contains the new supplementary affidavit which we were supposed to file. My lord, there is no point of filing a supplementary affidavit in addition to the paper book because this already has the supplementary affidavit.
No, file it because that contains the
original,
your affirmation.
My lord.
File that.
But may I file? I'll serve it today itself.
You're condoning the delay and directing them to serve copies today itself.
Gotcha.
We'll give it tomorrow.
Yes.
Tomorrow.
Learned counsel for the appellant submits that the appellant is out of time in filing the supplementary affidavit and paper books. Full stop. Such supplementary affidavits and paper books are filed in court today and be kept on record on condonation of delay in filing the same. Full stop. Copies thereof shall be served during the course of the day by the learned advocate on record for the appellant to his counterpart appearing for the respondent defendant during the course of the day. Full stop. Next para. The matter shall be listed tomorrow under the same heading. The understanding was that we'll hear out the appeal.
Yes, brother. Yeah.
Item number 13.
এটা 13। The matter was adjourned on September 16, 2025 on the prayer of the appellant. Full stop. Even today, comma, at the time of call, comma, none appears for the appellant to move the matter. Full stop. Next para. As a last chance to the appellant to move the matter, the same is adjourned for the day.
Item number 14.
My appeal, my lord. I'm
Yes.
the wife, my lord. There was a divorce decree granted ex parte. I preferred a proceeding under Order 9 Rule 13, which was dismissed. Against that, I have come before your lordship, my lord. On the last occasion, my lord was pleased to pass an order, thereby injuncting the husband from contracting any further remarriage. Now, although there was a point taken by the husband in the written objection that he has remarried, no evidence was adduced or nothing was
You must
corroborated.
have put in some if not.
Yes, well, if not already
Yeah, obviously.
That,
Yes.
that,
Because
that,
he is saying the
this is my affidavit of service.
served.
Served.
So we'll extend that till disposal of the appeal and direct.
The usual directions. may be
Usual
passed.
directions. Ex parte divorce degree, right?
Ex
The
parte
appellant.
divorce decree 913 dismissed against the
কোথায় এফিডেভিট আছে? Affidavit of service filed to be kept on record. So despite service, none appears for the respondent, although the appellant is represented through counsel. Good service effected, you have checked.
I have checked up, my lord.
You have checked up. Next para. The present appeal arises out of the dismissal of an application under Order 9 Rule 13 of the Code of Civil Procedure filed by the appellant wife for restoration of a divorce suit filed by the respondent husband and recall of the ex parte divorce decree passed therein. Full stop. Next para. Learned counsel for the appellant submits that although the respondent took a point before the trial court as to having contracted a remarriage, comma, the same was not substantiated by any material documents. Full stop. Next para. We find from the order dated August 27, 2025, passed by us in connection with the appeal, that we had observed that a prima facie case had been made out for hearing of the appeal and had granted injunction restraining the respondent husband from contracting any remarriage, if not already contracted, comma, till disposal of the injunction application. So since nothing subsequent has been brought to the notice of the court to vary such order at this stage, and since the appeal is pending for hearing both on questions of fact and law, comma, we find no reason not to make the said ad interim order absolute. Full stop. Next para. Accordingly, can 1 of 2025 is allowed ex parte, comma, thereby restraining the respondent husband from contracting any remarriage during pendency of the appeal, if not already contracted. Full stop. Next para. The trial court record shall be brought by special messenger at the cost of the appellant, comma, to be deposited within a week from date. Full stop. The appellant shall prepare and file. Do you have all the papers?
You have all the papers.
Or will direct formal paperwork? Normal. The appellant shall prepare and file the requisite number of paperbooks within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Full stop. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing.
I'm grateful.
Thank you.
Item number 15.
15, my lord, I beg to appear on behalf of the appellant.
Yes, you are appearing after a long time before this. Yes.
My lord, my affidavit service, my lord.
Good service?
Yes.
Very good. Yes. What is the matter?
Matter is that, my
Okay,
lord, petitioner, my lord, purchased the mother of the petitioner, writ petitioner, purchased
Mother of the writ petitioner.
Writ petitioner.
The appellant.
Appellant herein, my lord, purchased a land. CS and RS duct number is same, 2246.
You are appearing for the respondent?
My lord, I am for the railways, my lord.
For the railways?
Railways.
Yes.
CS and RS, my lord, plot number 2246, measuring about, my lord, my lord, 0.056, my lord, like that one. Equivalent to my lord, 11 cutters.
You are
11 cutters, my lord, equivalent. That is 0.0567 acres.
You are for whom?
For the state respondent, led by Supratim Dhar.
Yes.
Yes, my lord. During the my lord, lifetime of the mother, she,
You are
my
the
lord,
occupier. Mother was the occupier.
occupier, my lord, I have already constructed. I am coming to. I have already constructed a
But you don't have any title deed.
title deed. Yes, you know, I have purchased, my lord, by dint of the two title.
Mother
deeds.
purchased by two title.
Yes, yes.
Construction, yes.
I have also muted it. My name in the
Very
LR records, my lord.
Then
After my lord, suddenly mother, my lord, after demise of the mother, suddenly mother railway, my lord, incorporate the name on the LR records.
their name.
Their name. No notice has been given to us, my lord. We have already filed a my lord for my lord change of the same, my lord. That way is pending before the my lord, my lord, BLR. In the meantime, my lord, I have my lord asked for a my lord, a stop work notice has been given.
Stop.
Yes, sir, my lord, because my lord, I have already my lord got a my lord sanction plan from the Jila Parishad. I have also constructed a building thereon. Suddenly, railway has issued one stop work notice, claiming that this property belongs to the railway.
Stop work notice under which provision?
There is no such provision, my lord. I am coming to that later also, because my lord, I am giving the facts, my lord. So, my lord,
Stop work means you have already constructed. You
I have
have
already
completed the construction.
my verge of completion, my lord. It was
So that little construction left that has been
because
stopped.
my lord, all the races, my lord, petition, my lord, outside the state staying, my lord, in Bihar, my lord.
All right.
Lord will be fine. So, I have my lord, asked for a my lord, Right to Information Act before the my lord, LA office. They are saying, my lord, if land was my lord, requisitioned in the year 1961. Requisition, only 4. Section 4 notification. Subsequently, my lord, I have also, in respect of the same LA case number, I have got, my lord, a subsequent notification.
No, requisition under 1940 Act.
Yes, my lord, Land Acquisition 1, Act 1894. Yes.
That is not a requisition.
4 is the requisition.
It's not requisition. Requisition is under 48 Act, 3 is requisition, 4 is notice of acquisition. But under 1894 Act, there is no requisition. You give a notice, then a declaration.
Yes, my lord, 4
only 4 notice. Possession is taken after award.
Yes, my lord, because,
Unless it's section
because my lord,
section 9 situation or something.
My lord, 6 is my lord contemplated after the 4.
4, 6,
Yes. Then 11.
In the meantime, 5A and all. There is no requisition.
So there is, if there is no my lord, section 6.
So you found a section 4 notification only.
Yes.
After that, nothing.
Nothing.
When was that dated?
After that, my lord, they have also.
What was the date of that
I
notification?
am coming, my lord. After that, my lord, section 6 notification published.
Then
my land has been excluded from that notification.
Oh.
That is.
So what is the what
then
was
my
the
lord, I came before this honorable court challenging that one stop work notice.
This
This honorable
dismissed?
court,
Yes.
This honorable court relegated this relegated this matter to the my lord, Railway Authority for consideration of the same. Requisition as well as my lord, acquisition.
You gave a representation or something?
Yes, yes. On the basis of my representation.
Then what happened after that?
After hearing, it was
dismissed.
Dismissed.
Again,
challenging that, my lord, I preferred the my lord, writ petition.
What was
the
their
writ
ground?
petition,
What was their ground for rejecting?
they are saying, my lord, section 4 notification means, my lord, everything is done, my lord, because there is no erratum. Subsequently, erratum published, your land has not been, my lord, included in the erratum. That is the procedural aspect. If the
No, in section 6 notice, your land section 4 it was there, but section 6 excludes.
Excludes.
They say there was an erratum to the section 6 notice.
No, they are saying that some lands were relinquished as like that. That was
Then
also,
your land was also relinquished. Then.
but that is not there. They are saying, but in the erratum notice, that
Very
is
well.
their
Then-
part, my lord. That
then-
is no, that is not the law. Your lordship knows that.
So the learned
Erratum is
similar
a-
said what?
My lord, there was a call for the affidavit from the state authority. Now, state has, my lord, taken a new my lord, ground stating that your land was acquired. That land is, my lord, only 0.02. That is also recorded in the state. Thanks to my lord state, my lord. That land was acquired in the my lord under the my lord Defense of India Act 1943. Already, my lord, my adjacent plot of land, your lordship, that appeal is pending. Similar view has taken by the learned single judge, my lord. Your lordship has already granted stay.
So this is the standard practice of the state.
No, I'm not saying that, my lord.
So we are saying that. This is the second matter we are getting similar.
Similar, yes. Oh. But here, my lord, the only thing is
advocates
that,
are changing, but the matter
no, my only thing is that there is
State
a
is
one
the same.
little difference, my lord, in that, my lord, I have seen
No,
that.
even if it was what is the year of the act, Defense of India Act?
1943.
43. Even if that be so,
that is at least 0.02 acre.
No, not only that. Then they say that it was given to the railway authorities or what?
No, that is
Defense
not.
of India. In that
Yes,
case also
that
the railway authorities' decision should go.
Yes, obviously that I'm coming to that.
So what was done by the writ court? Why?
The writ court says the entire land was acquired
under Defense of India.
Defense of India Act.
So how does the railway authorities, as per the learned single judge, acquire?
No, my lord, discussion regarding that. How it has come to the railway authority. That is completely two different projects, my lord. Now, my lord, may I place the my lord notification at first? First. My lord, that is one, my lord, only one thing, my lord.
Yes.
It could said, my lord, the vacate the premises.
So you had challenged in the writ petition. You had challenged only the railway authorities' decision.
Order, yes.
Order.
Order.
So even if it was acquired under the Defense of India Act, in the absence of anything to show that it was
transferred to the
railways or given to the railways,
they cannot claim. They
cannot
claim.
claim. Then the writ petition should have succeeded, but might be if you had challenged the acquisition, then it's a different matter. No, probably your locus standi was then hit.
Because first time it has come because to the knowledge of the petitioner that it was acquired at only 0.02 acres.
That has not been discussed in writ.
Anyway.
So, my lord, only one thing is that, my lord, that is, my lord, it requires some time because, my lord, I will, my lord, place, my lord, whether, my lord, the temporary provision of the, my lord, acquisition and permanent position. When it was acquired, my the state report says, my lord, that compensation was paid in the year 1951 when the act was not in force.
You have not preferred any challenge against the acquisition or the requisition. Till date, there is no writ petition filed against the requisition or the acquisition. So if that requisition and acquisition learned single judge proceeds on the basis that there was a gazette notification produced showing the requisition and also subsequent acquisition under 75A2 of the rules, and all these the learned court, in the absence of any challenge, the acquisition cannot be reopened by the writ court or this appellate court at this stage, unless you prefer a challenge to that. We cannot reopen that acquisition. The limited question we have to consider is whether the writ petition succeeded, because they would argue obviously that you don't have any locus standi since the land has been acquired, and you would argue that in any event the railway authorities did not have any right to issue that notice because there is nothing on record to show that the railways have any right. So that can be the only conspector. We cannot hear your arguments or decide on the sanctity or veracity of that acquisition or requisition because you have not challenged it in the writ petition. What is your stand? Defense of India Act and all. Yes, how does the railway get an entry into the picture?
My lord, with regard to railways locus standi, my lord, for issuing this particular notice, my lord, there was a writ petition in terms of PIL file, my lord, before the Honorable Chief Justice, my lord. There were a lot of lands which has been encroached, my lord. In terms of that writ petition, direction was given upon the railways that railway will see into it, will check whether these lands belong to the railway, and railways will issue notices accordingly. Now, my lord, good or bad, that land is today in the name of the railway, my lord. So, railway has the locus standi to issue such notice because in the records it is railway in the name of the railway. So, railway is required to issue the notice today as the land is in the name of railway.
But does record of right confer any title or right? Possessory, yes, possession, but they are in actual physical possession. Now, at best, records of right can raise a presumption of possession. they are in actual physical possession, that is admitted because you have issued a stop work notice.
My lord.
So then it does not confer in title. What is the locus standi of the railway? Even if your name is recorded in the records of right, admittedly you are not in physical possession. At record of right does not confer any title. You have no independent document, and the state stand, the lead court proceeds on the premise of the state's version and says it was acquired under the defense of India. We can understand that.
My lord.
It may very well be. They have not challenged that. But railways does not have any locus.
My lord, we had written a letter to the.
You have not produced any document in support of your title to the property.
No, my lord, we had written to the state government with regard to the title of this property, my lord.
Achha.
If your lordship comes to page 280, my lord.
280?
My lord.
Yes, please. 280.
May I place it, my lord?
Please. Yes.
Across the subject and reference mentioned above, this is to inform that as per the available records of this office, a notification published in Calcutta Gazette on 13th May 1943 is found related to acquisition of CS plot number 2246 of Moja Dhulia, Jal number 35 in LA case number 2 of 1943-44. Copy attached. Other documents, that is award possession certificate, etc. related to the LA case are not available as the case is too old and damaged. No further LA case is readily available regarding acquisition of that plot. Further search is being continued in this regard. Now, my lord will come to the next page, my lord. Your lordship has seen it, my lord, in the
Yes,
previous
in the
matter.
previous one, right?
My lord.
That is what my learned brother is saying.
Now, my lord, 246 dark number is there, my lord. May I show it again to your lordship, my lord? At item 4, my lord. Second last line. Point 4 on the right hand side, my lord.
On the right hand side.
4.4, my lord. Second last line of point 4. It is not.
Yes.
Just
2246.
My lord.
Yes.
2246, my lord.
In the section 4 notice it is.
My lord, your lordship has seen that case number 2, my lord, in the previous page of 280. Now I'll show your lordship, my lord, that payment has been given to them.
Not section 4. This is the notice under 75 of the Defense of India rules. Not under section 4. Other matter was involved, section 4 is involved. Not in this matter.
Yes, Defense of India rules. You have mentioned that.
Now, my lord will come to page 236, my lord.
To 36, yes.
My lord, this is the payment details of the sub case numbers made in 5 sub case 21, 22, 23, 24, and 25, my lord. Your lordship has seen in reply, my lord, what railway has received. Their sub case is 2, my lord. So payment has been made with regard to this, my lord.
That does not complete your title.
My lord. Now, because the state government says that this land has been handed over to the railway because there is certain project to come up for the railways, my lord. That is why this land has been handed over to the railways. Now, the state government says that this land belongs to the railway, my lord. Then I have to take steps, my lord, to remove the encroachers because it is the direction of this Honorable High Court, my lord.
State, the Defense of India Act taken and given to the railways, why?
Mori, there was a link, what I have instruction, my lord, there was a Morigram link project to come up, my lord. For that only this land has been handed over. Certain land has been directly handed over.
The transportation for the arms and ammunition through the railway. So, Malad, the purpose has to be seen. Malad, kindly come to page 231.
All right.
Same thing, I believe.
Also, see my kind of 233.
Page 231. Whereas the property described in the schedule attached to this order has been requisitioned under Rule 75A. Defense of India has the same provision like Act 2. First requisition, then if government is satisfied.
This is requisition. Very well.
This is no, kind
Acha.
along with me. Well, attached to this order has been requisition already under Rule 75A.
Oh, now therefore I declare that.
Defense of India
Is acquired.
by virtue of the powers vested.
75A2, right. Acquired.
Then 75A2 was invoked and government has decided.
It vests along with this.
Along with this. Once it is acquired, then vests.
But how are they in position and they got permission to make construction and all sanction plan? You have granted state.
That gentleman who came
What
before
gentleman?
this court by filing a public interest litigation, sometime he first pointed out that this huge tract of land is getting.
He may be the whistleblower, but you are the culprit. State gives permission, takes money, gives sanction.
No.
Railway property and
I concede to that.
Kindly turns to page 233.
230?
233. Quantum of the land, my lord.
Yes.
That's why, my lord, that project has been, my lord, accomplished. 2246 only 0.02 acres. My lord,
where is it?
Schedule is there. 230. I am referring to 233 page.
233 schedule. 0.046.
2246.
Oh, acha.
Yes.
This is only 224, right?
Now, my lord, kindly
what
compare.
What is the total area of that plot?
My lord, kindly compare. After getting this, my lord, I have applied under the Right to Information Act. That is, my lord, additional documents, my lord, I have filed.
Right to Information Act, all right. But here the schedule.
Schedule 0.02 acres. My land is, my lord, 0.0567 acres. Not, my lord, the entire land.
What is the extent of the entire land? Let us see. And this 224, no. If you come to page 281, you will find that item 4, as your learned friend was pointing out, that says that the entire 2246 cadastral survey plot number 2246 that has been acquired.
Entire land has not been, my lord, mentioned. Only land. It says land.
Plot number such and such.
Plot
number 2246.
Yeah, suppose, my lord, that is, my lord, published during the, my lord, what situation, my lord? Suppose some lands were not required for the purpose of, my lord, acquisition. That's why, my lord, it is very next day, my lord.
No.
Subsequent
in the absence of any erratum,
subsequent that.
Acquisition vests right title in the property.
Subsequent, it is subsequently published. Subsequently published. Kali says that.
This is a gazette notification. How can an order? What order is this? LA case number such and such. Where is the property described? What does it say?
Where is the property described in the schedule attached to this order has been requisition under 75A requisition under 75A Defense of India rules. Now, therefore, by virtue of the powers vested in me by Rule 75A2, which says about, my lord, acquisition.
Can that magistrate and collector, the collector here, can the collector deviate from the notification? On the notification, as per the Act, if it is similar to the LA Act or the 48
May I
Act,
please have a 75A2?
please do that.
My lord, before my learned friend proceeds, my lord, I want to draw your lordship's attention to page 235. 235.
Yes, what is this?
My lord, this is regarding temporary land acquisition, case number 2. My lord, will see, my lord, at the bottom, CS plot number 2245 and 2246.
Enter.
Not
in part.
Yes.
And my lord, I have shown your lordship that their case number was 2, my lord. The payment with regard to case number 2 also I have showed your lordship.
Not 2, my lord. That is my 2 by 1.
2 by 1.
Why? The 2 is different.
There were sub cases, my lord.
State is saying, my lord, it is not missing. Now he says
there are
that
5 sub cases, my lord, which has been satisfied. And I have shown your lordship, my lord. It is with regard to CS plot number 2245 and 2246.
Let us see this section once.
Yes, my lord.
Defense of India Act একটা আনিয়ে রাখবেন তো Act আর rules দুটোই Act's সঙ্গে rules ও লাগবে যদি এক বইয়ে না থাকে তাহলে দুটো On the notification, it automatically vests in the government as per subsection 3. There is no scope of the magistrate or the collector doing anything contrary to that. That is not a requirement under the Act. Official publication in the official gazette is sufficient. Under subsection 3, under subsection 3 of section 75A, where a notice of accusation is served on the owner or published in the official gazette under sub-rule 2, then at the beginning of the day on which the notice is so served or published, the property shall vest in the government free from any mortgage such as such and such or encumbrance. And the Act does not authorize anyone, collector or anybody, to deviate from that. Collector has no jurisdiction to do that.
Subsequently, perhaps there is some notification.
No, perhaps this declaration.
Malad, kindly sees my Malad additional documents, Malad.
What addition can you make to this?
Because after getting, because the first time Malad, it has Malad, this Malad thing has been surfaced before the learned single judge. No, Malad, I have applied under the Malad Right to Information Act. What's the reply of the state? State is saying Malad 0.02 has been acquired under the LA case number 2.
The official gazette is staring at your face, at the face of the state also.
But then Malad,
how do they explain that?
Any notification published?
Where have they?
Malad, additional document Kali says Malad.
Additional
Can
document?
Can 2. Can 2 to the?
Both of you have got a copy of Can 2.
My lord, but this was not part of the writ petition.
Not filed at the
With
time
the part of the writ petition, I have also mentioned in the my lord, my exception, in my exception. What are you
Can
saying?
2 type of kothay?
In my exception, I have stated.
Why did you file the additional evidence?
Because, my lord, it was not placed, that document.
Additional document.
But that
Production
document.
of additional evidence, what was the necessity?
That
if it was a part of the writ court's record?
I have made the averments, but that document was, my lord, since the petitioner was living in, my lord, I could not, my lord, collect it, my lord.
Just now said it was part of the writ court records?
That is, my lord, averment I have made.
Averment is not part of records. New document. What do they say here? Let us look into it. Information subsequently, we are looking at the gazette notification itself. What information?
Now the say is perhaps there is some release of the land because only 0.002.
We cannot go by, I mean, conjecture and surmise. Perhaps
that is the record of the state. State record says 0.02.
State record is not material. Official gazette is. Yes. So how do you explain this?
This is a completely new document.
No.
I'll have to
Exception, I have stated.
my client regarding this. It was never placed in the writ court.
In the exception, I have mentioned, my lord.
No, but that document was there before the writ court. The one they have.
Yes.
The other one.
It is state report.
That somebody is noting in the order sheet and written.
That somebody is your collector.
Could be, can
collector
can the gazette notification, which one will override? I have learned it from my lords that notification definitely will override.
There may be something subsequent, some erratum or something, which you are suppressing.
My lord, because of these discrepancy, my lord, they
you are caught in the crossfire. As usual, railways caught in the crossfire between the owner and the state. You are more a victim than a predator.
When both the notifications is saying, the entire plot as also, kindly come, kindly, let me place my case. Kindly come to page 231 first.
231, what is the plot mentioned?
This is required for winding roads and for
231
by excavation of borrow pits.
You're harping much on 231. We don't find the mention of that plot.
It's the same notification, Howrah, 7 and 8th May 1940.
Yes, where is the plot number mentioned? 2246?
There is same
kindly turn to the next page.
The same plot.
Kindly turn to the next page.
Same notification is referring, my lord, that Defense of India.
2246.
Yes, Malad has got it.
Yes.
Next, on the next page, 2246.
Hipipura.
Because this next page is not, got the photocopy of the entire page, last portion got cut off. That's why this first page, page 9, means or page 231. So now, Malad, kindly come to the
231 contains the first part of the left column, and this contains the right hand. Excellent.
Now, my lord, kindly come to the
No, but
235. LA case number of, my lord has got it.
yes.
75 of 1942-43 on top, my lord has got it. Notice regarding temporary land acquisition number, LA case
No,
number.
no, this is temporary land acquisition.
Yes. Now, I'll take your lordship to the next part. Then, my lord, kindly come to the award sheet. That is at the next page.
Yes.
LA case number 2 of 43-44.
2A.
Yes.
2A.
Then, my lord, kindly come, my lord, read along with me, my lord. Calculation sheet prepared and checked by the deputy collector, Sri such and such, and award made in 5 sub cases. One is 2 by 1, another one is 2 by 2, another one is 2 by 3.
What do you understand from this?
My lord, and their land is coming under 2 by 5, and payment is
Yes.
already made. Kindly come to the left hand side portion that on 18 April 1951, 29th May 1951, 30th May, and every date is been mentioned, and the person concerned has signed on the right hand side. Then kindly come to the next page, 237. All payments
appears to be the same signature.
Yes, my lord, the officer is signing, and my lord, on the date.
What is the sign of signature of the person concerned? You said person concerned is same.
No, my lord, the officer is.
Both signatures are of the same person.
Yes, all the signatures of the same person.
Of the officers.
Of the officers.
Not of the recipients.
No, not of the recipients.
No, very doubtful, my lord. The date, my lord, kindly says. Kindly date says, my lord.
Yes, yes.
21st February 51, 18th April 51, then 29th May 51, then 30th May 51.
Yes, need not read the entire thing. You have seen.
All the different dates and all the cases in respect of all the cases 2 by 1.
How do you explain page 233, Mr. Dhar?
Regarding this, in later stage, somebody note.
And we don't find any reason why we shouldn't entertain this RTA information also. We'll give you opportunity, both of you, obviously. But for the sake of complete justice, we should look into this also.
And then I'll have
there might have been something in between, because yours consistency here at page 233, your collector is writing this. The information given is only 02.02. So there's an arguable case there. You categorically state, yes, you are right. Section 6 declaration is there. 75A declaration is there, acquisition. But there are always erratum published by you. So many cases we find errata published subsequently. We don't know whether there is an errata. Then we require an affidavit from you stating that there was no further erratum to this.
I'll do that.
If you do that,
fast
and you'll also have to explain.
Let them say on oath
What?
that they have not made out that case.
What?
Their case was, Writ Court case was, that there was only in the 1960s, there was section 4 and subsequently no section 6. And that's how they say the land acquisition.
No, because you are changing stands between yourself and the railways. Railway initially took a stand that LA Act was invoked. That is the premise on which they proceeded.
I do not blame them. Now I have come.
And now you have come up with this act.
Both the notifications are taking over.
Which is quite correct. If you have done that. But then also these documents are there, which cast some doubt as to whether there was an erratum.
Then I'll have.
You are relying on different acts altogether, the railways and you.
Now,
my lord, kindly says page 113.
That's why section 6 did not take place. My justification was why after section 4, section 6 was not taken place, because government was satisfied that I do not require this land because it's already been vested to the state under Defense of India rules.
Section 4 notice also you had issued in the respect of this.
True.
What are the respective dates of the section?
Only section 4.
Section 4 and 75A?
But 75A is 1943.
1943, right.
It is, my lord, 22nd August 1961, section 4. My lord, your lordship kindly turns to
1943 is Defense of India Act, and
Defense of India.
So you
8th May 19.
So you are not sure about your records. It's very evident.
18 years.
So how can you repose faith on you that there was no subsequent erratum? Two documents at least have been produced, both issued by one by your collector and the other one is at the ground level. These are being issued,
Well,
and
who-
the other is SPIU and additional LAO.
Yes.
Collector, same. Collector's office is consistent on point 02.
Regarding that one, that's completely new document. I'll have to check. I can't comment on that.
230.
Possession was acquired to the tune of 0.02. Yes.
233 is
Come
called
back with your, we'll direct affidavits in this matter because here affidavits are necessary. But you are constructing.
Yes,
Stop
ma'am.
work will stay for the time being, for a limited period.
My lord, stop work has to be there, my lord.
kindly-
My lord, give them time, my lord.
No, he's right. Stop work, if you stay stop work, that will have a negative, double negative.
Grateful.
Then it will complete the construction. No interim order will direct affidavit.
Well, interim order is, my lord. Kindly see
What
the
sort of
order of
interim
the
order?
later portion of
What
the
interim order? Tell us.
To, my lord, appoint some police officers to demolish the structure.
Where?
That, my lord, kindly says in the writ court order. Then interim order.
Oh,
Formally, it is
Kindly come to page,
paragraph
24.
22.
But you had challenged only the stop work notice.
22. It starts from paragraph 22.
This portion will stop work will remain.
My lord.
Stop work.
22 onwards.
Yes.
An arguable case has been made out in the present appeal. Full stop. Next para. The learned counsel for the writ petitioner contends that the writ petitioner purchased the property in question comprised of plot number 2246 and upon obtaining sanction, started construction. Full stop. The construction is now, it is submitted, on the verge of completion. Full stop. Next para. At this juncture, a stop work notice was issued by the railway authorities, prompting the writ petitioner to challenge the same. Full stop. In the first round of litigation, the writ court relegated the matter to the railway authorities for the purpose of adjudicating on the merits of the representation of the writ petitioner. Full stop. Next para. Upon such consideration, the railway authorities took a stand that the said land had been acquired under the provisions of the Land Acquisition Act, 1894. Full stop. Next para. The writ petitioner took out another writ petition challenging the stop work notice. Full stop. In the said proceeding, the state appeared through counsel and took a defense that the land was acquired under the Defence of India Act in the year 1943. Full stop. A declaration stroke publication under section 75 capital A of the Defence of India Act was also furnished by the state authorities, which showed that the entire plot number 2246 was first requisitioned and then acquired under the said act. Full stop. Next para. The learned senior counsel appearing for the state submits that by virtue of operation of section 75 capital A within bracket 2 of the said act,
May I?
the property automatically vests in the state upon a publication of the notice under the said provision in the official gazette. Full stop. Next para. Apparently, due to such anomaly, although initially a notice and notification under section 4 was published, section 4 of the 1894 Act was published, the same was not proceeded with further. Full stop. Next para. Learned counsel for the railway authorities submits that the state had handed over the property in favor of the railway authorities. Full stop. That apart, from the concerned notification in the official gazette, which is relied on by the state, it is evident that the entire plot number 2246 was acquired. Full stop. Next para. Learned senior counsel for the state as well as learned counsel for the railway authorities rely on certain documents which go on to indicate apparently that payments of compensation were made in connection with the said acquisition. Full stop. Next para. However, comma, in reply, comma, learned counsel for the writ petitioner argues that at least two documents relied on by the writ petitioner show that the acquisition took place only with regard to 0.02 acre out of the total plot number 2246. Full stop. Next para. For such purpose, comma, learned in support of such proposition, comma, learned counsel for the writ petitioner places reliance on an annexure at page 233 of the writ petition, which is apparently an order passed by the concerned magistrate and collector, comma, Howrah, indicating that in plot number in CS plot number 2246, only 0.02 acre of land was acquired. Full stop. Next para. Learned counsel also seeks to rely on an additional document which was not in the custody of the appellant at the juncture when the writ petition was pending, comma, being an information furnished under the Right to Information Act by the office of the concerned collector, Howrah, reiterating that only land to the tune of 0.02 acres out of CS plot number 2246 of Mouza Duila, DUILYA, was acquired. Full stop. Next para. Learned counsel for the state as well as the railway authorities dispute such document and argue that even if such an information was given and or an order was passed by the concerned collector, comma, under the Defense of India Act, comma, it is the notification in the official gazette under section 75 capital A which prevails. Full stop. Next para. However, comma, a prima facie doubt is cast as to whether there was any subsequent erratum issued, ERRATUM, 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 italics, erratum issued by the concerned authority, by the state under the Defense of India Act, comma, thereby restricting the acquisition only with regard to 0.02 out of the total land in plot number 2246, comma, in view of at least two contrary documents which are sought to be brought on record as indicated above. Full stop. Hence, comma, the writ petition is required to be heard on the above issues. Full stop. Next para. We find from the impugned order of the learned single judge, comma, which affirmed the stop work order issued by the railway authorities, comma, that over and above doing so, comma, the learned single judge, comma, upon dismissing the writ petition, comma, directed the respondent number 5 authority to take immediate steps for removal of encroachment over plot number 2246, comma, if necessary, with the help of adequate police force, and directed the respondent numbers 9 and 10 authorities to provide adequate numbers of police personnel for removal of the encroachment of the aforementioned plot in the event any such requisition is made by the railway authority before them. Full stop. Further directions were issued to ensure that no breach of peace takes place and no obstruction is created by any person in executing the work of removal of encroachment and ancillary directions. Full stop. Next para. We are of the prima facie opinion that such directions, comma, while dismissing a writ petition filed by the present appellant / private party challenging a stop work notice issued by the railway authorities, were passed beyond the jurisdiction, dehors the jurisdiction of the writ court. Full stop. Accordingly, the portion of the impugned order dated September 11, 2025, whereby directions for removal of encroachment and consequential directions, comma, contained in paragraph numbers 22 to 27 of the said order are concerned, shall remain stayed till disposal of the writ petition. Full stop. Next para. However, comma, it is made clear that nothing in this order shall be constituted to operate as a stay to the stop work order issued by the railway authorities, comma, which was the subject matter of challenge in the writ petition. Full stop. Next para. The respondent shall file their respective affidavits in opposition. What would be a reasonable time for the state and you? 1 week after the vacation?
My lord.
2 weeks after the vacation? Very well. We reopen on 24th. We have the entire next week excepting 30th. So 2 weeks is 7th November. 7th November is sufficient. You get 2 weeks. Within November 7, 2025, full stop, reply if any shall be filed, replies if any shall be filed within how much time? 2 weeks. Within November 21, 2025, full stop, the writ petition shall be, the appeal also has to be. Achha, very well. This was can 1, can 2.
Additional document can.
Can 1, my lord, stay.
And can 1 is a stay.
Stay, yes.
Achha, can 1 of 2025 is disposed of in the light of the above observations without any orders to cost. Full stop. Can 2 of 2025 shall be heard along with the appeal.
Right.
Full stop. Affidavits in opposition in respect of the affidavits in opposition and replies in respect of the same shall also be filed in consonance with the directions vis-a-vis the timeline given in respect of the main. There's no scope of affidavit ডিরেকশনটা তাহলে তো যেটা affidavit ডিরেকশনটা দিলাম না, যেখানে যেখানে affidavit ডিরেকশন দিয়েছি ওটা টু ক্যান টু করে দাও, টু ক্যান টু. So next para, in view of no affidavits having been invited in respect of can 1 of 2025, it is deemed that none of the allegations made therein is admitted by any of the respondents. Full stop. Next para, the appellant shall prepare and file the requisite number of paper books containing all relevant documents, comma, including the entire documents which were produced, which were furnished before the writ court, comma, along with copies of the application for production of additional evidence bearing can 2 of 2025 and the affidavits in opposition and reply filed in connection therewith. Full stop. Next para, such paper books shall be filed within November 21, 2025, more than 6 weeks after open. Full stop. The appeal shall be listed for hearing in the monthly list of December 2025.
My lord, one indulgence, my
Yes.
lord. My lord, a direction upon the land acquisition department should be specifically given, my lord, because this dispute has to be resolved by them only, my lord.
They are a party here.
My lord, they are not party, but state will be filing an affidavit, my lord. Otherwise, this confusion will keep on going on, my lord. So the specific direction has to be given upon them, my lord.
No, you're right. We'll pass an observation in our order.
No,
That
no,
this
party nahi.
state's affidavit shall contain, because they're the state, all comprehensive, the
My lord.
state's affidavit shall contain relevant information and documents furnished by the land acquisition department.
Affidavit, my lord, from the land acquisition, my lord.
Land acquisition also not a party.
Not a party, not a, we cannot implead for the first
Lord,
time.
then kindly direct them to make them party, my lord,
Achha,
because
no,
this
no, no.
entire dispute stands on them, my lord.
State is representing them.
My lord, then kindly direct them, my lord, because
We
railway.
cannot direct a department to be implemented.
My lord,
State
today,
itself is a
my
party.
lord, kindly appreciate. Today, railway is not in a position to confirm anything.
It is made clear that in the affidavits filed by the state, comma, the state shall disclose all relevant documents available from the concerned land acquisition department which has any bearing upon the present litigation.
Grateful, my lord.
Only one prayer, my lord. That is another matter. That is adjacent plot. Your lordship is hearing. It is part-head matter.
It is appearing in our release.
Yes, part-head.
When has that been?
Raja Basu.
No, my lord,
Raja-
that matter actually, my lord, that matter,
Similar issue, my lord.
it is not to be
Similar
taken on
issue.
record. It will be remanded because that document was not taken on record, my lord, at the time of passing of the order.
But it
of
is
the request.
part-head. It is hanging, your lord.
Here, my lord, it was taken on record.
My lord,
When that comes up.
kind of part-head, my lord, then by part-head. Part-head.
No, definitely not. আসবার ছিল নাকি? সকালে হয়ে গেছে না? পার কাজ। এইটা
রিমান্ড ব্যাক করবে বলছি।
ওইটা
বইটা নিয়ে নিন।
জজ স্যার বলছিল।
Please take back your photocopies because those may be necessary in other courts also.
Your lordship may take that matter with this, my lord. Raja Basu. That is adjacent.
That has
plot.
been
Because I will show, my lord.
when has that been directed to
I
appear?
will show, my lord, all the.
When has that been directed to appear? It will appear
It is
at due
appearing,
course.
yes,
It
yes.
is appearing in the list, my lord.
Arey, item number টা বলো।
আচ্ছা, very well. We'll direct this to appear along with it.
This is the number.
এখানে বলেছি
ma'am.
shall next be listed for hearing in the monthly list of December such and such, along with what is the number?
MAT 1335 of 2025.
ঠিক আছে তো? MAT 1335 of 2020
25.
25.
My lord,
With you,
He is appearing, I remember.
my lord,
The both of them.
that matter may be disposed of, my lord. That matter can be disposed of, my lord.
Earlier?
My lord, because, my lord, this document,
Let it appear along with this matter in the.
it will be delayed, my lord.
Delayed. What is the item number today?
30, my lord, I think.
30 will never be reached before the vacation.
And that
In
is
any
also
event-
part heard.
No, but we are directing December. It could be taken in November then.
My lord, and my lord, that can be disposed of. my
No,
lord.
he's right. If he says that, along with ota kete daw. When it comes up, if you feel that it's necessary to be tagged along with the other file, we will do.
All the lands were acquired in the.
No, if you
46
find from his submission that it is required to be relegated back, then we will not do that. Otherwise, at that point of time, when we take up, we
My
can
lord, this
also
is the submission of the petitioner that this document has not been taken
You're
care of.
considering
with
to
the
that.
petition, my lord.
Should we put it as to be mentioned and record that in
My
some-
lord, your lordship can do anything, my lord.
No, we cannot do anything, first of all. Secondly, should we do that here? Are you also asking for a remand? Take
No,
instructions
no,
on
no,
that.
that is not.
তাহলে along with the কেটে দাও, হ্যাঁ?
Along
শুধু
with
এটা।
this.
ওটা থাকবে লিস্টে।
Extremely grateful.
Pass over, madam.
Pass over item number 7.
Yes.
My apology, Milord.
Accepted, Mr. Boss.
Yes.
Anything
Milord, I have
else?
no.
Any other point in the matter?
No, Milord, I have affirmed the
Your
affidavit.
apology is very tender.
Milord, I have affirmed the affidavit, not on Friday, but on Saturday.
I have received a soft copy of the affidavit on Saturday, and today in
It was the matter when we were sought to be misled by Mr. Basu's client.
Yes, yes.
Yes. We are certain that today another omission will be detected. What is this? So,
Culturally, I was going through this when a soft copy was served. I have came across certain infirmities therein. I will not again call proprietor against the perjury.
Point out the information. Yes. What was the matter about your forgotten?
Milord, matter is, Milord, that initially when the affidavit was filed, Milord, in response to his application for enhancement of alimonies, in consonance with Milord Rajneesh versus Neha, Milord, I omitted to place, Milord, certain bank accounts, Milord, which were required to be placed as per the order of the Supreme Court. Now, Milord, thereafter I filed a supplementary affidavit. Milord, then Mr. Chatterjee pointed out that this is not in consonance with the direction. As such, Milord, the CAN 6 was filed that this is this amounts to perjury. Mr. Chatterjee has raised 3 pertinent points, Milord, according to him, and this was placed before your lordship, Milord, on the last occasion. First, the gentleman, the respondent before your husband, Milord, has paid a sum of rupees 3,50,000, Milord, from his account in a particular month, when it also shows that his bank account maintains a bank balance of rupees 20,000, which is absurd, right? Number one. Number two, Milord, so far as I have understood, Milord, the premise of Rajneesh versus Neha, Milord, the date, the preceding date, that is, Milord, prior to the marriage, what was my income? I said it is not applicable. I was not assessed to tax. It is not taxable income, which is correct.
Date of separation.
Then, Milord, on the date of separation, what is my income? I said that this is not taxable. So I said not applicable. Because it was not assessed. But the day when the application for maintenance was filed in 2016, Milord, I filed, Milord, the return, Milord, pertaining to the year 2017, 2018, as well as, Milord, 2018, 2019, which, Milord, said that, according to Mr. Chatterjee, a huge amount of TDS, tax deduction at source, Milord, it reflects. Even then, I said that my income is not up to the mark. Milord, Mr. Chatterjee possibly, and court was not, Milord, appraised of, since, Milord, I omitted to annex, Milord, the bank accounts, which are the requirements as per the Rajneesh Neha. My bank account clearly suggests, Milord, that the TDS, Milord, amounting to rupees 1 lakh, Milord, this was initially, that was correct, but thereafter, Milord, 68,000 was deducted, something amount, and 60.
What about the first point, that 3,50,000 was
Yes,
paid? You
Milord,
said by loan
yes.
or something
No,
like
Milord, yes. First answer is to that. That is why I have explained my affidavit. Milord, I paid this amount from the Axis Bank. Axis Bank.
Your account?
Yes, my account, which I do not normally use.
3,50,000 was paid to whom? Her?
Her. 3,50,000 I
For
paid.
direction of court?
Yes. Because according to me, Milord, this amount was due and payable to him, to her, Milord.
Not according to you, according to court.
Now, my lord.
Yeah.
Now, my lord, Axis Bank account was, I did not operate this account. It was a infrequent, my lord, infrequently I use this account. The account.
There in the infrequent account also you had more than 350,000.
No, I, my lord, transferred this amount from HDFC Bank account 350,000 to Axis Bank, from which, my lord, I have paid this 350,000.
HDFC was a regularly run account.
Yes.
Why did you do that rerouting?
Because, my lord, I sought to maintain, my lord, because this particular account, my lord, Axis Bank account, I meant it for, my lord, my wife's maintenance. And it was not, my lord, for other transaction or business, my lord, which I often do, my lord, from other purposes.
That you can appreciate because you may have a particular account dedicated to a particular
purpose. And, my lord, I parked my money from HDFC to Axis Bank.
Yeah.
And, my lord, thereafter I transferred this account, which would be evident, my lord, from the Axis Bank and HDFC. If one correlates, then one will find, my lord, this is substantiated. Second point, the TDS part. No, second point is omission. So far as a bank account is concerned, my lord, I said there are two bank accounts which I, my lord, did not mention in the affidavit, which, my lord, Mr. Chatterjee has pointed out. One is, my lord,
TDS, huge TDS, but
yes,
insufficient.
yes, TDS, my lord. Total TDS, according to Mr. Chatterjee, is one, that is not Mr. Chatterjee, that is from the record, 1,967.
1,967.
That is, my lord, the total, and, my lord, the amount refunded 37,380. That is, my lord, after
37,380.
self-assessment tax 7A, 7B, 1 lakh, and then, my lord, refund is 37. TD initially it was 1,967. That is the TDS tax deducted at the source.
Yes.
Then, my lord, it was refunded 37,380. Meaning thereby, my lord, 63,000 something, my lord, that is the, my lord, the tax paid by my client. So, my lord, if 63,000 is the tax paid to TDS, then my income, my lord, commensurate with the slab, my lord, fixed by the income tax authority.
What would be the slab? I don't have any idea. We don't have.
No, my lord, because
63,000 is
the
the
60,000,
TDS.
my lord, according to me, subject to the 10%, 6 lakh.
No, what is according to your income?
According to me, I said, my lord, 1,37,000
per month.
Per month. And
supplementary effect 1,41,000 something. Subsequently, correct.
Will at the subsequent affidavit, will kindly write instead of 1,37,000, 1,41,000. 1,41,000.
After it was caught, it has now jumped.
There
to
is not of catching, my lord.
So I deny that income as well.
A few thousands. 41,000 and 37,000.
Because it's a manufactured
4,000,
document.
nobody would.
He said manufactured, he has to prove
this obviously, this balance sheet that has
just because he is in a litigation, you cannot say whatever you like against him.
No, not against him, against the client.
No, not him.
We
are speaking about against him. You can say whatever you like.
Why?
Whatever you like.
No, this is not.
He's an officer of the court. You are an officer of the court. We are the court, so do whatever. Regarding his client, we are trying to protect his client. You cannot say anything against his junior or your junior. Between yourselves, you can fight out. No difficulty. We would enjoy that. But against your clients, respectively, please don't malign them. They're not here to defend themselves. Unless there is something on record.
Yes. Millard,
so this 4,000 difference.
No. And Millard, 37,380. Millard, that is the tax, Millard. If it is
63,000.
According to
63,000 is TDS, Mr.
Millard, 63 lakh.
That is your problem. You don't let people finish a sentence.
Little bit nervous, Millard.
We are also nervous when you are in court. What step next you will be taking? If 63,000 is that 63,000 is the TDS deducted, Mr. Vasu, what would be the income? We don't know. We don't know the correlations.
Yes. Subject to what my learned friend will say, Millard, according to me.
Do you have any idea of that? I mean, we
lakh,
don't have any
it's there. It's there in the ITR return itself.
What?
In the return, Millard, it's income assessed is
gross total 8,96,000.
Net tax payable is 63,586. My case is that in the affidavit he
Let
says,
me answer the queries, Millard, as he raised.
He is raising new queries. You'll have to answer those also. Let him finish the queries.
No, this query is my question was that in the affidavit he says it's not taxable. But in the ITR return, it's clearly, it shows that it's a taxable income. The question of not being not taxable is to only show that he's earning less.
Yes, Mr. Basu.
No,
Not
I have
In the same
categorically,
affidavit, in the above it says that it's not
Milord, I
taxable.
categorically,
Annexed
Milord,
is
let
why
me
it's
answer.
taxable.
I have rather, Milord, suppose, Milord, in my income tax return, I said, Milord, my income is 1,41,000. At that time, that is 2017-18. And presently, I am saying that is net surplus capital is
2017-18 assessment year.
assessment
That
year.
means 2016-17 financial year.
Yes.
The previous year you had income.
Yes.
And you have said you had no income.
No,
Not taxable.
I said, Milord, so far as the TDS is concerned, he said that I have, Milord, committed forgery by making a wrong statement. I said
You
that
had no income.
it is
You
no,
said no, not taxable. Your income was
NA, not, Milord, at that point of time.
What
the
is
fact
not NA?
NA, Milord, not applicable.
Which column?
That is
Income.
income.
Taxability.
Taxable income. I said NA.
You said NA in taxable or
But
not.
at the same time, Milord,
But
I
your TDS is being
submitted.
directed at the rate of 63,000.
63,000 means, Milord, that I have submitted, Milord. Everything, Milord, I have submitted in the document, Milord. I will show one after another.
No, after being
No,
caught.
no, not caught.
After his application.
No.
After the perjury application.
Kindly
you said-
see,
After it was pointed out by way of my reply to CAN 4. Everything
Yes,
was
yes.
pointed out, leave was sought
But
to
in the
file it
affidavit
separately.
of asset, it was not there.
affidavit of asset, it was not there, and I have explained, Milord, in this affidavit, kindly sees, Milord, allow me to read this. I hope, Milord, it will eradicate the clouds, Milord, which envelop
It will do what?
eradicate the cloud enveloped your lordship's mind.
How do you eradicate clouds?
Let me see, Milord. Kindly let me read, Milord, first.
What sort of cloud is this, Mr. Basu?
Suspicion, Milord. Milord, suppression is not perjury, Milord. Kindly
No,
see.
suppression is not perjury.
Yes, Milord. I'm extremely grateful. Milord, kindly turns, Milord, page 4.
Yes.
Milord, allow me to read, Milord. I further, Milord, I read for my lord's consideration 7 paragraph, page 4. I further submit that that I had been transferring the maintenance amounts towards my wife from my bank account, being number such and such in Axis Bank, Chetla branch. I otherwise do not regularly
That is
operate.
regarding the first point.
First point. Now, then I said the marriage had been solemnized in the year 2007. The parties were separated in the year 2009. The interim application for maintenance was filed.
Take us to the,
Yes, Milord.
Yes.
Yes. The above situation would portray that the husband was supposed to file the income tax return for the financial year 2006-7 and the corresponding assessment year 2007-2008, financial year 2008-2009, and the corresponding assessment year 2009-2010, and financial year 2016-17, and the corresponding assessment year 2017-18, if assessed to tax during such period. Although inadvertently the respondent has missed out on annexing the ITR of 2017-18 in his affidavit of assets and liabilities, he had voluntarily submitted the affidavit of assets and liabilities of 2017-18 and 2018-19. It would be apparent from the same that the respondent had in fact received a major chunk of TDS so deducted, and there is no mismatch between the actual income of the respondent and the income reflected in the affidavit of assets and liabilities. It would be apparent and is a matter of record that the respondent husband was not filing in income tax returns for the financial years 2006-2007, since incomes was not within the taxable limits. It is also abundantly clear that since there was no dispute at that point of time, there could not have any reason for the respondent to suppress his income in as much as he could not have conceptualized or predicted the subsequent marital discord to lead to the filing of a subsequent.
Basu, we cannot finish in 5 minutes. We have something.
Tomorrow 2 p.m. is possible, or Wednesday at any time.
Wednesday, I think it will be from 2 p.m. because that's a original side matters are there in the
side maybe 2 p.m. I will finish it, Milord. I will take my 15 minutes time. I know, Milord, your lordships are facing insurmountable pressure, Milord. Kindly allow me.
Yes, due to a certain council.
এটা কি চলছে?
And there's suppressions of material facts.
YouTube চলছে? Fabian, wait. It reminds me
of George Bernard Shaw. Shavian wit is Bernard Shaw's wit. So I remind you of George Bernard Shaw. Have you seen him?
No, not.
How can I remind you of him?
I will discuss on Wednesday.
Wednesday, very well. That is also part heard.
Lordship, because I have received it today.
But there is still lies, even after
No,
Judge Bandhan.
I received it today itself, so I shall affirm a reply in the meantime.
To this supplementary affidavit.
Yes.
Very well. A supplementary affidavit filed today by the respondent husband be kept on record. Full stop. Learned on the prayer of learned counsel for the appellant wife, petitioner wife, comma, leave is granted to the petitioner to file a rejoinder to the same by day after tomorrow upon circulation of a copy thereof to the learned advocate on record for the respondent. Full stop. Can you do it, or we will keep it after the vacation?
Lord, before the vacation.
After the vacation.
Lord, before the vacation.
Before the vacation. Very,
Wednesday.
very well.
Wednesday তুমি তাহলে বৃহস্পতিবার হয়
আরে কালকেই তো দিয়ে দিচ্ছি।
Let
কাল
the
তো মঙ্গলবার।
matter be listed next on September 24, 2025. It will appear in the list as it is. I mean, application it is appearing in it.